morning. This is on time. We are waiting for closing arguments, rebuttal witnesses. Good morning. Good morning. If anyone is there, I am on time. Shocking as it is. Good morning. Good morning. I'm on time. Somebody else is. We're waiting for the trial to start back up. I think we may have some rebuttal witnesses. Oh, I hear sound. Might have rebuttal witnesses. Maybe we will have, I think we're going to definitely have closing arguments today. And maybe a verdict. Possibly a verdict. It's not going to be a good Friday the 13th for Laurie Shaver. I think she's going to get, it's going to be a very bad day for her. Good morning. Good morning. Welcome. Welcome. It's about to get started. Happy Friday the 13th. Happy, happy, happy. Good morning. Good morning. It's going to be a good day today. Good morning. Hey, Tommy. How are you? Welcome. Hey, Gwen. How are you? Happy Friday the 13th. I'm actually on time today. Today is going to be a good day. I think we're going to have closing arguments, and I think we're going to get a verdict today. It's going to be, Laurie is not going to have a good day today. Tommy, do you know about this case? Good morning. Good morning. Welcome. Welcome. Today's going to be an exciting day. Is everybody familiar with this case? I think we're going to hear some maybe rebuttal witnesses. I don't know, but we're definitely going to get the closing arguments today. And I think Laurie is about to. Yes. Who will she blame next? That's funny. Hey, Brandy. Good morning. Good morning. I'm excited. Today's going to be, she's going to get a rude awakening. What do you think about it, Tommy? I feel terrible for Michael. I feel like he has just gotten completely lost. We don't know anything about him. It's so sad that poor Michael has just gotten totally lost in all of this. The screen? Yeah, it is a clear case, Tommy. That's for sure. I think she's a terrible person for having her daughter get up on the stand and say those things. Yeah, they're in there. I can hear them. I mean, I can hear the buzzing. Yeah, it's just wild, but we were all pretty flabbergasted yesterday at her testimony. And the timeline is all messed up. She couldn't keep her lies straight. Well, I made it on time today, Brandy, so that's great. The first, just one day out of the entire week, I made it on time, so I'll take it. Yeah, she's a pretty. She's definitely not Mother of the Year, that's for sure. Womanizing. They talk about womanizing. Man, I don't know. I don't know what we have words for what she's been doing, Tommy. She was a busy girl. Busy. I don't know. I couldn't keep up with how many people she was hooking up with. And like at the same time, I think she was busy. She is not a cougar. She ain't old enough to be a cougar. She was just there you go, Brandy. That's more like it. She was just doing that. She wasn't a cougar. She was I don't know. Her husband's a felon. I don't know what was. I don't know. I think she clearly never got enough attention. And she was looking for it from anywhere she could get it. And that's bad. I think that's terrible for her daughter too, because she's raising another little manipulator. Like we talked about yesterday, it's another Gypsy Rose situation, what she's done with that little girl of hers. Yeah. Between 11 and 12. Yeah. That's the window of time that we have to hook up. Ugh. But yet he was there and spent the night. And he was there for that second magical, invisible shot that nobody else found. Yeah, I feel that little girl, you could tell that was a definitely rehearsed story, because she had all those details in that story about her bedroom, the description of the house, all of that stuff, like down pat, but she could not put together any details of timing. No, it was only one. But the daughter, when she got up on the stand, she said she did one, and then she said Jeremy came in after her and did another one. And I was like, wait a minute, what? That's not how it happened. But the daughter had to come up with a story to include Jeremy so that she could kind of curb the blame off of her confession, whatever you want to call it, because, they're trying to change the narrative, because they were going to have the little girl take the blame. And then they were like, oh, wait, we got to make it look like Jeremy did it, because we don't want the little girl to take the fall. They don't know who they want to take the fall. The defense has changed their story, their defense strategy. Like, I know. Yeah, and then their timing is off because the daughter messed up her testimony. The timing had to change. It was because he hasn't been heard from since November of 2015, but Laurie and the daughter have had to change the timing to May of 2016, because that's when the daughter messed up and said the timing was in the spring or summer. It's ridiculous. I'm flabbergasted. I think we're all flabbergasted at what we were having to listen to yesterday. It's nuts. So they've changed the timing to May of 2016. Laurie has, but that doesn't make sense either because she had a woman living with her in April of 2016. So there's no way Michael could have been there in May 2016 and this have happened if she had a roommate. Welcome, everyone. We're waiting on the judge and everybody to get in. I'm sure there's going to be motions when he gets in there. Yeah, so they changed the narrative or trying to change the narrative. It's very confusing. I'm sure the jury's heads are like, wait a minute, when did this happen? And they only have 6 jurors. Does anyone know why in Florida? Let me look it up. Why Florida only has 6 jurors? Tommy, where are you from? Oh, Sweden. Cool. We have people from Germany, South Africa, all over the world. I love it. So you guys have pretty strict laws over in Sweden. You have no we call them for code. Oh, 12 juries. Oh, okay. Interesting. So you have that over there? That's interesting. Okay. Right, Gwen? She probably will bring out the roommate. Yeah, so in Florida you only have 6-member jury. It's crazy. So I didn't know that Sweden had that. But you don't allow Sweden doesn't allow pew-pews over there, right? Oh no. Oh, okay. But y'all don't allow people to carry bang bangs over there. Yeah. Oh. What she used to hurt her husband with. Do y'all allow those over there? Yeah, those. I can't say certain words on YouTube or I get in trouble. It's very restrictive. On this channel, we call them fishing poles. Yeah. On this channel, we call them fishing poles, Tommy, just to make it easier because I have to use code words on YouTube. But y'all have pretty strict laws over there, right?
Judge Carey Rader presiding. You may be seated. Good morning.
Okay, they're going to have motions, of course. The defense is probably...
They were present in case number 24 CF 596, State of Florida versus Daniel Trenton Purdue. Present for sentencing. Please state your name for the record, sir.
Daniel Purdue.
Raise your right hand. Do you solemnly swear or affirm that any testimony you give today
What? I don't know. He said someone was present for sentencing. Is he taking care of something? See, that's why I was wondering if they were even going to meet today, because Fridays are usually reserved for like what he's doing, sentencing. What he was just saying was sentencing. So I was kind of wondering if they were going to have trial today, but yeah, I'm sure they're... He's probably doing... I'm sure he's taking care of housekeeping stuff. So... Welcome, everyone who's waiting. We're just waiting for them to get started. Feel free to join the chat. Yeah, he always tells them to come at 8, but they always have to... They're just hanging out in the jury room. What got you interested in watching trials in the States, Tommy? Good morning. Welcome, everyone. Happy Friday the 13th. We're just waiting for this trial to get started. Oh, yeah, that was a... You know, he's already out. That's wild. The laws are so different. Do you think he actually did it on purpose? Yeah. That was so sad. It was just very sad. Yeah, that whole situation was sad. I hated that. I really liked him. I hate when you really like somebody and you think they're a really cool person or whatever, and then they're just not. She was a very pretty girl, really, really beautiful. And he just like, I don't understand. And he was out like partying and stuff after. Like it was no big deal. But now he's out. I don't know what he's doing. I guess keeping a low profile. So I was on time today. Of course I'm on time. And then this is what happens. I could have slept another hour. Yeah, I guess South Africa is not as forgiving as the United States, because here he would probably have had his career back. I mean, America is like, those kind of people can do something wrong. I mean, like Michael Vick, I think he was a quarterback. He went right back into the NFL. He was convicted of dog fighting. He was animal cruelty. It was a horrible, horrible crimes. And he went to prison, got out, went right back into the NFL. Yeah. And Martha Stewart, she was convicted of it was white collar crime or something, but she went to prison. She got out. She's on TV commercials and doing just fine. Harvey Weinstein, he went to prison. All of his charges got dropped. Bill Cosby, same thing. He went to prison. Him and Harvey Weinstein went to prison for the same things. Yeah, in America, you can do whatever you want to people. If you're a famous person and you go to prison and you come out and you just go right back to what you were doing before.
Versus Laurie Shaver. Will the parties present please identify themselves for the record?
Here we go.
State of Florida, Brief Button, the state. Jeffrey Wiggs on behalf of Laurie Shaver.
He had to have surgery.
Ma'am, please state your full legal name. Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and
Yeah,
nothing but the
Weinstein's
truth, so help
done,
you
but
God?
he.
All right, thank you. And are we conducting a proffer this morning?
Yes.
Okay, and the parties are prepared to proceed? Okay.
So a proffer
All right,
means
then,
outside
we
of
just
the
need Miss Johnson.
jury. Now they're going to talk to that little girl's attorney again. I don't know what they're going to get out of this attorney.
Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
Your Honor, as it relates to this offer, I know that a lot of my arguments are going to come about why this witness should be excluded, are going to deal with the fact that the agreement might possibly be able to talk about this hearsay for the purposes of this. I'm not going to be objecting in the middle of Mr. Wiggins' questions. I'll let him argue about the admissibility of the covered statement at the conclusion of it.
Yes, sir. All right, and please state your full legal name and spell your full legal name.
Kelly Johnson, KELLY JOHNSON.
Thank you. And please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? All right, thank you. Please proceed.
I went to college for criminal law and
Yes, sir.
forensics, Tommy.
Police report.
Yes, sir.
Ms. Johnson, could you state your name for the record, please?
I did, Kelly Johnson.
Okay. And do you remember being judicially appointed on this case involving Ms. Shaver? Okay. If I can approach Judge and show her
Yes, sir.
Defense Exhibit A for identification purposes, which is the order. You look at Defense Exhibit A for identification purposes. Is that the order you're looking at wherein Judge Singletary appointed you to this case?
Yes.
And in the respective order, what was your understanding your obligation was?
I was appointed to represent the child as an attorney ad litem.
Okay. And the child's name?
Isabel Shaver.
Okay. And having been appointed on behalf of the minor child, did you meet the minor child?
Yes, I have.
Did you go over?
I put it in the chat, Tommy.
Did you discuss with her the facts or knowledge of the case with her?
As with any client, I discussed the facts of the case, the applicable laws, and possible ramifications of taking any position.
So, did you discuss with Isabel? Did she express to you in any form or manner that she had any interest to testify in this cause?
She expressed a preference to me in a developmentally appropriate manner.
I'm sorry, speak up.
She expressed a preference to me in a developmentally appropriate manner.
Ms. Johnson, can you pull the microphone towards you a bit? It's adjustable and speak into it to the best of your ability. Thank you.
It was expressed to you, I'm not sure if I understood your answer, Ms. Johnson. Did she express to you an interest
Is this
in
today?
testifying in this cause?
As I stated, she expressed a preference to me in a developmentally appropriate manner.
Okay.
I can't discuss the
content.
anything that the child and I discuss, as it's bound by attorney-client privilege.
Right. Did you discuss when you were meeting with her if she were to
Are we
testify
watching the wrong day?
on
No,
constitutional
this is
rights,
today.
that she would be waiving by testifying?
Yes.
Did you express to her any legal penalty which she could face if she were to testify and the state took action against her?
I advised her as I would any client.
Did you detect any infirmity with regards to Isabel if she were to testify, that she would have a problem testifying truthfully?
Oh my gosh.
That's not within.
Offered into trial about consequences and acts of physical violence. So it becomes very, very significant. It's even spoken about by the daughter and the mother that there were acts of physical violence justifying the claim of
Sorry.
of belief
I just had a brain fart.
murder. And there was a
Thanks,
monthly
Tommy.
ongoing
You're right.
act
I'm
of physical violence that was spoken of by the daughter. It's in the standard jury instructions.
okay. I said I was on time. I didn't say I was wide awake.
Some confirmation.
And now I'm on the right one.
Confirmation of violence. We introduced the photographs to confirm there have been past acts of violence.
So these are the motions he's
Repetition
upset
of being a
about.
violent and dangerous person. There's been no repetition evidence, so that paragraph should be stricken.
Sure, Judge. We've heard actual
The
physical.
next two.
Yeah, we've heard testimony. We've seen exhibits offered into trial.
Oh, they're trying to
about
enter in that Michael was a violent person.
acts of physical violence.
Okay.
So it becomes
We're on the right
very,
day.
very significant.
Sorry.
It's even spoken about by the daughter
Ugh.
and the mother that there were acts of physical violence justifying.
They're trying to enter in that Michael was violent.
It was an attempted murder.
Nope, no duh.
There was a monthly ongoing act of physical violence that was spoken of by the daughter. It's in the standard.
I don't doubt that they had a volatile relationship, you guys. I don't doubt that there was some type of something.
The law requires there's got to be some confirmation, some circumstantial confirmation of violence. We introduced the photographs to confirm there had been past acts of violence. There was testimony about the injunctions.
I think they had a pretty strange relationship.
The acts of aggravated battery and domestic violence were testified to, and that those specific instructions should be included within the jury instructions and not excluded. They're standard instructions.
Yes, sir.
Evidence that he's referring to that he wants to reference as to why that this is permissible use of deadly force is covered in the previous paragraph. If you find at the time of the alleged murder in the second degree, Laurie Shaver knew that Michael Shaver had committed an act of violence, you may consider that fact in determining whether Laurie Shaver reasonably believed it was necessary for her to use or threaten to use deadly force. The two paragraphs that I am asking to be stricken specifically go to whether or not reputation evidence was presented. First, reputation of being a violent, dangerous person, and whether or not that was known. And then two, reputation of being a violent, dangerous person. You may consider that as far as whether or not he was the initial aggressor. There's been no reputation evidence. There has been acts of other violence, which is covered in the instructions already. I'm just asking for the redaction of the language that deals with evidence that had not been presented.
Judge, there's case law that's in Earhart sitting on my desk, and it talks about that the family is such a narrow community, you can never establish reputation to offer that specific conduct. So we do have evidence that there were past acts of violence. I'll leave it to the court as to whether you want to just delete the paragraph or you want to put in, again, reference to past acts of violence as demonstrated.
So he basically wants to tell the jury
You're saying leaving in the
consider
second paragraph stating,
I believe, yeah.
their
all right,
past.
so you have no objection to the reputation being removed.
No, I just think if you want to tailor that, it should have to be tailored to represent that you've heard testimony that there were past acts of a physical nature of violence. Such acts may be
To
considered
justify
by the
why she
who was
did
the
what she
initial
did.
aggressor. I think it could be tailored that way because, as I stated, Earhart declares that you can't establish reputation within a home environment.
But he's conceding that there's no reputation evidence, so these two reputation paragraphs should be taken out.
No, I'm
And what-
saying they should be tailored.
And once again, the paragraph that precedes the ones we are talking about, the two paragraphs that we precede that we're talking about, if you find that Laurie Shaver, because of threats or prior,
I know, but
Michael Shaver had reasonable grounds to believe that
she's
was
saying
in
she
danger.
didn't do anything,
Two,
but
if you
he's
find at the
saying
time of the alleged murder of the
if they
second-degree
find
murder,
her
knew that Michael
on
Shaver
the lesser
committed
charge,
act of violence, both of those cover what
he wants the jury to consider
there's
the abuse.
The next two deal with the specific.
I can't say that word
presentation
either,
of
but
evidence that hasn't been presented.
the
and that's why it's
physicality.
under that.
All right, state's request is granted. The two paragraphs relating to reputation evidence will be removed.
And Your Honor, the last thing I just want to address on the record before we move on, the way the standard instruction is drafted and presented basically is very much focused on a self-defense claim as opposed to defense of others. And the state realizes that this is what they really are going for is whether or not Isabel Shaver was aware of these things and acting in defense of others. So I believe that those areas
They need to be included.
where I would say in that if you find that Laurie Shaver, who because of threats or prior difficulties, I think that we can put for Isabel Shaver in acting in defense of others, And,
I made notes
hold on
on that.
1 second.
Any objection?
No, I made notes on that as well, and I didn't know what the specific instruction was. I thought the state knew that Isabel was going to say this, and I thought actually they put it in their primary instructions.
So please modify the instruction accordingly.
Yeah, just put in the defense.
I was kind of waiting to hear how the defense would want to handle that, sir, but that's why I brought it up.
Yes, sir. So there's no objection.
And we will work on that. We will make sure we print out prior to any final instructions. Just, we'll
The
address that
child
and
is
make
not
sure
on trial.
Changes that need to be made later today.
Yes, sir. All right. 3.7. Any objections?
Judge, one moment, please.
Yes, sir.
I want to hear these jury
Since we're
instructions.
dealing with the substantive crimes and instructions up to this point, let's say, we had requested instructions on consequentity.
You want to go back to the accessory after the fact? But
All right. I have that. Consanguinity as a defense. I've read over it and the state's position.
he's referring to a statute that has been modified and changed. The statute, the cases that he cites refer to a statute that was modified in 2006. The statute that's currently written, I have copies for. Your Honor, may I approach?
Yes, sir.
That is 777.03.
Thank you.
Paragraph B, any person who maintains or assists the principal before the fact or gives the offender any other aid knowing that the offender had committed the offense of child abuse, neglect of a child, aggravated child abuse, aggravated manslaughter. Apologize. Paragraph C, any person who maintains or assists the principal. Any person who maintains or assists the principal or an accessory before the fact or gives the offender any other aid knowing that the offense had been committed a crime, and such crime was a capital life, first degree or second degree felony, or had been accessory thereto before the fact with the intent that the offender avoids or escapes detection, arrest, trial, or punishment is an accessory after the fact. The discussion of people being in relation, which is what Mr. Wiggs is referring to, is in paragraph A, which deals with someone that is a accessory before the fact. So the language that he is requesting is not appropriate, and that's why the standard instruction does not include any of that.
Any person not standing in the relation of husband or wife, parent or child, grandparent, brother or sister by consanguinity, who maintains and assists before the fact, okay, or gives the offender any aid, knowing that the offender had, which is after the fact, committed a crime, and such crime was third degree. Now that's third degree,
Right.
okay, or had been an accessory there too before the fact with the intent, okay, and the offender who maintains, I wish I could read this.
Your Honor, you can't be an accessory after the fact if you are a relative to a third degree felony.
No, that's fair. Let me read.
All right,
it,
please
please.
take turns. Mr. Cavuccio, anything further? Okay.
No, I think it's still applicable based on the law that I cited to the court. And I don't see where this case has been overturned, Judge, which was Brown v. State. And it states that Marshall had been charged with a second degree murder, and Brown was charged with being an accessory after the fact. He first asserts the one guy that there was a relationship of consanguinity as a defense, and that was his defense. The court said, well, you're too remote in the relationship to assert that to a second degree murder.
I know this
don't
seems
see
boring,
where
but this is
clearly what
important.
Mr. Cavuccio at the last minute, having produced these weeks and weeks ago, is providing that says that this has otherwise been revoked or overruled.
What you're
This case. provided something with mice type to try to read off of. I've read the statute update. I don't see, this is a 2006 version. I've read the latest version of the statute, and I don't see where it changed, as Mr. Calucci was suggesting here.
Your Honor, may I approach?
Yes, sir.
Here's the copy of the statute that was in effect before 2006, which is that Mr. Wiggs cites was the statute at the time. So in 2006, when the Florida legislature changed the statute, the standard jury instructions were changed to conform.
Morning, everybody. Welcome to the
statute,
chat.
And that's how the cases.
We're waiting for them to get through these jury instructions.
From 2001, Brown was from 1996, have been abrogated.
I don't believe so, Judge. I'm looking at the current statute, and I don't think that's the position. I think it's still in effect. It's a still viable defense, and we request the instruction.
All right, the request is denied.
He said it's denied.
3.7 plea of not guilty. Acceptable?
This is just a standard, Judge?
Yes, sir. Okay. 3.9, weighing the evidence. We have to decide yet as to what or if all or any of 6, 7,
Tommy.
8, 9, and 10 will be given.
Look, Brandy made it. You got to look up if you don't know who Dr. Phil is.
3.9.
He sounds like Dr. Phil.
Goes from 3.7.
Brandy pointed that out. Now I can't unhear it.
Self-defense. Okay. Well, 3.9. These are the standard.
Yes, sir, except for 6 through 10. Do the parties want 6?
We had testimony from Adam Narvaez about the reputation for truthfulness as to Laurie, Isabel, and Travis. We request that it be included.
We can't believe he's an attorney because he is so bad.
Your Honor, I don't think we have any evidence of 6.
Correct.
I don't think we have any evidence of 7. We do have.
Judge, I'd ask that 6 remain in, and I'll tell you why. We did.
Mine's an Alabama accent. I live in Texas. I have an Alabama accent. Close, Tommy.
He's represented by counsel. He has an arguable and viable interest in the case. There may be an inference that he has negotiated some kind of obligation or with the state. He's under compelled testimony of the subpoena, so I ask that remain in.
So it reads, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify?
I think that he has.
Oh, Wiggy's.
So there is an
He talks
interest,
really slow.
so there could be a preferred treatment.
He could be
That
Georgia,
should remain in.
The state's response?
but they are in Florida.
But there has been absolutely no evidence of any sort of deal. And his arguments that this can be inferred when he knows that I have a Brady obligation to turn over some sort of deal on that, I think would be an improper argument and completely improper.
Wiggy's,
I'll
he
tell you
could be
what,
from
I
Georgia.
worked with the state. I worked with Brad King. I worked with Rick Ridgway, and those gentlemen would infer a preferred treatment with the counsel and not put it in writing, and it would be silently implied. So to just say, I don't have anything in writing, there still can be an innuendo that somebody's receiving fair treatment. And to just say, I would do it and I would turn it over, I'm sure if you had it in writing.
I'm quite frankly offended by the attacks on the character of former state attorney Brad King and former Chief Assistant State Attorney Rick Ridgway at this point. But what really matters is the fact that I do have a Brady obligation. I would have to turn that over. There is no agreement. There is no preferred treatment. And to just make stuff up and infer it to the jury is improper argument.
And I agree, and I work with those same individuals, Mr. Wiggs.
I've worked
Yes.
life
Wow.
cases, and that's why they dealt with me.
And the state has a Brady obligation.
Yeah.
And so if there was any type of agreement, you would have knowledge of that. So 6 will be stricken. Okay, number 7.
I don't think there's been any evidence of any pressure or threat against a witness that affected the truth of the witness's testimony.
Well, how are you going to find that out? How do you know? I mean, the jury, that's a factual determination for a jury.
Well, what evidence has there been, Mr. Wiggs?
I think they can imply something. I think they may infer from their common sense what they heard that there may be.
The suitcase case
I've
or
heard no testimony as a state.
That's all.
A 7 will be stricken. Number 8, did the witness at some other time make a statement that is inconsistent with the testimony he gave in court?
Yes.
Yes. There's evidence.
Yes.
Okay, so 8 will remain. 9, has the witness been convicted of a felony misdemeanor involving dishonesty, false statement? Yes. So Mr. Filmer
Staircase,
testified
yes.
to 3 felony convictions. 10, does the witness have a general reputation for dishonesty or truthfulness?
Yes.
Yes, that remains.
You're all right.
What do you think about that case, Tommy? I think
Actually, what was asked
I don't know what
Mr.
you think about
Gomez
that one.
was, do you know of their reputation? He said yes. He actually never gave a response as to what it was.
Yeah,
The defense
that's a wild
wants
case.
Once that one in there, that's fine.
What do you
All right,
think?
10
What do
will
y'all think
remain.
about
So
that one?
8,
Do y'all
9, and
think
10 will
he did
remain.
it?
6 and 7 are stricken.
Or do you think it's just a terrible, terrible accident?
Okay, the defendant has testified, so the last 3
I know.
paragraphs are applicable.
It could go either way, right?
Yes, sir.
3.9A will be removed, defendant not testifying. 3.9B will remain, defendant statements.
I know. And I'm a
3.10
huge
rules for
Dr. Henry Lee
deliberation
fan,
appear to
so
be standard. Is there anything further on that?
I'm inclined to believe Dr. Henry Lee. So
Okay. 3-9.
I also, you know,
Go ahead. 3-9B.
used to think highly
Yes,
of
sir.
Dr. Bodden.
3.9B will remain.
I have his
Any
name right.
modifications?
Dang it.
In the state's packet. After
Everybody,
the
welcome to the
390
chat. If you're in here, you can join the chat.
Section.
Don't forget to like, subscribe, share. It's very important for the algorithm.
I've tried to have broken up the 2 sets of instructions
Yeah, spot stains. I mean, it's
before
It's,
and after closing arguments.
Yes, sir, and I will
With
read
blood
the
spatter
initial
evidence,
instructions prior to closing
it's-
argument
it's
and
definitely
the remainder after. So I have the closing argument instruction, both that's standard.
blood spatter.
Okay, 3.10
it could
rules
have
for
been-
deliberation.
She's probably running late.
These are just standard, Judge, all the way through, correct?
Yes.
All right.
I think the scene was
3.11
contaminated because of the
cautionary
guy that
instruction.
did it in the first place. So I don't know if we'll ever know the real answer.
Yeah, that's standard.
But the original investigator was not
3.12
qualified.
verdict.
Correct, that's standard.
Okay. 3.12A,
Yeah.
single defendant, multiple counts or information.
Because he kept doing
Okay.
the scene over and over until he got, it was basically like the definition of insanity. He kept doing the scene over and over again, expecting a different result, and he just kept doing it until he got what he wanted. I mean, anyone can
Yes, sir.
manipulate.
3.13, submitting case
Yeah.
to jury.
That's fine, Judge.
And we have the verdict forms. Does everyone have a copy of the proposed verdict form?
One other proposed instruction I did.
But his
Yes, sir.
story didn't add up either. You clearly couldn't hear anything at the pool.
I had submitted a proposed proposed instruction on that.
So I don't
There's
know.
no duty to report a crime just because you had observed a crime. And I attach the authority on that. I think the law is clearly still the same on that issue today.
Yeah,
Right,
it was
response?
everywhere.
Yes, Your Honor. Let me get
But there was some questionable actions done after, like they let his son wash his hands. I mean, I don't know. There was a lot of it was messy scenes.
As far as the law that relates to special jury instructions, the defendant must prove, 1, that the special instruction was supported by the evidence, 2, the standard instructions did not adequately cover the theory of defense, 3, the special instruction was a correct statement of the law. That is Wheeler.
And there wasn't a fire pit or anything out there. They were just sitting by the pool.
The court does have wide discretion in deciding whether
Michael
or not
Peterson. Yeah,
to
another
give
Peterson,
a
Brandy.
special instruction. We'll
Another
say,
Peterson.
That we have found no
What's
case
up with the
dealing with any
Petersons?
sort of special instruction to say that it's not a crime. No one is saying that she is guilty solely by failing to report the crime, so there's no need to instruct the jury as such.
Yeah.
It also creates
Wow.
confusion because we are obviously going to argue that the fact that she doesn't report anything, when this is a self-defense claim, is a reason to question the veracity and credibility of that statement, and also that
it tore that family apart.
That
It was
dealing with consciousness of guilt for the murder itself. So, and there's also the fact that she not only does not report the crime, but lies to law enforcement about the fact that she witnessed this crime, which is part of the accessory after the fact charge. So giving this instruction would be misleading and confusing, and based on the fact that they need to establish that it is necessary and that it is.
The son was not.
That it should be stricken.
Judge,
He's questionable.
She's not charged here with lying to law enforcement. That's not the charge. She's not charged with bank fraud. She's not charged with anything other than the charge of murder and accessory. The law still directs that if there's any reasonable evidence to support the proposition.
If I remember, I think the son got there pretty fast.
The proposed instruction. To do otherwise is an abuse of the discretion of the court. There is, again, the state is thinking that they're going to that the jury's supposed to render a verdict because somebody went on Michael Shaver's account or she made a misstatement to law enforcement. That's not the law. That's not found with any of the instructions that we just went through. So any evidence that she thought that
very
the body
convenient, right, Tommy? Like the son was there,
which we've heard,
like literally right after it happened. It's kind of weird.
There was evidence that she believed that the body was taken off the site by Mr. Townsend. Somebody called and said there was a trespasser, and the body later shows up there. The defense is entitled to the instruction that the defendant had no duty to report the crime. Specifically, there must be a factual determination by the jury that the defendant committed the crime. So we're entitled to that instruction, and the state's vague statement to the otherwise is not supported.
All right, I'll grant the request. Where would the parties like to have it? When would the parties like to have it read?
I should probably go after the.
It split the entire family. It was terrible.
All right, is that acceptable, Mr. Wiggs?
Yes, sir.
But I think
Right,
I think
will
that
read it
happens.
after the
It happens a lot
self-defense instruction.
in those situations.
State, please include that. And I think we have the verdict forms remaining. We have count 1 and count 2. Count 1, is it acceptable as drafted? Yes, sir.
Oh my goodness gracious, Mr. Hawigi. Mr. Hawigi. Who doesn't use a computer? What the heck? And now, I don't know if you've seen Tommy, but Scott, wait, Scott Peterson might get a new trial, or well, he's getting some evidence rechecked. Yes, there are a lot of adoptive children in the U.S. People here do a lot of foreign adoptions too, though.
Okay. And so verdict form count 1 is acceptable to the defense. Verdict form count 2 as presented.
Judge, I'm going back. Let's go
I'm
back.
adopted.
Yes, sir.
As to the verdict form. Was
Yeah,
the defendant
I'm
in
adopted.
actual possession of a firearm? I think you need to
Brandy's
put the language
got
in
her
there.
husband's adopted, her
She
aunt's
used to be
adopted. Yeah,
commission of this
so
crime.
everybody's adopted.
She's not guilty of just having a firearm in the house.
Well, no, that's not.
And
So it says if you checked A, please answer the following questions. So clearly, if the jurors determine that Ms. Shaver is not guilty of second-degree murder, they do not proceed to 1, 2, and 3.
okay.
So as phrased, it is appropriate and properly worded.
Okay. You're good.
All right. Then we're on to count 2.
Count 2. Let's go. So I guess the prosecution's not going to have any rebuttal witnesses, or you don't want me to adopt you. I gotta save all my monies for my Keanu stuff. And you'll starve. You know I don't eat.
Oh, nice.
Yeah, that's true. They do. Hey, Trial Junkies. Good morning. Hey, I was on time today. I was watching the wrong day, but I was on time. I didn't say I was awake. I just said I was here. I don't know what it's like over in Sweden, Tommy, but here people are not.
That's fine, Judge. Count 2.
All right. And I believe that concludes
Getting
the
married
jury
as much as they were.
Excuse me, jury instructions. Is there anything further?
Yes, sir. As it relates to accessory after the fact, and the way the standard instruction and is tailored discusses the fact that the level of the accessory after the fact is tied into the underlying offense that they were being an accessory to. That's
We
why
have a
we
new
do the accessory after the fact.
person here today. Trial Junkies. We got Tommy from
Suppose I
Sweden.
actually need to change that to accessory after the fact to
Joined
manslaughter,
us.
firearm, and then accessory after the fact to manslaughter on the verdict.
Sweden.
That also
Sweden.
does mean I have to include accessory after the fact instructions that refer to the manslaughter instruction. We will add that as lesser
I do
included
too,
to
Brandy.
the accessory
Because
after
see, you
the
can't.
fact of
You
second-degree
would
murder,
starve.
and we'll submit those with our final instructions.
All right. And the
Yeah, my boyfriend and I have been
numbering or
together
lettering on the
17 years,
verdict form
Tommy. We're
as to count
finally
2,
getting married.
there's a D in there. It should be a C.
Yes, sir.
Okay.
You're just going over jury instructions. Trial
All right.
Junkies.
Anything further?
Nothing, Judge.
Before
They've
we
been
call the
going back
jury in,
and
let's
forth.
take a 5-minute comfort break.
Comfort break.
Thank you.
Comfort break. They've been going over jury instructions. So they've been trying to decide how they want to word it to the jury. The defense attorney, of course, Mr. Hawige, has been a pain in the rear with the jury instructions. Yeah. So Tommy, America used to be like 50% divorce rate, but now I think people aren't getting married like they used to here. So I think all over the world, people are not having kids like they used to and not getting married like they used to. So It's a little different. I think most people are just crazy cat people. I know a lot of people like that. It's kind of weird. Are you a cat or a dog person, Tommy? This will determine a lot your answer to this question. Cats or dogs? And go. No pets. Okay. Neutral. All right. I can take that. So you're not a crazy cat lady. Okay. What are the oh, see, yay! Finally, I got somebody on my side. Yeah, I have crazy cat married people in here. Yeah. That's great. I love it. We all have our vices. What can we say? So the poor jury's been hey China, how are you? Good morning, good morning. We have a newbie here, Tommy. He's from Sweden. Unfortunately, the only thing I know about Sweden is Eurovision, the movie with Will Ferrell. That's terrible. Yeah, Gwen's got every kind of animal. But you don't have 400 birds like yeah, Laurie had 400 birds. Who has 400 birds? What kind of birds are they? I mean, when I was a kid, I had finches. We lived in Germany. I had finches. Those things procreated like rabbits. They were insane. China, you have 3 cats? I know, man. I keep looking at my dogs like, when are you going to pay rent? But they don't do anything. She sold them to restaurants equal. That's insane. That's crazy. I mean, I've had cats before. I mean, I've rescued cat. I worked at a shelter, so I've had cats before. Yeah, I've rescued cats before. I've tried with cats. They stayed away from me. Because, they're trying to kill me. I know. Well, apparently I'm a bad dog mom because my dogs were out of food and water this morning. And I'm a stay-at-home dog mom, which is terrible. Cats are low maintenance. My dogs are clearly high maintenance. Neo has been a pain in my rear all week long. Like literally this dog has just been like such a pain. I'm serious. Like, what the heck? My dogs do nothing except be a pain in my booty. That's what Neo has literally been a pain in the booty all week. I don't know what wild hair he's got up his butt this week, but he's just been just a different dog, like crying for attention or something. I don't know. But that's how it's been all week. Welcome everybody to the chat. We are waiting. We're on a comfort break because apparently the judge needed a comfort break. Yeah, China, it's either called that, kneading bread, making biscuits, or trying to kill me. I don't know. I'm telling you, that's what the cat, when I was a toddler, that's what it was trying to do to me. Okay? That's how I recall it.
Okay, are we ready for the jury?
I just want to ask you.
I went
Yes, sir.
down when I was a toddler. The cat has another side of the story.
How much,
My
whose
side
witnesses
is
were
it
made?
trying to kill me.
It looks like there's a couple witnesses that have been engaging in social media.
Oh
as
my
well as-
gracious day.
Right?
Okay, if I can approach with this.
Yeah, I believe in aliens. We've already been through this.
And what are their names?
Well, Mr. Philbrook said his wife doesn't go by.
Do you want the sidebar to go on? Okay.
Look, I was
All right.
a toddler, okay? That's my side of the story.
There's, Miss Philbrook,
Rebecca Urbanowski is the witness.
Right. she goes on social media by film. Okay?
Okay, this is annoying. How can she screenshot stuff on social media if she's not on social media?
Miss McManus, she's on the internet as well.
Her first name?
Rena McManus.
Yeah, my mother-in-law has a Maine Coon.
Both present, you can inquire on that.
Those things are ginormous.
And then make our determination.
Here's the timeline, so
All right.
that was after the pre-trial. And here is, Miss, McManus.
That cat's like the size of my Neo. What the heck? It makes no sense.
Would you like to bring it into the police?
Yes, sir. Let's do that.
Need Rena first, please.
Oh man, that is lucky, China. The shedding. That would drive me nuts, the shedding. Yeah, my mother-in-law's Maine Coon, like, he stayed kind of small,
Please
and
come
then
up
all
to
of a
the witness
sudden he
stand.
just blew up.
Good morning. All right, please be seated and let me know when you're ready to proceed. Okay, please state and spell your full legal name.
Rena McManus.
Okay.
Rena is R-H-I-N-A, McManus, M-C-M-A-N-U-S.
Who is this
Thank
woman?
you. Please raise your right hand. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. And have you yesterday or during this week viewed any broadcasts of the trial?
No.
Okay.
Only, like during the weekend when they were picking the jurors on the news, but nothing.
So only over the weekend, okay? But no picking or selecting of jurors occurred over the weekend. That began on Monday morning, okay? But so you did view some broadcasts regarding the case prior to trial,
Just listening to that they were going to pick and this was going to happen, but that's it.
okay? And did you go on social media and post anything concerning the case?
No, sir.
Okay. Did you view anything about the case on social media?
No, sir.
All right. Does the
Good
state wish to
clarification there, China.
Mr. McManus, anything that you have seen at this point, would that be news reports about the case?
Not news reports, just like, I'm sorry. just stating news over like Channel 9, stating that like there was a trial going to begin, and that's it.
There has been live stream of testimony from this case on Court TV and maybe other sources. Have you watched the testimony of any of the witnesses that have testified this week?
No, sir.
Mr. Wiggs?
The rule of sequestration was invoked at the pretrial, and the evidence we submitted to the court shows that she has been engaged looking at and discussing the matter with other people on the internet. We believe that is a violation of the rule of sequestration.
Do you have that document? Show that document to the witness, if you would, Mr. Wiggs. It's up here. You may approach.
Yes, sir.
This shows communication on a date specific at the top of this and communications transpiring, correct? And your name is on that document,
Down here, sir?
correct?
Yes.
Okay, and there's discussions about the case on a particular date referenced from this communique, correct? So while this court case was open, the rule had been invoked.
Look at her.
There was to be no
Hey.
discussions by any witnesses and no review of social media. When did you look at this?
I did not, sir, but
Okay.
my-
Let me ask, why does it
Yes.
have your name on
because my daughter and my husband, they all use my phone.
it? Okay,
But I did not, because I got an email from somebody from the state attorney saying not to look at that. And that was, I think, on Tuesday or Wednesday,
Okay.
something like that.
And you have abided by that request, correct?
Yes, sir.
Okay. All right.
I think that's sufficient, Judge. The state wants us to assume just because there's an internet browser in this household. Nobody else had access it, and nobody else could internet it or enter that same site.
But that's your
the
argument.
evidence They want to inform the jury about. I'm not satisfied. I'd ask that Ms. McManus be excluded.
All right. Anything further from the state?
Can we excuse, is there going to be any more inquiry of Ms. McManus? Should we excuse?
State have any inquiry?
Let me ask.
I have no more. I do have cases in the rule. I'm just, if Ms. McManus can go back outside.
Mr. Wiggs asked for a minute to
moment.
documents. He may have some additional questions.
Okay, doesn't Mr. Noigi have, like, this is his very argument that anyone can access Michael's stuff, right? Anyone can access Michael's stuff. So she's saying she didn't access it from her phone, her kid or her husband did it. So he says he's not satisfied with that answer. And he wants to exclude her testimony. But he's literally using the very same argument to exclude Laurie as a possible suspect or whatever, defendant. That, by that logic, and how come she's able to look up stuff on social media? I'm confused. How come she's able to look up stuff on social media, but nobody else is? Isn't she supposed to be sequestered as well?
11:55 this week, correct?
11:55. I don't know. I do have my phone and I can.
Okay. My client has her phone record showing.
Why is she having her phone?
You know, but we know it's during this week time. That's when we found it and discovered it. She's acknowledged that people within the household, she declares, were using her phone. I'm not satisfied with that. Yes. And my client has her phone records.
All right. And Ms. McManus has testified under oath that it was not her, but a family member.
Right. That doesn't seem to jive with the state when my client testifies to those same facts, Judge.
Is there any more inquiry from Ms. McManus?
Anything further, Mr. Wiggs?
No, thank you.
You may step down from the witness stand. Thank you.
Okay, it doesn't do the
Remain
job.
outside the courtroom.
I do have the Florida statute 90.616, which deals with rule of sequestration, along with Hines v. State 719 Southern 2nd 358. Provide those to the defense and the court.
And I tell you what, this prosecution has been on
The
point.
rule of sequestration only extends to the viewing of
That's-
testimony. Watching news reports or anything like that is not contemplated by the rule of sequestration. And in Hines, the court points out that the appellant correctly.
She's been doing it all week.
Notes 1 and 2. Appellant correctly argues that the trial court erred when it applied the sequestration rule as a strict rule. A trial court must first determine whether the testimony of a witness would be substantially different after having heard the testimony of other witnesses in violation of the rule. To determine whether the violation was intentional or inadvertent, and if intentional, whether it was the witness, party, or attorney who acted in bad faith. Once it has been determined that the circumstances surrounding the violation, the trial court may then exercise its discretion in deciding whether or not exclusion of the witness is necessary. In this case, the testimony of Rena McManus, she is the teacher of Isabel Shaver during the calendar year in question, and she is just going to testify about the child's demeanor, and that there was never any.
Oh, he is going to have
time
rebuttal
where there was
witnesses,
any
child
sort
junkies.
of
You're right.
Change, and also I have the school records of Isabel showing her attendance, her grades, things of that nature. So there's no evidence that she has actually viewed any testimony in this case. Whether or not she or someone in her family liked a post about the case does not warrant exclusion in this case.
All right, Mr. Williams.
To the court, Judge, the data, the information she's looking at is court TV. It's not just a little blog from one person to another. The heading directs that she's observing this.
What the?
That she's observing the trial matter as it's proceeding. It's not just a little blog from one person to the other. So I believe the witness is violated.
Welcome everybody to the chat. Happy Friday the 13th.
A motion to exclude is denied. As to Ms. McManus. Now we're on to Ms.
Denied.
Urbanowski.
Denied. This judge is not. He does not play. Mr. Mafioso.
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
Dang. He works out.
Are you all set? Okay. Please state
them
and spell
arms.
your full legal name.
My name is Rebecca Urbanowski.
Woo!
It's Rebekah. Last name is Urbanowski.
And please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth? So help you God.
Yes, I do.
Thank you. Please proceed.
Ms. Urbanowski, have you viewed online any of the testimony of any witnesses in this case?
No, sir.
Did you have a Facebook profile?
Yes. A business and a personal. Yeah.
And there was a reference, I believe it might have been like on a TV post with your Facebook profile liking the post. How did that come to be?
I'm not sure. I scroll pretty fast when I'm going through Facebook, and a lot of the news channels were covering this. If I might have hit that, then that's my fault. I don't know, but
Even if you were to like posts such as that nature, that doesn't necessarily mean you viewed the video on it, correct?
correct. No, I did not.
Have you viewed any of the testimony in this case?
No, sir.
All right, Mr. Wiggs.
Have you been looking at court lately?
I've seen some, not this week. I've seen some, not this week.
That's your name, Rebecca Filmer?
Yeah, it's me.
Okay. And Rebecca Filmer on this one, correct?
Yeah, it's me.
And that says Court TV up there, correct?
Yeah, that says Court TV.
Okay. You go by Urbanowski?
That's my legal name, but I go by Filmer.
Okay. Yeah, we heard different from your husband this week. But this would have been Wednesday, 4:37 this week.
She looks
Okay.
great, man. I'm jealous. She's got some great arms. Look at that
If that's what it says.
neck. Oh,
You think? You don't know. Okay. Judge, we'd ask these to be admitted into evidence,
It's fine.
and because of the questionable nature,
Or as far as the hearing, that is fine.
All right.
and because, yeah, correct.
So admitted into evidence as to the hearing only, not
you're
as to
new
the
here.
trial.
Don't be shy.
And
Jump in the chat.
what exhibit are we up to?
I think this would be exhibit 1 for purposes of the hearing.
Purpose of the hearing, this will be it'll be a composite of 3 documents. It'll be defense exhibit A. It'll be entered into evidence without objection as defense number 1 for the purposes of this hearing only.
I don't have any further questions this morning to the court.
All right, and please proceed. Yeah, further questions?
No further questions.
Okay. All right, you may step down from the witness stand. Please remain on standby outside of the courtroom. Thank you. All right, proceed with argument, Mr.
Yeah, I
Woods.
mean, these days I think it's really, really hard not to see.
Case, and the clear instructions of the court to every
Dang,
juror,
she's like
and the obligation of the
in really
state.
great shape.
And this matter has proceeded more than once throughout the trial. The state has had ample opportunity to properly advise the witnesses not to be talking. I know the court repeatedly questions the jurors whether or not they should look at, that they don't look at anything. This woman was not responsive and not definitive as to those questions. Yet we have physical evidence that's now in evidence that she has been viewing objects. We ask that she be excluded from this cause.
All right, state's position.
She gave definitive evidence that she has not actually viewed any testimony of the case. That is what would invoke the rule of sequestration and the inquiry. And there has been absolutely no testimony about how that would have impacted or altered her testimony in any way, even if it had been viewed. So therefore, the request should be denied.
Motion to exclude is denied. Is there anything further before we call the jurors back in?
No, Your Honor, not from the defense.
State?
No, sir.
All right, let's bring the
Denied.
jury in. Thank you.
Denied. Well, there's no excuse for Laurie not to still look like that. If she has, oh wait, she's not, they're not talking to each other. That's right. Okay, I'll be right back.
All right, please be seated. I see that all of the members of the jury have returned. Thank you again, members of the jury, for your time, attention, and patience today. And I have a few questions for you before we begin. Did any of you speak with anyone or each other about the case? Okay, everyone has answered no. Did any of you view any media, news reports on the internet, anything about the case? Okay, everyone has answered no. Did any of you conduct any research concerning the case? All right, all jurors have answered no. Did any of you encounter or speak with any of the attorneys who are present in this case? Okay, all of the jurors have answered no. Anything further from the defense or the state? All right. Then the defense has rested. State, you may proceed.
State calls Rena McManus.
Yeah, South Park hits stuff on the head, like nails it.
Good
Laurie's
morning.
a
Please
stalker.
come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. Okay, please state and spell your full legal name.
Rena McManus, RHINAMCMANUS.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Please proceed.
Please introduce yourself to the jury.
Hi, my name is Rena McManus.
Do you know Isabel Shaver?
Yes, I do.
How do you know her?
She was my student at Pine Ridge Elementary.
And what year?
That lady's a teacher?
was she in your class?
She was in my class in 2016.
Would that be the school year then going from 2015 into 2016?
Yes, it is.
Now, what grade did you teach them?
First grade.
How old are students in first grade generally?
Generally 6 or 7 years old.
And did you know Laurie Shaver?
Yes.
And what about her father, Michael Shaver?
Yes.
And
Maybe
how did you
she
know
just
them?
looked like
I
she
had
just got out of bed.
They were parents of Isabella, obviously, but I had met them both meet the teacher that school year.
And both Michael Shaver and Laurie Shaver attended that event?
For meet the teacher, yes.
And how were they acting during that time frame?
Normal parents, inquisitive about how the year would be, wanted to find out about me and the curriculum. It was very pleasant.
Now, over the school year,
You're an
you were
expert.
dealing with Isabel Shaver, she had good attendance,
Yes,
good grades,
yes.
and did you ever notice any issues with her?
No,
Was there any time that you saw some sort of behavior change in her?
not at all.
Any time where she appears to become more withdrawn or acted in a different way?
No,
Could I go ahead and at this time admit the records, school records of the children, showing defense states MMM for identification. Around the state moves into evidence, states MMM as the next numbered exhibit, as a business record with the proper business record certification and notice.
I believe we're up to 65, correct? Okay, thank you. Any objection?
Judge, no objection.
Or without objection, states MMM will be admitted into evidence as states number 65.
And I'm showing witness red number 1205 on the bottom. You recognize these as the records for Miss Shaver while she was in your class.
yes,
And does that confirm everything you've been saying about attendance, grades, no behavior problems, things of that?
not at all. Yes, it does.
Throughout your teaching experience, do you encourage students to talk to you if they have any sort of problems?
Yes, of course.
And did she ever talk to you about any issues that she had at home?
Never.
Did you also teach her brother Aiden?
Yes.
And when was that?
2 years later.
And how was his behavior when you were teaching him?
Just like hers. Sweet.
Nothing further, Judge.
All right, thank you, Mr. Wiggs.
What the?
How old was this about?
7.
7 going on 8?
I'm not 100% particular about her birthday.
Correct. Okay. What degree do you hold?
I have a master's in education,
Anything else?
my teaching degree.
Okay. You have a degree in psychology?
No, sir.
Okay. How large is your class?
Usually from 17 to 20.
Okay. So you're talking about the mindset of Isabel Shaver, correct?
Well, I'm talking about not her mindset, but the behavior that I witnessed.
Right. Okay. And your mind may reflect your behavior to a sense, correct?
Correct.
Okay. Your behavior actually may be shielded by other events in your life, correct?
My behavior?
No, anybody's.
Oh, yes.
Okay. They may want to lock up. They may want to be quiet, correct? Isabel was relatively quiet, was she not?
Yes.
Okay. Do you hold any degree in psychology?
No, sir, I don't.
Any degree in sociology?
No, sir, I don't.
Okay. How large is your class?
It goes from like 16 to 20 students.
How many sit downs did you have with Isabel Shaver on a one-on-one?
Many.
Any?
Mostly, it's all academic, so we do small groups. So
No, I'm not talking about a small group. I'm talking about you on one-on-one with Isabel Shaver.
in what manner, sir?
I'm just asking you, did you have any one-on-one sit downs with Isabel Shaver?
In processing education, the way we teach, yes, sir, I did.
You sat with Isabel Shaver individually without anybody else around.
That's not what I'm understanding.
I don't know.
So I have
What?
never.
No, ma'am. Let me ask.
Objection.
Please allow the witness to finish answering. You may finish your answer.
Sitting on a one-on-one in a room isolated, that's not what we do.
Correct. I don't care about what you do. I'm just bringing that point out. You didn't do that.
I think you should care about what I do because I'm a teacher.
Ma'am, I'm bringing out a point.
Okay, sir.
You're not sitting there with Isabel Shaver doing any kind of psychological analysis.
No, sir, that's not my job.
Okay. You don't have a degree.
What? That's wild, Brandy.
No, sir, and I would not.
Correct. Thank you.
All right, state.
Mr. McManus, would you have individual conversations with all of your students throughout the course of a year, although other students may have been present in the room?
Yes.
Nothing further, Judge.
Thanks. We have no further questions.
I should be released from our subpoena.
Yes, sir.
All right. Thank you for appearing today. You're released from further testimony. Have a good day.
The state calls Jared Strickland.
That's wild. That's
Good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
this guy again.
All set? Okay. Please state and spell your full legal name.
Jared Strickland, JARRODST.
This poor guy's not able to investigate other. Hey,
Please raise your right hand.
Joanne,
I'll swear you
welcome
in. Do
back.
solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God.
Yes, sir.
Thank you. Please proceed.
Girl, you should. That's crazy.
At this point, I'm pretty sure the jury knows you, but can you reintroduce yourself?
Sure. Corporal Jared Strickland, the Lake County Sheriff's
Poor
Office.
guy can't investigate any other cases right now.
We've been having various discussions about Facebook profiles.
How are you, Joanne? We're watching the Laurie Shaver trial. Have you watched any of this?
Did you view various pictures of Laurie Shaver's child, Isabel Shaver, from November of 2015 through May of 2016 on Laurie Shaver's Facebook?
Yes, I did.
Showing the fence was previously been marked for identification as states N.
So weird. I think I just saw a comment get deleted. It's weird.
Showing the witness who has previously been marked for identification that states NNN.
NNN.
Do you recognize those photos?
Yes, I do.
And are those photos from the Laurie Shaver Facebook profile? That
Yes, they are.
or at this time, the state moved NNN into evidence. as the
Happy
next
Friday
number
the
seven.
13th,
All
y'all.
right, that would be 66. Any objections?
Yes, Judge, a standing objection as to the motion regarding.
Same
the data
objection.
and relevance issues we've raised previously.
All right, the objection is overruled. States NN will be
Overruled.
admitted into evidence as states number 66.
And Detective, it's easier to just reference the posts from the packet I gave you. Go ahead and publish. A bit for you guys.
You don't know him, Brandy? Oh my gosh. That's sad.
All right. So this first photograph that we are looking at, when was that posted?
November 18th. Actually, November 16th, 2015.
So approximately 6 days, approximately a week after the last known sighting of Michael Shaver.
Correct.
Moving on to the next post. When was this photograph posted?
November 21st, 2015.
We have a series of I believe this is about 6 photos. When were these posted?
Are these the pictures with the cookies?
Yes.
November 22nd, 2015.
And that would extend on to the picture that appears to have a gummy worm coming out of her mouth, out of her nose.
Yeah.
I don't know if I'm in order. I see the screen.
Yes. This photo here is part of that same April post, correct?
Yep, there it is. I believe that those are
Hey, Lucy.
dates
Good
are
morning.
out of whack.
I'm glad you're here. Welcome back.
It looks like the end of March 2016.
Yeah, we have some crazy stuff for you to read. Happy Friday the 13th.
Photos here. First of all, this post that starts with page 18.
Thank you, Joanne.
On the photo 1829.
I'm glad you're
We
here.
have a date for the post. Actually, I believe it goes over to when were these photos posted?
May 3rd, 2016.
Finally, picture of her in a black dress. The post that went along with that. When was that posted?
May 19th, 2016.
Going back to the excavation of the Shaver residence, were you involved with contacting Ms. Shaver after the warrant had been completed?
Yes, I was.
And how did you contact her?
By phone.
So she was not in any sort of custody.
That's correct. She was not.
And when you were calling her, what was the purpose of that call?
To let her know that we were finished with the search warrant and that she could return to the house, and also to let her know the items that we had taken.
And at that time, were you asking her any questions, or were you just informing her of those facts?
Just informing her of those facts.
Showing the defense what has been previously been marked as states AAA for identification.
A. I think we could all write books about our moms.
Showing the witness, states AAA.
Do
You recognize that?
I love they do these triple letters for evidence.
Yes, I do.
And what is it?
This is a CD copy of the phone call that I made to Miss Shaver.
How do you recognize that?
It has my initials on it.
Oh,
Have you reviewed it?
are we going to hear a phone
listened to it
call?
Before initialing that?
Yes.
Is that a fair and accurate reporting of that conversation?
Yes, it is.
At this time, the state move states AAA into evidence as the next numbered exhibit.
Is there any objection?
Woo!
We just subject irrelevant.
Objection is overruled.
I
States
love that he
AAA will be
overrules
admitted
every
into
objection
evidence
for the
as states
defense.
number 67.
You're going to ask to publish?
Permission granted.
Publish that sucker. Play it. What's on there? I wonder if they know that they named a juror the other day on the court channel. Because you know Margaret Van Houten would have been all over that. Are they going to play it? I have no patience, Todd Murphy. You know that.
Yeah, let me see what she's doing.
I was like, what story can I make up?
This is Laurie. Hey, Laurie Shaver, with the sheriff's office. Hi. I just wanted to call you because you own the property that we are done out here. You guys are welcome to come back anytime. We locked the doors back up. Put the keys off the phone in the shed back where it belongs. And everything is just ordered. But I do have to real quick and put the paperwork we left not touch. Additional swabs, SD card with photos belonging to Laurie Shaver's office. Possible buckshot bleeding, projectiles, unfortunately this is a word that I cannot read, and human skeletal movement. So as far as all that stuff goes, do you have any questions? Okay.
Okay, that was uneventful.
During this phone call, did you inform Ms. Shaver there was human skeletal remains found on the property?
I did.
Did she react in any way?
No, she just said okay.
That's exactly it. It was uneventful. She was like, okay.
There was some mention of a computer, some SD cards, things of that nature. Were those ultimately reviewed to see if there was anything relevant about the time frame of this homicide?
Yes, they were.
And was there anything relevant on those various electronic items that were?
There were not.
Nothing further, Judge.
Mr. Wiggs?
Just that police report.
Yeah, she wasn't surprised at all. It was like, oh my gosh, she didn't react that way. Like, oh, you found this? She didn't even blink.
May it please the court.
Yes, sir.
Yes, Mr. Hawigi.
Deputy,
Corporal.
corporal, sorry. You were quite polite on that call, correct?
Excuse me, I can't hear you.
I believe you were quite polite on that phone call, don't you?
Yes, sir, I do.
I believe that Laurie Shaver was quite polite on that phone call, don't you?
Of course.
And I don't believe we heard any confession of a crime or any implication of any guilt on that phone call, do we?
To repeat what I've tried to say for the last 2 days.
No, sir.
Whenever you take
No,
all
sir.
of the evidence as a whole,
Sir, please answer the question directly.
As to this phone call, do we hear any confession of guilt?
I didn't ask her.
No. Do we hear any
Oh my
confession of guilt?
gosh.
No, sir, you do not.
Very well. Thank you.
Thank you. State? All right, sir. Thank you for appearing today. You're excused from further testimony. Have a good day.
Good
State calls
gravy.
Kendall Davidowski.
Are we ever going to get to closing arguments today?
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable and let me know when you're ready to proceed.
Oh,
All right,
goodness.
please state and spell your full legal name.
Kendall Davidowski, KENDALLDAVIDOWSKI.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Thank you. Please proceed.
Can you please introduce yourself to the jury?
Kendall Davidowski.
Did you know Michael Shaver?
Yes, I did.
How did you know him?
We originally worked together at Spaceship Earth over at Walt Disney World from November of 2014 till about May of 2015.
And what was your position with this?
I was an electrical apprentice at the time. He was a mechanic.
No, this is the
At the
girlfriend.
time that you met him, where was he living?
He was living at the Warbirds hangar in Kissimmee.
What is
I already
that?
checked it. You didn't see
It's
the big
a
smile on my face?
Airplane hangar, I mean.
And do you know Laurie Shaver?
I know of her, yes.
And what was, at the time that you met Michael Shaver, well, let me ask you this, at some point did you start a dating or physical relationship?
Yes, we did.
And what was the status of his relationship with Laurie Shaver while he was living at the hangar?
They were separated at the time.
How old is she?
Now, are you aware of what caused Michael to separate and move into that hangar?
I was told.
Based on hearsay?
State your response.
Your Honor, can we approach?
Yeah.
Sidebar, please.
You can't say what you were told. I want to hear what he's going to say about this one. You can't say what you were told. I mean, right? How old was she in 2015? Because she looks pretty young today. Hey, Kirsten, you're back. I know, but that's who she was dating. He was dating her in 2014, 2015. Kirsten's here. I didn't think she was going to be here for like a couple of weeks. Look at that. Can't stay away. Yeah, so how old was she? That's crazy. She looks young. She is the girl that sorry, Kirsten, she's the girl that Michael was dating before he passed. But keep in mind this was almost 10 years ago, if not 10 years ago. Look how young she is. So I don't know how old she was back then, but she was just a young thing. I mean, I don't know. She had to be. Oh. That's yeah, she had to be very young back then. That's crazy. Yes, she did yesterday, Kirsten. She took the stand yesterday. Oh my gosh, you missed it. It was a wild ride. We could not believe the story. Her daughter took the stand yesterday. She allowed her daughter to get up there and take the hit for her. How awful is that? Yeah, this is literally a Lifetime movie. True. I mean, it just has been a tangled web. It's really bad.
Were you aware of the events that led to why Michael Shaver was living in Woodward?
He had told me why he was, yes.
And was that related to his arrest for domestic violence?
Yes, it was.
Yes.
Now,
The daughter is
did he talk? And I'm not going to ask you to
very, very
say
close to her mom.
What he told you about that event, but did he explain what had happened that night to him?
Yes.
Based on that, did he express fear of Laurie Shaver for his safety?
Yes, he did.
And can you explain that?
He was concerned of his safety and the children's safety with Laurie and a gun.
Laurie and what?
And her having a gun.
Now, did you ever see Michael Shaver interact with his children?
I saw him interact with his son, Aiden, once.
And how was that?
They seemed to get along very well.
And at some point, did your dating relationship with Michael end?
Yes, it did.
And when was that?
About April of 2015.
And who ended it?
It was kind of mutual decision. It was just becoming too much at that point.
And
Yeah, she was like, "You got too much baggage, man."
To reconcile with Michigan.
To my knowledge, yes.
Did you remain friends with him?
We weren't friends. We still worked in the same area, so I mean, we were cordial, but we didn't speak to each other.
After he went missing, did you make attempts to reach out to him to see where he might be?
Yes, somebody from Spaceship Earth had contacted me, seeing if I had contacted him or heard from him. I had not, so I reached out to him around November of 2015.
And did you ever hear from him?
I believe he said that he had left and that his children, or he just left the children. But at that point, I didn't know if it was actually him or not.
You and had, well, first of all, was that a phone call?
It was through Facebook. It was through Facebook Messenger.
And had you interacted with him in Facebook before?
Previously, before May, yes.
And did you, when you guys were dating, did you also exchange text messages?
Yes.
So was there anything unusual about the contact that you had with him and the content of it?
It just didn't seem like him to just up and leave. He spoke so highly of his children, so I didn't see that happening. And it was very short. It was just all very short, one-word answers. So that was not usually like him.
And have you ever initiated any sort of sexual harassment claim against him?
No.
Nothing further, Judge.
Mr. Wiggs?
Yes. You never filed a sexual harassment claim against Michael?
No, I did not.
You know anybody that did?
I had a sexual harassment claim filed against me.
You're
Whoa.
sexually harassing people?
Supposedly, yes, according to
Okay.
Disney.
How long did you date Michael?
From about, I would say December of 2015, December 2014 to April 2015.
So you heard Michael's version of events,
Yes.
correct?
Yes.
Did you see any did he show you any photos of any battered women?
No.
Okay. Did he show you any police reports involving Michael Shaver? Okay. Did you ask him about that?
We had a brief conversation about it.
Okay. Did you ask him about any involvement with law enforcement or any agencies?
No.
You know who killed Michael Shaver?
I do not.
Thank you.
Oh, well,
Redirect.
okay.
Ms. Kavadowski, was anyone involved with this case involved with making that claim against you?
According to Disney, it was Laurie Shaver.
Oh,
Nothing further, Judge.
Any follow-up?
No follow-up.
Thank you for appearing today. You're excused from further testimony. Have a good day.
dang.
The state calls Robert Sellers.
Whoa.
morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed.
I'm ready, sir.
All right, please state and spell your full legal name.
Robert Sellers, Robert, last name Sellers, Sellers.
Please raise your right hand. I'll swear you in. Do you solemnly swear
You
or
open the
affirm
door.
that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. Please proceed.
Please introduce yourself to the jury.
My name's Rob Sellers. I'm currently an FBI agent. I was a Lake County Sheriff's Office deputy for 5 years, and that's how I'm involved with this case.
Because the sexual harassment charge was
In
filed from Laurie.
2014, what was your position with the Lake County Sheriff's Office?
At that time, I was on road patrol, assigned to Sector 3, which is the southern portion of Lake County.
And what will your duties be as someone on road patrol?
I'm his road patrol, just like the guys and gals that are on the street now, responding to 911 calls and answering calls for service in the southern portion of the county.
Now, did you have an opportunity to come into contact with Laurie Shaver and Michael Shaver in September of 2014?
Yes, sir, I did.
And were you the arresting officer of Michael Shaver from the domestic violence incident that has been discussed in this case?
Yes, sir, I was.
And when you got there, did you speak with both Laurie Shaver and Michael Shaver?
I did. I spoke with Laurie first and then ended up making contact with Michael a little bit later on.
Is it fair to say that their stories contradict?
Yes, sir.
Now, were there photographs taken of both Laurie Shaver and Michael Shaver, along with some things that happened, conditions within the house?
Yes, sir. I believe Deputy Suttles took those photos.
I'm showing defense, which has been previously marked as states QQQ.
All right, sidebar, please.
Everybody who's not in the chat, say hello. Happy Friday the 13th. Am I moving? Sorry. Oh no, Kirsten, you don't feel well? I'm sorry. Yeah, it's Friday the 13th, y'all. I gotta see what's happening today.
Showing witness, what's been labeled as states QQQ. You recognize those photos?
Oh, Beetlejuice is out.
Yes, sir, I do.
And what are those photos?
Those are photos that were taken the night of September 4th when we responded to, I guess the first couple photos are from when we met Laurie Shaver in the Target parking lot in Claremont. And then the last couple photos appear to be when we met Mr. Shaver at the residence and photos of the residence itself in Claremont.
Did they fairly and accurately?
Oh, I hate that. I'm sorry, Kirsten.
As part of your identification in this case back in 2014.
Yes, sir, they do.
The state moved to states QQQ with evidence is the next numbered exhibit.
All right, Mr. Wicks, without objection. Without objection, states QQQ will be entered into evidence as states number 68.
Going to go ahead and publish. This photo number 1 from states QQQ. Who is that?
It's Laurie Shaver.
Photo number 2. What does this photo depict?
The photo of her left arm,
Photo number 3.
her right arm.
And photo number 4. Who is this?
Mr. Shaver.
And during the course of your investigation, did you observe any sort of laceration to his head?
Yes, sir.
Photograph number 5. Does that demonstrate that laceration?
That would be the laceration, yes, sir.
And photograph number 6. What is depicted here?
Their residence.
Photograph number 7. What is shown in this photograph?
Broken door to their residence.
Did Laurie Shaver give you any explanation about how that happened?
I don't recall.
Photograph number 8. What is that photograph?
I believe it's the other side of the same door.
Photograph 9.
2 firearms that were involved in the altercation.
2.
Photograph 10.
Be the bathroom.
Was that all the various areas of damage that occurred?
Yes,
That you took photographs of?
to the best of my recollection, yes, sir.
There's also some sort of indication of an entertainment center that was damaged. Did Laurie Shaver give you any explanation about how that happened?
Not that I recall.
Any explanation of the broken vase that
Not-
went along with the sliding glass door?
There was, but I think there was a story from Mr. Shaver about how that had occurred.
But Ms. Shaver gave you no.
No, it's not that I recall.
Did Laurie Shaver give you any explanation of how Michael Shaver got the injury to the top of his head?
Yes, sir, she did.
And what was that?
She stated that Michael had the pistol in his left hand and that they fought over the pistol. And while they were fighting over the pistol, it somehow went up and struck him in the head.
Did Mr. Shaver have contradictory version of events?
He did.
Were there any adult witnesses present when any of this happened?
No, sir.
No. Were there any attempts to talk to any of the children in this case, specifically the oldest child, Isabel Shaver?
There was, yes, sir.
Was she able to tell you anything about what happened?
No, sir.
Nothing further, Judge.
All right, Mr. Wiggs.
We move this thing, Madam Bailiff?
So now they're having to explain all these pictures the defense put in. That's why they're bringing all these people. Good morning, LaDonna. Thank you. Happy Friday the 13th. Thank you, thank you. And I was on time.
I'm sorry.
I was
what do
watching
you-
the wrong
name,
day,
please,
but I was
report.
on time.
Yes, sir.
What do you go by now? What's your,
I go by Rob, but my legal name's Robert. Yes, sir.
okay, I know you're with the FBI.
My
now.
government name is Robert.
What's your title? is?
Special agent with you.
Special agent, okay. What do you want me to call you? Special agent? Rob, okay. Rob, when this event transpired and you went to the scene, where was Miss Shaver?
She was on her way to the substation in Claremont, and she was told by dispatch to stop where she was at, which I believe was the target located off 50 in Claremont.
Right. Miss Shaver's the one that fled the residence for her safety, correct?
From my understanding, yes, sir.
Correct. Miss Shaver's the one that fled the residence with the children to protect those children, correct?
Yes, sir.
Very well. Thank you.
All right, redirect.
No, sir.
All right. Thank you for appearing today. You're released from further testimony and have a good day.
Thank you, sir.
Yes, sir.
State calls Weldon Nicholas.
Good gravy.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Wilma
Oh, it's the
Nicholas.
neighbor lady. Oh, she doesn't have her hair all blown out today.
Nicholas.
And please raise your right hand and I'll swear you in. Do you solemnly
chewing
swear
gum.
or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Thank you. Please proceed.
Can you please reintroduce yourself to the jury?
Hi, Wilma.
Now, in September of 2014, was there a disturbance at your neighbor's house, the Shavers?
Yes.
And how did you become aware of that?
When I arrived home from work around 6 o'clock, Mike called me on my cell phone.
Not getting into anything specific that he said, but did you go over to his residence at that point?
Yes.
And when you met with him, how was he acting?
He was kind of frantic, distraught.
Did you observe any injuries to him?
Yes.
What was his demeanor? Was he said distraught? Anything?
He was really concerned.
Did he still appear to be under the effects of the event that placed him into that condition? Was he still troubled by whatever caused his injuries and things of that nature?
Not so much of his injuries as something else.
Just for the record, I'm going to object on Williams' basis under the Williams rule, the matters that we previously addressed at the court.
Yes. State.
Can we approach?
Yes, let's have a sidebar. Thank you.
Good gracious. Remember yesterday, Laurie was like, yes, she's a very nosy neighbor. I think she heard her say that because look how her demeanor has completely changed today from what it was the other day. She is not a happy person today. I think she knows that Laurie said some ugly things about her yesterday. LaDonna, we've been waiting on you to get here so we could spice up the chat a little bit. Oh yeah, somebody said something to her because you could see her demeanor is like completely different. Because you know all that stuff Laurie talked yesterday about her talking about how they had to put up a privacy fence or whatever to keep her from looking in their yard. And she won't even look at Laurie right now. She is just disgusted with her. She's like, oh, she's fit to be tied today.
So while Mr. Shaver was in this excited state, did he describe to you what had happened?
Yes.
What did he describe to you that happened?
He told me that they had an argument. Laurie was intoxicated.
Woo!
And she had taken off with the kids. The injuries that I saw on him, he said that
hey everybody,
welcome, to kill the children, him and herself, and he fought her with the gun and was trying to get the gun away from her, and she hit him over the head, the top of the head with the gun.
Did you see injuries consistent with that?
Yes.
Did you take pictures of those injuries?
I did.
Oh, she took the pictures.
Previously marked for identification of states. Oh.
Welcome everybody. Happy Friday the 13th.
Showing the witness states oh.
I don't know why I like their triple letter.
Yes.
And what are those photos of?
Those are the pictures that I took of Michael and his injuries and his torn clothes.
Does that accurately reflect how Michael Shaver was when you observed him that night after you described the events that you talked about?
Yes.
This time the state moves states 000 into evidence. This is the next numbered exhibit.
Mr. Wiggs, any objection?
Same objection, Judge Stanton.
Objections overruled.
Overruled.
States 000 will be admitted into evidence as states number 69.
Oh, and it's number
At the
69.
time that you knew Mr. Shaver, what was his approximately height and weight?
He was about 5'6", almost the same height, I think, as me, and about 150 pounds.
Going to go ahead and publish photograph number 1 from the previous exhibit. What were you trying to show with this photo?
About suitcase size.
Barely.
Let me turn it.
Okay. You can tell that he has blood coming from the top of his head and it has come down onto his shirt. His shirt has been torn in multiple areas here in that photo.
And the tearing of the shirt, did he attribute that to Laurie Shaver?
Yes.
You got it, Trout Junkies. You got suitcase
You
size.
can see the top of his head and the injury a little bit better here.
Did you take a top view of that in photograph number 3?
Yes.
Photograph number 4, what are you showing here?
He had the keys to her truck in his pocket and she was fighting him and tore his shorts to get the keys out, and she succeeded in getting the keys out.
And did he express why he was trying to prevent her from having those keys?
Because she was drunk and she was taking off with the children.
Nothing further, Judge.
All right, Mr. Wiggs.
Hey, please, court.
Yes, sir.
Do you know who was charged out of this incident with any criminal offense?
Yes,
Who?
Mike was.
Correct. So you get Michael's version of the events, and only Michael's version, correct? Correct, ma'am?
Yes,
And Michael ends up being prosecuted, correct?
he does.
Okay. So you would agree the state attorney's office had a different opinion.
Oh my.
Objection, Your Honor. Charging decisions of the state.
Sustained.
So evidently, people were dealing with Michael
Welcome,
Shaver.
welcome.
Michael Shaver ends up prosecuted, correct?
Based upon,
Ma'am?
Yeah.
Correct?
yes,
Okay. So what you got is a one-sided interview with Michael, correct?
I have heard her myself.
No, ma'am. You spoke to Michael, correct?
Yes,
Okay. Did you interview Laurie Shaver?
No.
Okay. Do you know who the initial aggressor was that caused that injury to Michael Shaver other than what Michael Shaver told you?
I wasn't there in person.
Correct. Correct. Thank you.
All right, redirect.
Yes, sir.
All right, thank you for appearing today. You're excused from further testimony. Have a good day.
Woo, she is
The state calls Rebecca Urbanowski.
fit to be tied. I don't know, where is Wiggy from? I've never heard that name, Wiggy.
Good morning. Please come up to the witness stand. Please be seated. Make yourself comfortable. Let me know when you're ready to proceed.
Oh,
Thank
here we
you.
go.
All set?
I wonder where Jenny's
Please
been. I
state
haven't
and
seen
spell your
my
full
Jenny
legal name.
Peach.
It's
Oh,
Rebecca Urbanowski, REBEKAHURBANOWSKI.
All right, thank you. Please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Please proceed.
I am Rebecca Urbanowski.
And do you know Laurie Shaver?
Yes, I do.
How did you meet Laurie?
I met her at the gym through her boyfriend at the time.
And you work for the gym?
Yes, Gold's Gym in Claremont.
And what position did you have there?
I was a personal trainer there.
And when you say her boyfriend at the time, who is
Jeremy Townsend.
Did you ultimately start a professional client-trainer relationship where you were training her?
Yes, I did.
And what was her general physical status at that point?
She was in pretty good shape. She had lost a substantial amount of weight on her own already, but she was in good shape, better than most, new clients that I get.
Was she doing strength training?
Yes, we train twice a week.
And do you know Travis Filmer?
Yes, I do.
How do you know Travis?
That is my brother-in-law now.
Who's your husband?
My husband is Austin Filmer.
And when did you get married to Austin?
October 28th, 2016.
Now, did you legally take his last name?
I did not.
So on your driver's license, it says Rebecca Urbanowski.
It still says Urbanowski, yes.
Have you ever had any sort of social media profile where you've had the Filmer last name?
Yes, I have, yeah.
But if it were said that you never took his last name, that would be a correct statement.
Legally, no, I never took it.
Did you ever socialize with Laurie Shaver and Travis Filmer?
Yes, I did.
And when did they start dating?
I don't know a specific date that they started dating, but I know that they were in contact after they had initially met and hung out.
When approximately did they meet?
Hi, Matilda. Welcome.
They met the first time at the end of February of 2016.
And when was this compared to when she was dating with Jeremy?
It was kind of in like that gray area, I think. When Travis and Laurie first met that night, Travis had already had a girlfriend at the time. So after that night, they actually left. We had gone to Old Town, and Austin and I were kind of dating at the time, or starting to date. And both the boys came, and Laurie and I had been there. And when Austin and Travis showed up, Travis felt it was uncomfortable because he had already had a girlfriend at the time. He didn't want it to look like a double date. So they left probably 20 minutes after getting there.
The period of time when she was dating Jeremy, was there like a hard break to that? And then Travis came to the picture, they kind of overlapped. What was the deal there?
They kind of felt like they overlapped. So it was kind of a gray area where when one stopped and then the other one officially began.
At some point, did you live with the defendant?
Yes, I did.
And is that at the residence in Claremont?
The Sandy Pines, correct. Yeah.
And when did you start living with her?
That would have been May 7th, 2016.
And at any point while you were there, would Jeremy come over, stay overnight, or anything like that?
Never overnight. I've only seen him there one time when I was there, but I hadn't moved in at that point.
And like, what kind of day are we talking about when Jeremy would come over?
It was during the afternoon time.
Around your lunch break?
Yeah, I would say so. Yeah.
And while you were living there, did you see Laurie with multiple phones?
Yes, I did.
And what was her phone number at the time?
Offhand, I can't say exactly what it was. I just have the one that I have now.
Is that the same number that you had back then, or has that changed?
It would have changed. Okay. Yeah.
Now, during the time that you were friends with Laurie Shaver, was a concrete slab put in the backyard around a fire pit?
Not when I had initially moved in, no.
Were you friends with her and socializing with her when that occurred?
Oh, yeah, sorry. Yeah.
And were you and Austin present when the cement slab was placed down?
I was actually at work most of the day. When I got back, it was there because I worked majority of the day.
During the time frame that Laurie has been with your brother-in-law, Travis Filmer, has the relationship between Austin and yourself change with Travis?
Very much so.
Describe.
We rarely see Travis anymore. For a while, we couldn't even get in contact with him because we found out that all of our phone numbers were blocked from his phone. Austin and Travis have always been very, very close. They're fraternal twins, and they've been through a lot in life together. They used to go fishing a lot, hanging out, but we don't see anything from him, or we don't talk to him. We don't socialize. The last time I've actually physically seen him was when their grandfather passed away at his funeral. That was the last time I physically saw him.
When was that?
Did Laurie Shaver ever tell you what happened to her prior husband, Michael Shaver?
Just that he had left.
Nothing further.
Mr. Wiggs?
So y'all have a bad relationship.
Who?
Austin and Lori and Travis, correct?
There is no relationship.
Correct.
Sure.
So that's what you have to testify here to tonight? That there's a bad relationship? Bad blood?
I guess.
You lived in the residence in a certain period of time, correct?
Correct.
Didn't see a homicide committed there, did you?
No, I didn't.
Didn't see anybody being buried, did you?
No, I didn't.
Okay. And you know there was, she was dating Jeremy for a period of time, correct?
Yeah, for a little bit.
You have sit downs with Jeremy?
I've seen him once there.
Okay. So he was at the house once. You moved out. What was the time period you moved out?
It was the day after their wedding. So it would have
Okay.
been 2008, January 1st, 2000.
You're talking about Travis and her.
Yeah, Travis and Lori's wedding, yeah.
So were you back there in the period of time when you was dating Jeremy?
Was I back there? What do you
Were
mean?
you living with Lori?
When I moved in May, they weren't really dating. It was kind of an up and down.
Thank you.
Redirect?
The wedding that you referred to, that was in, what year was that?
That would have been December 31st, 2016, sorry.
And had that been you were a guest at that?
Yeah, because we were, the next day, we were moving into, Austin and I and Kendall were moving into our new home.
Had that event been represented to you to, in fact, be a wedding?
Yes, it was.
And she was in a white dress?
Yeah, when I had come back from signing our lease and everything, she was already in her dress.
There was wedding cake?
There was a wedding cake, yep, a dress.
Everyone there thought that Travis and Lori were being married at that time?
For sure.
Nothing further.
All right, Mr. Wiggs? Nothing. All right, thank you for appearing today. You're excused from further testimony. Have a good day.
The state calls Katina Vasquez.
Good gravy. I'm trying to find this on a different channel because the sound for Law and Crime is terrible right now. I don't know who's on the microphone that is making this so bad. It's getting a lot of feedback.
All right, good morning. Please come up to the witness stand. Please be seated, make yourself comfortable, and let me know when you're ready to proceed. All right, please state and spell your full legal name.
Katina Vasquez, Katina V as in Victor, Asquez.
Please raise your right hand. I'll swear you in. Do you solemnly swear or affirm that any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God? Yes? Okay, thank you. Please proceed.
Please introduce yourself to the jury.
Hi, I'm Katina Vasquez.
And do you know Laurie Shaver?
Yes, sir.
Do you see her here in the courtroom today and identify her by something that she's
A black jacket.
wearing? And
That any testimony you give today shall be the truth, whole truth, and nothing but the truth, so help you God. Yes, okay, thank you. Please proceed.
please introduce yourself.
Hi, I'm Katina Vasquez.
And do you know Laurie Shaver?
Yes, sir.
Do you see her here in the courtroom?
Can y'all hear this one?
A black jacket.
No.
And how did you meet Laurie Shaver?
Through Scott Amatuccio, my ex-fiance.
No.
Meeting Laurie through boyfriend Mike, did you develop a friendship with her?
Yes,
Never
sir.
mind.
Did you develop a friendship with Michael Shaver?
Yes, sir.
Closer friends with her than Mike?
Yeah.
And
I tried to find a
did
better
you ever go
sound, but I
over to
can't.
the Shaver residence after Mike disappeared in November of 2015?
Yes, sir.
Okay, LaDonna.
Why were you going over there?
She said he had left, and I went over just to see how she was doing.
And did Laurie say anything to you about where Mike was?
No, just that he left in a black SUV in the middle of the night.
And did she reference anything to you about Mike's work or whether or not he was still working there?
That I don't think he was going to work.
And did she tell you specifically how he informed his employer that he was no longer going to work for them? You don't remember anything about that?
Mm-mm.
Okay. While you were there, did you see anything that you thought was unusual based on the story that she gave you that Mike had just left?
Yeah, all his stuff was still there.
When you say all this stuff, what do you mean?
She was in the she was on the porch on the phone, and I went to the bathroom, and like all his stuff was like still in the closet and stuff, and the car was there.
Talk about clothes, toiletries, things of that nature? Is that a yes?
Yes.
Did you see any extra phones in the residence?
There was a black phone on the counter.
Now, while you were there, was the defendant trying to sell or get rid of any of Michael's property?
Yes.
And what was that?
She was on the back porch on the phone and was trying to sell guns, and I asked, why are you selling Mike's guns? Isn't he going to need them? And she said she bought them. They were hers.
Now,
It's okay. They're just getting a feel for the vibe in the room.
Familiar with the domestic violence case where Mike Shaver was arrested in 2014?
Yes, sir.
And how did you become familiar with that?
Laurie told me.
And what did she tell you about that 2014 domestic violence case?
At her house, she said, because Mike had come back into the home, he was living at an airport. And she said that, and I was kind of like, why is he here? Kind of. And she said that she was working with being honest with her therapist and that Mike didn't touch her. Like all the wounds were from her. She threw a vase and broke a door. That wasn't Mike, and he was actually trying to stop her because she had a gun and was trying to kill herself.
She wasn't trying that hard.
When did your friendship with Laurie Shaver end?
2017.
And at the time in 2017, when the friendship ended, did she make any statements to you relating to Michael Shaver still being alive?
Yes, sir.
And what did she tell you?
She was going to move up to Gainesville because I had a son and couldn't afford daycare. And she was going to drive up, look for houses. She got my Starbucks order, took pictures of the kids in the car, and then disappeared. Didn't hear from her for 2 weeks. Took me off Facebook. 2 weeks went by, and she finally got in touch with me and said that she panicked because Mike was in the parking lot. And she thought maybe Scott told Mike that she was coming up there and he was stalking her. And I'm like, well, why haven't you called me? And she said that the cops had her phone and the truck was at the police station because he was tracking it.
And this is in 2017 that she was saying Michael Shaver was stalking her.
Yes.
So clearly after May of 2016.
Yes.
And clearly after September of 2016 when the cement slab was put in her backyard.
Yes.
Nothing further.
Mr. Legs?
Please support.
Yes, sir.
Ma'am, did you file a letter to support Laurie Shaver on an injunction?
No.
No? You never submitted any letter to DCF?
No.
Did Michael ever obstruct your relationship with Laurie?
No.
Okay. Now, when you said that Laurie was selling property out of the residence, do you have any understanding whether that was only Michael's property or whether it was marital property?
It was.
That she was by law prohibited in any manner?
She just said the guns, and I know the guns were theirs. And
Okay. Do you know anything about marital labor and contribution to the marriage?
no.
Correct. So you just assume this is Michael's property and she had no right to touch it, correct?
They were their guns. He built and restored guns. So
Do you know why the property was being sold?
no.
Do you know if it was maybe the need for groceries and necessities?
No.
Do you know if there was any plan to aid anybody with those funds to escape detection of a crime? Did you ever witness a murder or any event occur at the house?
No.
Now, the event that you spoke about an incident that occurred at the house, a crime, a battery, were you there to witness that event? Correct. Thank you.
Redirect. All right, thank you for testifying here today. You're excused from further testimony. Have a good day.
Woo!
Next witness.
At this time, the state of Florida rests.
Thank you. Y'all, this chick is cuckoo for Cocoa Puffs. Crazy.
All right, let's take the jurors out at this point. Have a comfort break.
Okay. She's a stalker. She filed a harassment charge against her husband's girlfriend at Disney. She's writing letters as her friends. She disappeared for 2 weeks after getting her friend's Starbucks order. What the?
Jurors have exited the courtroom. Are there any motions at this time?
Yes, Judge, we'd renew our motion for judgment of acquittal on same grounds previously stated. We'd also make clear that these acts of violence that have been spoken of have been only offered for prejudicial value against the defendant. There's no probative value. There's no notice. It's not substantive evidence established to prove a prima facie case. It's purely circumstantial. The state supplied the court with case law. In that case law, there's a notation to a 5th DCA decision speaking about any relative probative value can be outweighed by the substantial prejudice that it presents. It should not have been presented to the jury. The digital data that the state relies on is not sufficient to establish causation. It does not establish the nature of the offense. It does not defeat a claim of self-defense. There's been reference to sale of guns. There's no distinguishing that this is non-marital funds, that Ms. Shaver had no right to sell this property, nor does it advance any claim to an accessory after the fact. We'd ask that the court grant a judgment of acquittal on these grounds and all other arguments previously mentioned before the court.
All right, thank you, Mr. Wiggs. State's response?
The state most favorable to, in the light most favorable to the state, there's sufficient evidence to present to the jury.
Motion's respectfully denied when viewed in the light most favorable to the state.
Respectfully
Evidence that
denied.
establish a prima facie case sufficient to support a conviction as to each count in the information. Motion's respectfully denied.
Wait, who brought up the
And anything further, Mr. Wiggs?
Nothing from the, 1 second.
Yes, sir.
who brought up the altercation stuff? Didn't Mr. Hawigi bring that up?
There's no rebuttal. Thank you, Judge.
Thank you, sir. No rebuttal from the defense. How long will the state take to print out the revised jury instructions?
I have a couple questions for clarification. They're done, Your Honor?
Yes, sir.
Some answers from Mr. Wiggs on a few things. The forcible felonies in the self-defense instruction, you wanted attempted murder and aggravated battery.
Correct.
In order to define my needs a little more specific, I'm assuming you want attempted second-degree murder and not attempted.
I do too, LaDonna. They opened the door on a lot of things.
I think we've declared, or my mindset is that there is an attempted first on her, by Michael against her, so the elements of attempted first.
Attempted first and aggravated battery.
Correct.
Okay. Do you want the definition or do you want the elements?
The elements.
Yes, sir. Thank you, Judge.
All right. And is there anything further? I will read the preliminary instructions to the jurors when they are called back in.
Rich, how long are you going to put that together?
We need probably 15 minutes to.
Well, 15-minute break, is that sufficient?
I think so.
Would you like additional time for yourself?
No, sir. I'm good.
15 minutes is
I
good.
think so.
Okay. I will plan on a 15-minute break. Yes, sir.
Okay, I'm sorry. Do you want to go direct yet? What time do you want to take up closing?
Well, and again, there are no time constraints, but for timekeeping purposes, how much time would the parties like?
Usually shorter than the defense. I'll defer to Mr. Wiggs how long he thinks he needs.
I'll let the state advance first.
You're all right. I will probably be around an hour. Worst case scenario, an hour and a half for both my initial and rebuttal. But usually not very long-winded.
All right. Well, sounds like combined it might be 3 hours.
I would say, I would, yes, at the most.
And again, please take as much time as you need. Right now it's 10:46. We'll plan on coming back around 11, and I'll read the initial instructions to the jurors at that time, and we can go into the closing at that time. We can break for lunch after. Well, we'll see where we get, and then perhaps after the state's initial closing argument, we'll break for lunch, and then proceed with the defense and the state's second round after that.
Yes, sir.
All right. Anything further? We'll take a 15-minute break.
OMG, y'all. We're gonna have a verdict today. What do y'all think? Right? What do y'all think? Verdict today? She going to get her new jangalang-langs today? Jangalang-lang? Jangalang-lang? She's gonna get those today. I think she's gonna get them today. You don't think so? Oh, come on, trial junkies. I think so, LaDonna. She going today. I wonder. No. I think she's gonna go today. They can't make us wait all weekend. Yeah, I think it's gonna be today. I don't know. Let me see. It would be, I mean, there's only 6 of them. It's not like there's 12 jurors. Remember that. There's only 6 of them. So there's not 12 people that have to be convinced. I don't know. The daughter's going to be a separate situation. So we'll have to see. I'm gonna look up what are the odds of the daughter getting charged. Um, um, it's not saying anything about whether or not her daughter could be will be charged or not. She's gonna have to have like serious. Oh,
on the record in case number 2020 CF 2361.
I made the appropriate changes to the jury instructions that would ask that Mr. Wiggs double check especially the self-defense instructions, since there were a lot of changes made to that to make sure it's accurate.
Please let me know once you check the instructions, Mr. Wiggs. And prior to calling the jurors back in, I'd like to have a sidebar with the parties and with the deputy, if you would. Okay.
Email you that. I got that on my way. Oh, he's still looking.
Is this my copy?
Yes.
Okay. Terrence, do you have a stapler? Big stapler? Okay. I'll find it.
long time.
No, it's sidebar.
It was extremely.
All right, please bring in the jurors. Thank you.
All rise.
All right, I see that all the members of the jury have returned. Please be seated. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Laurie Lee Shaver, the defendant in this case, has been accused of the crimes of murder in the second degree with a firearm and accessory after the fact to second-degree murder. Introduction to homicide. Laurie Lee Shaver is accused of murder in the second degree in count 1. Murder in the second degree includes a lesser crime of manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Michael D. Shaver was killed by Laurie Lee Shaver, you will then consider the circumstances surrounding the killing and deciding if the killing was murder in the second degree or was manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. Number 1, when the killing is committed by accident and misfortune in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation, or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design and construction. An object not designed to inflict bodily harm may nonetheless be a dangerous weapon if it was used in a manner likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Laurie Lee Shaver may be found guilty of murder in the second degree or any lesser included crime. Murder second degree, count 1. To prove this crime of second degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1, Michael D. Shaver is dead. 2, the death was caused by the criminal act of a Laurie Lee Shaver. 3, there was an unlawful killing of Michael D. Shaver by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1, a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2, is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove that the defendant had an intent to cause death. An issue in this case is whether Laurie Lee Shaver did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation. In order to find that the defendant did not have a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, A, there must have been a sudden event that would have suspended the exercise of judgment in an ordinary reasonable person, and B, a reasonable person would have lost normal self-control and would have been driven by a blind and unreasoning fury, and C, there was not a reasonable amount of time for a reasonable person to cool off, and D, a reasonable person would not have cooled off before committing the act that caused death, and E, Laurie Lee Shaver was in fact so provoked and did not cool off before she committed the act that caused the death of Michael D. Shaver. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her guilty of second-degree murder. Possession of a...
You should not find her.
Yes, sir. I will read that again. If you have a reasonable doubt about whether the defendant had a depraved mind without regard for human life because she acted in the heat of passion based on adequate provocation, you should find her not guilty of second-degree murder. Please make that correction. Thank you. Possession of a firearm and discharge causing great bodily harm or death. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission
Yeah,
of the
you
crime,
do need to go back and watch it.
discharged a firearm and in doing so caused great bodily harm to or the death of Michael D. Shaver, you should find the defendant guilty of murder in the second degree with discharge of a firearm causing great bodily harm or death. Great bodily harm means great is distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she discharged a firearm, you should find the defendant guilty of murder in the second degree with discharge of a firearm. If you find that Laurie Lee Shaver committed murder in the second degree, and you also find beyond a reasonable doubt that during the commission of the crime she actually possessed a firearm, you should find the defendant guilty of murder in the second degree with actual possession of a firearm. A firearm is legally defined as any weapon, including a starter gun, which is designed to, or may readily be converted to expel a projectile by the action of an explosive. The frame or the receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means the defendant, A, carried a firearm on her person, or B, had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. When there are lesser included crimes or attempts, and considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included offense. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of murder in the second degree is manslaughter. Manslaughter. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Michael D. Shaver is dead. 2, Laurie Lee Shaver intentionally committed an act or acts that caused the death of Michael D. Shaver. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Aggravation of manslaughter by carrying, displaying, using, threatening to use, or attempting to use a firearm. If you find that Laurie Lee Shaver committed manslaughter, and you also find beyond a reasonable doubt that during the commission of the crime she personally carried, displayed, used, threatened to use, or attempted to use a firearm, you should find her guilty of manslaughter with a firearm. A firearm is defined as any weapon which is designed to or may readily be converted to expel a projectile by the action of an explosive. The frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. If you find that Laurie Lee Shaver committed manslaughter, but you are not convinced beyond a reasonable doubt that she personally carried, displayed, used, threatened to use, or attempted to use a firearm, then you should find her guilty only of manslaughter. Accessory after the fact to second-degree murder. To prove the crime of accessory after the fact to second-degree murder, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, a murder in the second degree was committed by another. 2, after the murder in the second degree was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at the time Laurie Lee Shaver knew that other person had committed At that time, Laurie Lee Shaver knew that other person had committed the murder in the second degree. 4, Laurie Lee Shaver did so with the intent that other person avoid or escape detection, arrest, trial, or punishment. The elements of murder in the second degree have previously been given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment, nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which she is accused, there may be evidence that she committed other acts that would constitute a lesser included. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser included crime indicated in the definition of accessory after the fact to second-degree murder is accessory after the fact to manslaughter. Accessory after the fact to manslaughter. To prove the crime of accessory after the fact to manslaughter, the state must prove the following 4 elements beyond a reasonable doubt. Number 1, a manslaughter was committed by another. 2, after the manslaughter was committed, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid that other person. 3, at that time, Laurie Lee Shaver knew that the other person had committed the manslaughter. 4, Laurie Lee Shaver did so with the intent that the other person avoid or escape detection, arrest, trial, or punishment. The elements of manslaughter have been previously given to you. It is not necessary for the state to prove that Laurie Lee Shaver's assistance was successful in allowing another person to avoid or escape detection, arrest, trial, or punishment. Nor is it necessary for the state to prove that the other person was convicted. The intent with which an act is done is an operation of the mind, and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence, like any other fact in a case. Justifiable use of deadly force. It is a defense to the crime of murder in the second degree, including lesser included offenses, if the actions of Laurie Shaver constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm. Laurie Lee Shaver does not have the burden of proving that she was justified in using or threatening to use deadly force, or that Isabel Shaver was justified in using or threatening to use deadly force in the defense of Laurie Shaver. Instead, for you to find the defendant guilty, the state must prove beyond a reasonable doubt the defendant was not justified in using or threatening to use deadly force. The law on justifiable use or threatened use of deadly force in Florida is as follows. Laurie Lee Shaver was justified in using or threatening to use deadly force, or Isabel Shaver was justified in using or threatening to use deadly force in defense of Laurie Shaver if she reasonably believed that such force or threat of force was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The elements of attempted first-degree murder are: 1, Michael D. Shaver did some act intended to cause the death of Laurie Shaver that went beyond just thinking or talking about it. 2, Michael D. Shaver acted with a premeditated design to kill Laurie Shaver. 3, the act would have resulted in the death of Laurie Shaver, except that someone prevented Michael Shaver from killing Laurie Shaver, or he failed to do so. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. A premeditated design to kill means that there was a conscious decision to kill. the decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The elements of aggravated battery are: 1. Michael D. Shaver actually and intentionally touched or struck Laurie Shaver against her will or intentionally caused bodily harm to Laurie Shaver. 2. Michael D. Shaver, in committing the battery, intentionally caused great bodily harm, permanent disability, or permanent disfigurement to Laurie Shaver, or used a deadly weapon. A deadly weapon is any object that will likely cause death or great bodily harm if used or threatened to be used in the ordinary and usual manner contemplated by its design and construction. I believe there's a typo there as well. Great bodily harm, and after great bodily harm, there is another one as well. Great bodily harm means great as distinguished from slight, trivial, minor, or moderate harm, and as such does not include bruises. If Laurie Shaver was not committing any crime other than alleged murder in the second degree, or any lesser included crimes for which the defendant is claiming self-defense or defense of others, and if she was in a place where she had the right to be, then the defendant had no duty to retreat before using or threatening to use deadly force, or before Isabel Shaver used or threatened to use deadly force. If Laurie Shaver or Isabel Shaver was in a dwelling in which she had a right to be, she had no duty to retreat and had the right to stand her ground and use or threaten to use force, including deadly force, if she reasonably believed that such conduct was necessary to prevent imminent death or great bodily harm to herself or another, or the imminent commission of attempted first-degree murder or aggravated battery against herself or another. The use of deadly force is justifiable if Laurie Shaver or Isabel Shaver reasonably believed that the force was necessary to prevent imminent death or great bodily harm to herself while resisting any attempt to murder her or another, or commit an attempted first-degree murder or aggravated battery upon her or another, or to commit an attempted first-degree murder or aggravated battery upon or in any dwelling house in which she or another was present. In deciding whether Laurie Shaver or Isabel Shaver was justified in the use or threatened use of deadly force, you must consider the circumstances by which she was surrounded at the time the force or threat of force was used. The danger need not have been actual. However, to justify the use or threatened use of deadly force, the appearance of imminent danger must have been so real that the defendant or Isabel Shaver actually believed the use or threatened use of deadly force was necessary. Moreover, to justify the use or threatened use of deadly force, a reasonably cautious and prudent person under the same circumstances would have believed the use or threatened use of deadly force was necessary. Laurie Shaver or Isabel Shaver is presumed to have held a reasonable fear of imminent peril of death or great bodily harm to herself or another when using or threatening to use defensive force that was intended or likely to cause death or great bodily harm to another if A, the person against whom the defensive force was used or threatened to be used was in the process of unlawfully and forcibly entering or had unlawfully and forcibly entered a dwelling, residence, or occupied vehicle, or if that person had removed or was attempting to remove another against that person's will from the dwelling, residence, or occupied vehicle, and B, Laurie Shaver or Isabel Shaver knew or had reason to believe that an unlawful and forcible entry or unlawful and forcible act was occurring or had occurred. The presumption of reasonable fear of imminent death or great bodily harm does not apply if A, the person against whom the defensive force is used or threatened to be used has the right to be in or is a lawful resident of the dwelling, such as an owner, lessee, or title holder, and there is not an injunction for protection from domestic violence or a written pretrial supervision order of no contact against that person, or B, the person or persons sought to be removed is a child or grandchild or is otherwise in the lawful custody or under the lawful guardianship of the person against whom the defensive force is used or threatened to be used, or C, the person who uses or threatens to use defensive force is engaged in a criminal activity or is using the dwelling to further a criminal activity, or a person who unlawfully and by force enters or attempts to enter another's dwelling, presumed to be doing so with the intent to commit an unlawful act involving force or violence. Dwelling means a building or conveyance of any kind, including any attached porch, whether the building or conveyance is temporarily or permanently or mobile or immobile, which has a roof over it, including a tent, and is designed to be occupied by people lodging therein at night. Residence means a dwelling in which a person resides, either temporarily or permanently, or is visiting as an invited guest. If you find that Laurie Shaver or Isabel Shaver, who because of threats or prior difficulties with Michael D. Shaver had reasonable grounds to believe that she or another was in danger of death or great bodily harm at the hands of Michael D. Shaver, you may consider this fact in determining whether the actions of Laurie Shaver or Isabel Shaver were those of a reasonable person. If you find that at the time of the alleged murder in the second degree, Laurie Shaver or Isabel Shaver knew that Michael D. Shaver had committed an act of violence, you may consider that fact in determining whether Laurie Shaver or Isabel Shaver reasonably believed it was necessary for her to use or threatened to use deadly force. In considering the issue of self-defense or defense of another, you may take into account the relative physical abilities and capacities of Laurie Shaver, Isabel Shaver, and Michael D. Shaver. Defendant's failure to report a crime. The state has charged Laurie Shaver with the murder of Michael Shaver. Further, the state has charged Laurie Shaver with being an accessory after the fact. You must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. All right, it's about 11:30 right now. I think at this time we'll take our lunch break. Parties have anything further, state? Yeah, come on up, please.
He said.
So we're not even going to get to closings before lunch?
Yeah, that's what I'm saying. Brian has to be that dense of an individual.
Instructions that I will read to you prior to breaking for lunch. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation and the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whether the words reasonable doubt are used, you must consider, whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? 7, has the witness been convicted of a felony or a misdemeanor involving dishonesty or false statement? 8, does the witness have a general reputation for dishonesty or truthfulness? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that their testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give their opinion. However, an expert's opinion is reliable only when given on a subject about which you believe them to be an expert. Like other witnesses, you may believe or disbelieve all or part of an expert's testimony. You have heard the testimony of a child. No witness is disqualified just because of age. There is no precise age that determines whether a witness may testify. The critical consideration is not the witness's age, but whether the witness understands the difference between what is true and what is not true, and understands the duty to tell the truth. The defendant in this case has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about their testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to 1, whether when the defendant made the statement, she had been threatened in order to get her to make it, and 2, whether anyone had promised her anything in order to get her to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. All right, and was that to the satisfaction of the parties?
Yes, Judge.
Okay. And at this time, is there anything further before we break for lunch?
Nothing from the defense, Judge.
No, sir.
Thank you. All right, we're going to break for lunch at this time. Again, please do not discuss the case with anyone, including each other. I would ask the parties to return to the jury assembly room at 12:45. So that will give you over an hour for lunch. Thank you. All right, the jurors have exited the courtroom. Is there anything further before you break for lunch? We'll meet back at 1 o'clock.
Not at this time.
All right, then we'll begin closings at that time. Mr. Wiggs, anything further?
Okay, so I'm gathering
All right,
that
thank you.
this
We're in
all
recess.
fell on the daughter. Even in the jury instructions, this seems to have fallen on the daughter. What the heck?
Donald needs freedom. That's what he needs. You can have a story if you can get him freedom. How about that, Trey?
So there, he's saying to the daughter's testimony shouldn't be think that they're like not influenced.
Go get
This makes no sense.
On the stand. Have at it.
That they're saying,
like, what the fuck?
I don't understand. They're saying to make the daughter's testimony not think it was influenced or anything, that they should think that she was clear-minded. Yeah, they make it sound like the daughter did it and not the mom. What's for lunch today, y'all?
Little did Sean fucking know. I had Bolanos on speakerphone.
They have to arrest the daughter
I had Bolanos on speakerphone listening to the entire conversation on the other phone.
if they don't find her guilty. If they don't find her guilty, y'all, I'm going to be shocked.
I don't fucking care. I was like, period.
But these jury instructions make me think that
You don't need anything from these people.
they're going to find her not guilty and just guilty of after the fact.
Either they accept your terms and they tied to this fucking
I can't believe the prosecution didn't fight more
He's not interested in doing
over these instructions.
because the only thing that he fucking cares about is that
Yeah, she does. I know. I'm sorry, y'all. Yeah, they messed up on these charges. The jury instructions are terrible. Yeah, why didn't they mention that she was drunk? Did they even test her for drunkenness? Alcohol. Being drunk. I can't believe it's not a crime to not report a crime. Yeah, this whole trial is just redonkulous.
I didn't see that comment. Well, I didn't probably see a lot of comments.
Yeah, I don't understand. Okay, so I'm confused. Enjoy your lunch, Brandy. Enjoy that stew.
Ridiculous. Oh God.
Well, we'll see what happens in the closing arguments because I want to see how they're going to spin this daughter confession.
I don't know what to say about it anymore.
And the timeline. They're going to have to attack the timeline.
I'm irritated to know Tierra did. Do anything on behalf.
I don't know. That
which is
defense attorney is pretty bad.
That's probably the easiest thing.
He can do a lot of damage.
Would be to show up to that thing and just say.
Okay, you guys, we're going to break for lunch. I'm going to make me some pasta. Now that Kirsten said she's having pasta, I'm going to go make me some butternut squash pasta. LaDonna's having Italian. I'm having Italian. We're going to have Italian.
Well, I think I got 13.
Holy moly.
13 plus one more today. Another murder I'm picking up, so 14.
Dang.
Today is.
Yeah, Kirsten got me in the mood for some pasta, so I'm going to have pasta. All right, let me find something to put on here while we're waiting during lunch break. Well, Okay, what do y'all want me to put on here while we're eating lunch? I don't think there's any other trials going on today. You're eating breakfast, trial junkies? What? Just now? It's only 11. Husband of missing woman back in court. Husband of missing woman. Okay. I just got it, Gwen. Oh. Oh, that's wild. Who is this guy?
Breaking news right now here at 5. Major new developments in the search for a missing Manassas Park mother. The husband of Matma Kafle Bot is now charged with hiding her body. The charges come more than 3 weeks after she disappeared. Good evening to you. I'm Scott Thuman.
And I'm Megan Clark. 7 News was there as police escorted Naresh Bhatt out of his home in handcuffs this afternoon. And even though
Sorry, looking for the current link. Oh my gosh, did you see this?
An international model, once a finalist in the Miss Switzerland pageant, is strangled to death, dismembered with a jigsaw, and then allegedly pureed in a blender. And prosecutors say they already know who did it, her husband. This is the story of 38-year-old Christina Joksimovic and the case against her husband and
Kirsten,
the father
do you want me to play
of her
the
two
daughter's
kids.
testimony
Christina's
from
story
yesterday?
takes us to Switzerland, where she lived and worked as a model and later a coach. In 2003,
I can play the
she won
daughter's
the Miss
testimony.
Northwest Switzerland pageant,
You missed
and
it
by
yesterday.
2008, she
And
was
the
a
moms.
finalist in
You
the
want me to
Miss
play that?
Switzerland competition. She later founded her own business called Catwalk Coach, where she transitioned to a coaching role and mentored a
Bill Shaver has been called to the stand. Ms. Shaver, please state and spell your full legal name.
My name is Isabel Shaver, ISABELLESHAVER.
Please raise your right hand and I'll swear you in. Do you solemnly swear or affirm that any testimony you give today
Yes.
shall
Here's
be
the
the
daughter's
truth, the whole
testimony
truth,
from
and nothing
yesterday.
but the truth, so help you God?
Yes, sir.
Please proceed.
When you hear
Isabel,
this, Kirsten,
spelled your name,
you
but
will
would
be
you
like
put your name on the
appalled
of the open court?
that she allowed her
Sorry?
daughter
Say your
to do
name
this.
Isabel Shaver.
How old are you, Isabel?
I'm 15. I turned 16 this Sunday.
I'm going to go make my pasta.
It's your desire to testify in this matter, correct?
Yes, sir.
You're aware of the arrest of your mother, correct?
Yes, sir.
Now, Isabel, there's allegations raised and floating around, so to speak, that you've been brought in here, kind of thrown under the bus. Has anybody pressured you to testify in this cause?
Absolutely not, no.
Now, there was, Miss Johnson was appointed as an attorney ad litem to represent you.
Correct.
Did you meet with Miss Johnson?
Yes,
Did you discuss your case with Miss Johnson?
I did.
Did Miss Johnson go over all the rights that you would waive by testifying in this case?
Yes, sir.
Is it still your desire to testify?
Yes,
Do you understand your obligation to testify truthfully?
I do.
Are you going to testify truthfully?
I'm going to testify truthfully.
Would you explain your relationship to Laurie Shaver?
Laurie Shaver is my mother. Me and her are very close. We've always been very close. We do everything together. I don't know. She's like my best friend and a mom in one.
Excuse me one moment, Judge. Judge, I'm just asking Madam Clerk to mark the birth certificate. The court is taking judicial notice of this matter.
All right, defense, do you wish to view the birth certificate?
Excuse me?
Do you wish to view the document, the birth certificate?
Yeah, do what they do. Judge, we had had a hearing on this matter as to the birth certificate of Isabel Shaver. The court had approved mandatory judicial notice. Madam Clerk is identifying the document. And once identified, we'd ask that the matter be accepted to the court, again pursuant to your order.
Is that Exhibit B? E is in Delta? Okay. All right, the birth certificate has been marked as Exhibit D. Is there any objection from the state?
Your Honor, it's improper to admit that as judicial notice, but it is an official record, and because of the fact that it's an official record, it is admissible, so the state has no objection.
All right.
Judicial notice, the state has.
Without objection, Exhibit D will be entered into evidence as defense number 1.
Isabel, you met me some time ago, correct?
Correct.
Met me at or about the time of your mother's arrest.
Right. Yes.
I had, did I not, a brief discussion with you?
We did. Yes.
And upon that brief discussion, we had requested that Ms. Johnson be appointed, correct?
Correct.
Now, if I ask you any questions you do not understand, would you please ask me to rephrase the question, repeat the question, or try to ask the question in a different way?
Yes.
Do you recall your father?
Yes.
His name?
Michael Shaver.
What was your relationship like with Michael Shaver?
We didn't really have much of a relationship. He wasn't very present. He worked at night, and so he slept all day during the day. And anytime he was home, we weren't really allowed outside of our rooms. We didn't have a relationship, really. He really wasn't a father to me.
Was the atmosphere calm? Well, how would you describe the household?
It was very combative. It was very tense. There was a lot of tension constantly. It's not calm. It was the complete opposite of calm. Nobody, whenever he was home, it was just, it was scary. It was like, we were just stuck in our rooms all day. And then like, whenever we weren't, it was just, he was very aggressive, and we didn't have that type of relationship. No, it wasn't a calm household.
You see any without talking about the facts of any events, did you see any altercations between Michael and your mother?
I did, yes.
Were they frequent?
Yeah. They were pretty frequent.
Were they physical?
Yes.
Your Honor, I'm going to ask Madam Clerk to mark these exhibits. The court has previously accepted them, taken, and entered an order to take judicial notice of those.
Can I see these?
Documents. I'll show you.
All right, the state can please view the documents. Thank you.
Can we approach?
Yes, sir. Come on up.
So speaking about household events, you had spoken that it was an atmosphere that was tense, I believe.
Yes.
I'm showing you a composite exhibit. It has 6 photographs in it. Had you seen your mom in that same or similar condition on multiple occasions?
Yes.
Are those true and accurate depictions how you frequently observed your mom? Without speaking about the events themselves. Did those images and mental impressions in your mind cause you to feel the need to take your mother's side at any time?
Yes. I mean, look at her.
Did it cause you, Isabel, to step up and in the past, on more than one occasion, and side with your mother?
Yes.
In the pictures that you looked at, who committed those injuries to your mother?
My father.
Judge, we'd ask that this exhibit, this composite exhibit, without testimony as to the events, be admitted into evidence and published to the jury.
How's the exhibit identified? What letter marking?
It is being
B as in Bravo? Okay. Any objection from the state?
okay.
Without objection, Exhibit B will be entered into evidence as defense number 2. Yes, sir.
Isabel, I'm showing you what's marked as Defense Exhibit C for identification purposes. Would you tell the jurors what you're looking at?
I see my father with his torn shirt and blood.
Speak up, please.
Oh, sorry. I see my father, and he has a torn shirt and blood.
Whose blood's that?
I mean, I'm assuming his,
Sis?
maybe.
Now, the photos you looked at.
Hello, we're listening to the daughter's testimony from yesterday.
Is this
For anyone who missed it.
that would do that? And say, we moved state Defense Exhibit C into evidence at this time, Judge.
And no objection? Without objection, Defense Exhibit C will be admitted into evidence as defense number 3.
Isabel, how frequently would those events occur? Without speaking the details of the events.
It would happen pretty often. They'd at least argue and like fight really bad, pretty much on the daily.
On the daily?
But it would escalate to those points a few times a month. Like it wasn't a rare occurrence. Like it happened often.
And as a matter of those events, and I may have asked this question before, did you feel a need to attempt to protect your mom in any fashion?
I did, yes.
Did you perceive your mother as a victim through those events?
Yes.
That response that transpired in you, did it become a natural and automatic response? You talked about the feeling inside of yourself of a need to protect your mother. Did that become automatic inside?
Yes, it did. Growing up, I mean, yeah, I've always stepped in for my mother. I would, do whatever I could do. I mean, I remember I had this stuffed animal, and her name was Lammy, and she was my favorite stuffed animal. And he used to, she would go to sleep on the couch, and because he would drug her water, and I would tuck her in, and I would give her my stuffed animal to protect her. And obviously it's a stuffed animal, it's not going to protect her, but it was just the act and the principle of it.
Was there a period of time when your father was removed from the residence?
Yes, there was.
Sorry for the sound. For some reason, the attorneys are very quiet on this one.
Yes.
As a consequence of these events?
Yes. Mm-hmm.
And during the period or the absence of your father, did your mother start dating anybody?
After he had been removed for a while, she did start dating Jeremy.
Okay. What was Jeremy's last name?
Townsend? I don't think I know his last name. It's something like that.
Okay. How often would Jeremy come to the residence?
He was over all the time. I mean, he came over for holidays. He was there for my brother's birthday. His son went to the same school as me and my brother, so he would meet up at our house every day before we go to school. And he was at the school for all the plays, the events, all that type of stuff. He was over all the time.
Would he come in the morning?
Yeah, morning, night.
Would he ever spend the night there?
Yes.
Would y'all go to places with Mr. Townsend or Jeremy?
Yes, we would.
Was he there for Christmas?
Not Christmas Day, but Christmas Eve.
Was he there for any other holidays or special events?
He was there for my brother's birthday. I don't really remember any other holidays, but I know he was there for my brother's birthday and Christmas.
Do you remember going shopping or out on the town with Mr. Townsend?
Yeah, we used to go to this Chick-fil-A a lot. That was one of the ones with like the playgrounds. And we'd go with his son and then me and my brother. We did that a lot.
Do you know if Mr. Townsend or Jeremy was married?
I don't think so.
Isabel, I'm sorry. I have to do this. But let's talk about Michael, your father. Do you know anything about the death of your father?
I do.
Do you know anything about how your father died?
I do.
Could you tell the jury?
So, it was a school day, and I'm sorry. And he.
First, let's relax, go slow, make sure the jury understands the events, okay?
Okay. It was a school morning. Me and my brother were getting ready for school. He hadn't been at the house for a while. He was kicked out, removed, and me and my brother were in separate rooms where we had pretty much been ready for school. I was eating my breakfast and I was watching TV. We had these like little plastic tables in our rooms, and I was watching TV and I heard arguing. Initially, I thought it was the TV, and then I was like, no, that's not the TV. So my room, it was my room, and then it had a bathroom and then a spare room. And so they all connected to each other, like through the bathroom. It was almost like a little like pathway. And so I heard, the fighting and the yelling, and it escalated. So when I was little, I would go through there to like sneak around. And I opened the spare room door, and in front of the spare room door was the dining room. And in front of the dining room, there was a glass door, like a sliding glass door. So I opened the door to the spare room, and I stood there, and I saw my father, and he wasn't supposed to be there. And my mom and my father were fighting, and my mom went to leave the argument, leave the porch. They were out on the porch, and he pulled her by the arm, and he pulled her into her lap onto one of the porch chairs, and he held her there. And then she was like, "We can work things out. Like we'll figure this out. It'll be different." And he was like, "No, there's no next time. There's no figuring it out." And he pushed her onto the ground. And he started kicking her in the stomach and in the back. And then he took his other foot and he put it on the side of her face. And she was screaming, and he was like saying there's not going to be another time, and that he was going to kill her this time. And I heard my mom screaming for help, obviously. And then he put his foot on the side of her face and pushed it into the ground. And I didn't hear her anymore. And sorry. And so I went to my mom's room, and I went at her end table, and I grabbed her gun, and I went back out, and I went to the door. The door was already open, and he had my mom on the ground still holding her to the ground, still kicking her. And I shot him. And nothing happened. He didn't fall. Nothing happened. And then Jeremy.
Let me stop you a little bit, Isabel. Okay, you say nothing happened. Was he standing or sitting?
He was sitting in the chair. Right.
You shot him. you know exactly where you shot him, or
I'm not exactly sure.
did you shoot him from the rear region, or where do you think you shot him?
I was aiming towards his head, but I'm not sure where the bullet went.
Okay. And what happened after you fired the gun?
He was just sitting there. I mean, he wasn't moving. Nothing happened. There was no blood. There was no nothing. And then,
Stop you there. Okay. Let me interject here and there, if I may.
okay.
Did you feel when you fired that shot that had to be done, or he would have killed your mother?
Yes.
Firm on that?
I'm firm on that.
Was he using that type of force in your mind?
Yes.
That it was necessary?
Mm-hmm. Yes.
Okay. What happened after you shot him, or you believe you shot him?
Afterwards, Jeremy came, and
How long?
it was right after it happened. Like, I hadn't even had a chance to walk away, move, nothing yet. And he came in and he took the gun from me, and then he shot him again. And that's when he fell to the ground. And my mom had crawled away. He fell to the ground. Jeremy shot him. He told my mom to take us out of the house, take us to school, and that we needed to leave. We are not to tell anybody. We can't tell nobody. We can't call the cops. We can't say anything, or else he was going to do the same thing to me and my brother. And he was going to, hurt us too. So we went to school.
Okay. So you leave the residence, you go to school. When you get to school, what happens?
We get to school. Nothing really happened at school. I would say I was most definitely in shock. But at the same time, it was like, because those types of events happen often, I was very used to the violence and seeing things like that. And so I was still able to perform normally at school and just kind of, not go about my day, be at school.
What time did you get out of school?
I was in elementary school, so I think around 3.
Okay. When you came home, was Jay there?
Yes, he was. He was fixing the front door.
Okay. Was there any evidence of your father in the residence?
No.
No, you're right. Yeah,
Did
trial junkie said no evidence.
Jeremy make any mention about he'd take care of this or anything like that?
Yeah, when he had told my mom to take us out of the house, and he told us not to tell anybody. He said that he would take care of it.
Okay. So let's get off that subject. There was a period of time, I understand, where y'all were intending to build a duck pond, correct?
Correct.
Tell me about the duck pond and what the plan was there.
So we had a bird farm. We had a bunch of different birds, and we needed a place for the ducks. So we built this big whole pond shaped thing, kind of like an artificial pond. And I remember me and my brother, we got these little red plastic shovels, and we were gonna dig the hole, make the pond, and that was the intended use for it.
Did you guys finish it or?
No, we never ended up finishing it. We ended up later on turning it into a fireplace.
Okay. Had there been previous discussions you were going to put a fireplace when you abandoned the duck pond?
Once we decided we weren't going to do the duck pond, we were thinking about either doing a fireplace or a pool.
Okay. After this happened at the house, what happened to Mom and Jeremy?
They broke up. I mean, that the last time that he, I mean, like that they were really like together, I guess, was the day my dad died. They broke up, so obviously they stopped seeing each other. But he would come, like I remember one time we were at a light, like a stoplight, and he like pull up next to our car. This happened on multiple occasions, and he would like scream at us from his car, like tell us to roll our window down. I remember we were going to this Publix, and he would follow us through the store to try and like talk to us, and then we switched Publix to a different Publix. He came to that one too. I remember he came to us in Walmart one time. He was driving by our house trying to, talk to us, talk to my mom.
When was the last time you drove by the residence, you think, Isabel?
Sorry?
When was the last time that Jeremy drove by the residence that you can recall?
At our old house, it was quite a while ago, but we've moved since then, and he has driven by the house we're living at now.
When was the last time, you think? How many months ago?
It wasn't too long ago, probably less than a year ago.
Can you tell Kirsten she has this child as screwed up as she is?
Okay. Isabel, this item is not here right at the present time, but did you have on the property a blue tarp? And by that, I mean the type of tarp you see sometimes put over roofs if there's a leak or to cover a boat or an item.
No.
Did you have, sometimes you see on boats or other items, straps to hold it down. Did y'all have any of those on the property?
No.
Frank Merritt, you recall Frank Merritt?
No.
You ever go to a tractor show?
Yes, yeah.
Was there a man, Frank Merritt, present that you recall?
Yeah, we did go. I mean, if that's Frank Merritt, then yes.
Okay. Do you recall leaving the tractor show early or anything like that?
Yes, I was really, really sick that day, and it was really, really hot. I'm really sensitive to the heat, and I have.
Let me interrupt you there. Do you have any health issues?
Yeah, I have like autoimmune issues.
Who's Frank Merritt?
Any arthritis or other issues?
I mean, we're still trying to I think it's arthritis. We're still trying to figure out what it is. They just have diagnosed me with hypermobility for now.
So she's got Munchausen too?
Yes.
Did you ever observe Mr. Marcato coming to the house to remove your father because of an injunction or any reason?
Yes.
During that event, did you see your mom waving a gun at him or anything like that?
No.
Scott Amatuccio. How often would Mr. Amatuccio come to the residence?
He wouldn't come over that often because he did live far.
Okay,
Wilma
I was like,
Nichols,
where's this
do you
tractor
know
show
Wilma
come into
Nichols?
play?
Our neighbor?
Okay. Did Miss Nichols come by and socialize with y'all at all?
No. We've hung out with her probably once when we first moved there.
I like your picture, LaDonna. I'm like looking at it up close. Don't look at my gray hairs.
Isabel, I'd started this with a discussion about your mom being arrested. Do you feel that it's imperative that you step up and tell this jury what happened?
I do think it's important that, I say what happened, yes.
And everything that you've testified before this jury, is it true and is it accurate?
Yes.
No embellishments?
No.
Nobody pressured you?
No.
And you've had your own advice of counsel, correct?
Correct.
Thank you. That's all I have. Thank you.
All right, thank you. All right, State?
Sir, may I please court?
Yes, sir.
Ms. Shaver, you need a minute?
No, I'm okay.
No, she's fine. She just literally talked about taking out her dad. But she can move on, have a normal day at school, and keep talking.
You said your birthday's coming up?
Yes.
Okay. And you're about to turn 16?
Mm-hmm.
And I'm not trying to pick on you, but these microphones and the recordings are recording everything. Sometimes it's hard to understand mm-hms and uh-huhs and things like that. So as much as possible, try to remember to say yes and no.
Okay.
And if you say it, because we all do, I'll probably correct you. And it's just to make sure the record's clear. Okay. All right. Now, the events that we are talking about obviously are some much longer ago, correct?
Correct.
All right. We're talking about stuff that happened in 2015, 2016, correct?
Right.
And some of this stuff that you've talked about is even older than that.
Right.
And so when we are talking about time frames in November of 2015, how old would you have been then?
2015.
Now her memory is
16.
very shady.
So I would have been awful at math. Oh my gosh.
6 and 7 years old. Sounds about right? Okay.
Okay, yeah.
And there's obviously been a long passage of time since that.
Mm-hmm.
Is that a yes?
Yes. Sorry.
That's okay. Now, it's fair to say that you don't want anything bad to happen to your mom, correct?
Correct.
You said you were very close to your mom. She's like your best friend.
Yes.
And that you definitely want your family to stay together.
Mm-hmm. Yes, correct.
Yes. Okay. I want to talk to you before we start talking about the event that led to your mother's arrest. I want to talk to you about some of the other stuff that you had mentioned. At one point, you said that your dad would drug your mom to put her to sleep. Do you remember saying that?
I do.
Okay. And during the course of this case, you've actually been talked to by law enforcement, by the Children's
Hello,
Advocate
everyone.
Center,
We're watching the
and myself.
daughter's
Is that fair?
testimony until the trial comes
And that
back.
interview with law enforcement would have been at the time of your mother's arrest in 2020.
Okay. Yes.
Okay. And then you went to the Child Advocacy Center and were asked questions about things that were going on a few months after that, correct?
Yes, correct.
And then the deposition where I asked you questions about this was in this calendar year, 2024.
Yes.
And there are going to be some times that I'm going to go ahead and refer to those various statements, and I've got the transcripts of them so you can review them if it helps refresh your memory. All right?
All right.
Have you reviewed any of those?
Yes.
And previously, when you talked about the allegations about your dad, quote, drugging your mom, you were 5 years old at that point, correct?
I believe so.
Okay. And what you described is you would see him put some sort of powder in a drink and give it to her.
Yes.
Okay. But when asked what he put in the drink, you didn't know, correct? All right. And you didn't know what it was.
I don't.
You don't know where he would get it.
No.
And quite frankly, you have no idea what he was putting in that drink.
Yeah.
Okay. But you don't know where it is or where it came from.
I don't.
All right. Now,
Kool-Aid mix.
the morning that your father was killed, you are saying that he was not living at the house at the time, correct?
Correct.
Saying And previously, you had stated that the last time he had lived at home was before you were in second grade. Do you remember saying that?
Yeah,
Is that accurate?
I would say first, second grade-ish.
Okay, so you hadn't lived at home at all since you were in first or second grade.
Yeah.
All right. And you were in third grade during the 2015-2016 calendar year, correct?
I think so.
Do you need to think about it a little bit, or are you good with that?
Yeah, I mean, I'm not sure what grade was in. I did 2 grades over the summer, so it kind of makes it a little.
Okay. Now, your school records indicated you were in third grade in the school year of 2015-2016. You would be.
Yeah, no, I'm not. Yeah, I'm just. Yeah.
So second grade would be the 2014-2015 calendar year.
Okay.
Is that
correct?
All right. So you're saying that he had not lived with you since before August or September of 2014.
Yes.
And the event that we're here to talk
somebody over in
about,
the law and
you
crime
don't know
chat
what
is
grade you
saying
were
that
in
Jeremy
when
is
that
a
happened,
stalker.
right?
I don't.
Okay. You don't know who your teacher was when
And
this
that he
happened,
stalked
correct?
Correct.
Their
You
family.
don't know what month
The same
this
way that
happened
Laurie
in, correct?
described. or
You
is
don't know
described.
what year this happened in, correct?
Yes.
You can't think of any holidays that this event was near, correct?
Not necessarily holidays, but like birthdays. I know it was. I'm pretty sure it was after my brother's birthday. I would say probably spring, summer-ish.
Okay. And previously you had said you thought it was spring or summer because you had recently been to the beach.
Yes.
Okay. And so that's in keeping with your brother's birthday?
Yes, his birthday's April 1st.
And when you say spring or summer, what do you mean by that?
Like, I mean, anywhere between spring or summer. I mean, that was so long ago.
I understand. Let me try to ask a better question. I may think spring starts in March.
Mhm.
You may think spring starts in May. So when you say spring, what months are we talking about here when you're saying spring or summer?
Probably starting in like April, May.
Okay.
I feel like that's when like the school year ends is like May, so like that'd be almost summer.
Okay. And when would summer end to you?
August, September.
So this event that led to you getting a gun, shooting at your father, having him eventually killed in front of you, and then being threatened, having your life threatened. The best you can come up with as far as when this happened is sometime in some year between April and August.
Yes.
The day that this happened, the events that you have described all happened in between the time frame that you woke up and went to school that day, correct?
It's almost time for them to be back.
And that would
watching
be from 7 o'clock in the morning
Law
till
and
about
Crime.
8 o'clock in the morning, correct?
Yeah.
And what you are saying happened is your father showed up unannounced
Mhm.
sometime in that time frame, correct?
Correct.
You're saying that he hadn't lived there since 2004, since about August of 2014. When was the last time that you had seen him prior to him showing up and having this confrontation with your mother?
Last time I saw him, I don't remember the exact day or anything. I mean, I remember like certain memories because they weren't good days. Like they, had bad events happen on those days. Because, I mean, like I said, this was so long ago, so I don't remember just like, days. I just remember like those bad events that took place. Okay.
But
Okay.
in relation to the time that you saw your father killed in front of you, how long had it been since the last time you had seen your father?
I would probably say a few months.
And you do not remember how he was dressed?
I believe he was wearing a pair of shorts.
Okay. Do you remember previously when I asked you that question in a deposition saying something different?
Would
Would it help refresh your memory if I showed you your transcript?
Yes.
Showing you your deposition, page 37.
and line 9.
I'm just going to go ahead and ask you to read to yourself the question on lines 7 and 8, and then your response on line 8.
I said I don't remember. Yeah.
Okay.
I said I don't
And I
remember.
also
She's
just
a
said
smart
that
alecky
I'm not
thing.
sure, but I think it was shorts.
I understand. I just want to make sure we understand. When I asked you these questions previously this year, you didn't remember them.
Right.
Okay. And there's obviously pictures of his dead body wearing shorts. Did you review that before your testimony changed?
No.
Okay. Now, so he shows up. You haven't seen him in a long time. An argument starts out on the back porch between your mother and father, correct?
Correct.
You went out and saw them arguing.
Mm-hmm. Yes.
Is that a yes? Okay. And I believe the way you described it is, and if I have the time frame that this happened, please correct me, but he was sitting in a chair and his foot was on your mother's head, correct?
Correct.
All right. And you described how he was, it's very difficult, kicking her with his other foot, correct?
Yeah, it started out with him kicking her in the stomach, in the back. Then she was screaming. So then he put his other foot on her head to stop her from screaming, pushing her head into the ground, basically like suffocating her, choking her. And he continued to kick, but obviously because he's using his other foot now, it wasn't as strong of a kick.
But he's, as you described it, he's sitting here with one foot not on her neck, on the side of her head, correct?
Mm-hmm. Yes, correct.
Kicking her in the back and kicking her in the stomach, correct?
Yes.
You go back in the house, correct?
Correct.
You had a phone, or I believe you described it as an emergency device that you could call 911 in the house, correct?
Correct.
All right. You did not call 911, correct?
Correct.
All right. And you stated you were never taught how to call 911, correct?
Correct, but that's not the reason why we didn't call 911.
Okay. You go into your mother's room, correct?
Correct.
And you go to her end table.
Yes.
Still not back yet.
And you get her
so you
pink
guys
and black
know.
gun.
Correct.
Showing you what's been previously entered into evidence. It states 26. You recognize this firearm?
That's not the gun.
Okay, so she had a different pink and black gun?
Yes.
How many pink and black guns did she have?
I mean, I'm assuming 2. I'm not sure. We had a lot of guns in the house.
Okay. So you grabbed some other, how do you know that's not the white one then?
Because the one that I used was not entirely, it was black and then the handle was pink.
Okay. So you grabbed her other pink and black gun.
Yes.
And then you go back outside.
Yes.
And at that point, your father is still sitting in that chair,
Yes.
his foot on her head.
Yes.
Is he still kicking her?
No.
What's he doing?
I mean, he's just kind of yelling at her, like holding her to the ground with his foot. And he's saying, like, you know, he's going to kill her. It's the last time. Like, they're not working it out because, yeah.
Is she on her side, on her stomach?
She's on her side. She's facing, so her stomach would be facing towards him.
And what was she doing?
Being held to the ground.
Was she struggling?
Yes. She was trying to call for help and scream. And then he pinned her to the ground with his foot.
His foot on the side of her head?
Yes.
She couldn't get out?
No.
So you take your mom's other pink and black gun, and from about 5 to 10 feet away, you shoot it.
Correct.
And you shoot him in the back of the head.
I think so, yes.
Do you ever remember saying that you shot him in the back of the head?
Yes.
Okay. So previously, before today, you definitively said, I shot him in the back of the head, correct?
Correct.
But that's changed now.
I mean, no, not necessarily. Like, I shot him in the back of the head.
I don't know where the bullet went, but that's where I was aiming. That's where I'm pretty sure it hit.
Okay. You hit him.
Yes, I think. Yes.
Okay. And when you hit him, today you said he just sat there, correct?
Yeah, he sat there and he's like shaked.
Okay. I want to make sure that was clear because you didn't say that on direct. He was almost like seizing, correct?
Yeah.
All right. He didn't get up, he didn't move, he didn't try to run.
Exactly. Yeah.
Okay, so clearly you hit him.
Yeah.
All right. And then pretty much simultaneously to you shooting your dad in the back of the head, you're saying Jeremy just happened to show up.
Like I said, he came there every single morning before school. This was right before school. We already had our clothes on. We were in the middle of eating. Like we were about to leave for school. Like he was there. He came before school.
He would come to your house every day before school so that your mom could then take you to school?
I mean, he would come with us. They would hang out. His son went to school there.
Okay. Now, after he arrives, while your dad is shaking and as you described, basically seizing in the chair, at this point, the amount of pressure he's putting on your mom's head has released. Is she able to get up?
Yeah, she crawls away. She doesn't stand up immediately.
Okay. But you're saying Mr. Townsend came over and took your mom's other pink and black gun from you.
The same one I had, yes.
Oh. And shot him again.
Yes.
Where?
In the head.
Okay. And at that point, he turns around and threatens you and your brother that he's going to kill you as well.
Not immediately after. He has the gun in his hand. He helps my mom up, and he tells us that my mom to take us to school. We need to leave the house. And so, I mean, that's when he lets us know, like, no calling the cops. Like, I will do the same thing to you that I did to your father, basically. Saying he will hurt us. He will come after us. He will kill us if we say anything.
You're the one that shot him in the head.
Yes, first.
Okay. And so your mom actually went ahead and took you to school after this?
Yes.
Okay. Dropped you off like nothing was wrong.
I mean, I asked us to go to school. We were in the car, and she asked if we wanted to go to school, if we were comfortable, and I said yes.
Okay. And you said that you didn't talk to anybody at the school about anything, or you didn't react at all at the school about anything because, as you said, this was normal.
No, I mean, I said that I was in shock, but I did not mention this to anybody as I was just threatened not to mention it to anybody. No, it wasn't normal to see somebody die, but having these type of experiences where there's a lot of violence in the house, there's a lot of, trauma and fear, that was normal to experience that and then go to school afterwards.
But what she said on direct was you were able to go to school and function just fine.
Yes.
This was normal.
Yes.
No one had ever been taken to the hospital before in any sort of incident between you and your mom, correct?
Correct.
No one had ever been seriously injured in any incident before where they required medical attention, correct?
Correct.
And certainly nobody ever died before.
Still not back, y'all.
Now, today you said when you returned from school, Jeremy Townsend was still at your residence.
He was fixing the front door.
And do you remember previously during your deposition saying that after this happened and you went to school, you never saw Jay back at the house again? Do you remember saying that?
Yes, after that.
Hello,
day,
everybody.
yes.
We're still waiting on how to get started back.
After
Just
you went to
listening
school,
to the daughter's testimony.
you never saw Jeremy back at the house again. Today you're saying when you
From
got back
yesterday.
to school, he was there.
Yes, he was. He was
What
there.
I'm asking is, do you remember saying
I
something?
do remember saying that.
Okay. You described Jeremy as coming over and spending the night at the house, not every day, but quite a few days out of the week. That was normal, correct?
Correct.
When you got back from school that day, you did not notice any changes to the property, correct?
Correct.
You did have a huge hole in the backyard, as you described, which was going to be a duck pond, correct?
Correct.
Had that been filled in?
I don't know. No, it wasn't.
Okay. And that was the area that was eventually turned into the cement slab, correct?
Uh-huh.
Is that a yes?
Yes,
All right.
sorry.
That's okay. Since you sat there, shot your father in the back of the head, and were threatened by Mr. Townsend with your life, you have only once been taken to any sort of counselor or any sort of therapy, correct?
That is correct.
And that was actually sometime this year, close in time to your death.
Actually, no, that's not correct. I think I went when I was little. Me and my brother went. I think it was at a church. I'm not entirely sure if it's classified as counseling or therapy, but it was pretty much.
Let me ask this. Did your mom ever take you to see a counselor to deal with any of the trauma that you, first of all, witnessed right in front of you, but also participated in by shooting your father?
I mean, yes, I did go to counseling.
When?
I think it was probably in this past year, maybe a little bit longer ago, but yeah.
And that was one time?
Yes.
Okay. And that was this year?
I don't know if it was this year. I think it was the year before.
Okay.
It was, yeah.
When you shot your dad, that was back in an unknown year, sometime between April and August, correct?
Mm-hmm. Yes, correct.
Yes. Okay. And there was probably at least 5 years, if not more, because this case has been pending for 4 years, between any counseling that your mom brought you to, correct?
Yes, correct. And the counseling that I went to, it was literally like only one time. Like it was literally only for an evaluation, like
Very
nothing
little.
more. Yeah.
Okay. We previously spoke about the different times you've talked about this event, either with law enforcement, the Child Advocacy Center, or during the deposition that I asked you questions. I'm going to ask you some things about how your story's changed over that period of time, okay? And when your mom was arrested, you spoke with Detective Tammy Dale at your home, correct?
Correct.
And at that time, you said the last time you saw your dad, he worked at an airport, correct?
I think so. Maybe, yeah.
And you said, and this was in 2020, the last time you saw him was a few years ago?
Yeah.
Right.
But 2020 was also 4 years ago, which was a lot closer to the last time I had seen him.
Right. So your memory would be better then.
Yeah.
Okay. And at that time, she asked you, do you know what happened to him? And you said, I have no clue, correct?
I have no clue.
Correct.
All right. You also said, I don't know, he just left, correct?
Correct.
And the detective asked you if you ever asked your mom where he was. Do you remember that?
I guess.
And your mom told you she doesn't know because he doesn't talk to us, correct?
Correct.
And you also went to the Child Advocacy Center to be interviewed that same year. That would have been December of 2020, correct?
Correct.
And during that time, when you were interviewed, you stated the last time you remembered seeing him was when he was arrested in 2014, correct?
Correct.
And they asked if he came back to the house after that. You said, I don't know, correct?
Correct.
Right. And those pictures that you looked at, when were they?
The ones that Mr. Wiggs showed me?
Yeah.
You
refer to him by his first name?
I do sometimes, yeah, on
Okay.
accident. It's not on purpose. It's not to be like disrespectful or anything.
Okay. You clearly talked to him a few times.
I talked to him a few years ago, and I did tell him the full story. It was kind of just me saying a little bit about my side, and that's when I got my attorney, Miss Kelly.
I'm sorry, I sidetracked you there. Do you remember when those photos that he showed you were?
I don't remember necessarily when they were.
Okay.
Like the time period or anything.
Okay.
It was.
Did you see how they happened?
I believe those ones. I don't know exactly what event that one was from.
Okay.
Because, like I said, there was a lot of events like that, and they all, not all, but most of them ended in like kind of the same, like physically like
harm. You know what I mean? So I don't know which one that one belonged to.
And we're talking about physical harm. We're talking about bruises on the arm, correct?
Bruising, blood, yeah.
But the blood that you said you saw in the pictures was your dad's blood.
I think so. I don't know.
Okay. And when at the CAC interview, when they asked you, you had already said that the last time you remembered seeing him when he was arrested in 2014, and then asked if he ever came back to the house after that, you said, I don't know, correct?
Correct.
And then specifically you were asked, so you did not see anything that happened that would have made you have an idea of what happened to him, and you said no, correct?
Correct.
One moment. Nothing further, Judge.
All right, thank you, sir. Mr. Wiggs?
Yeah, just briefly, Judge.
Yes, sir.
United Police Court.
Yes, sir.
Judge Isabel, there's been a discussion about the guns and multiple guns at the house.
Correct, yeah.
Tell us about the atmosphere and the amount of guns that y'all had in the household.
So we talked about my mom's guns.
Go slow, but the jury can understand you, okay?
We also had in the living room, we had this really big mirror, like huge. And it was on the wall. It was like latched onto the wall by like these, so like it could like flip up like this. And so behind it was, I want to say like a hole, but it wasn't really a hole. It was kind of like this really deep like divot in the wall. And there was like a rack. And then he stored his guns there. So you could like the wall and then the mirror lifted up and there was like guns on the wall.
They were his
Okay.
his fishing poles.
So there were numerous guns within the residence. Is that fair to say?
Mm-hmm. Yes, for
Okay.
sure.
The question is, as the juries may wonder, how did you learn to fire a handgun?
My dad, he was obviously very interested in guns. So he did hunting a lot. We had 5 acres of land, so we had a lot of space to shoot the guns. And so he always taught us like gun safety or whatever and would take us outside to shoot the guns.
Sorry, y'all.
Was that
We're
a
back.
routine thing?
Okay, so that was most of the daughter's testimony.
All right.
As you
thank
can tell.
Thank you again.
Highly
I see that all of the members of the jury have returned, and thank you again for your time and attention today. Both the state and the defendant have now rested their case. The attorneys now will present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. State, you may proceed. Yes, sir.
Okay.
On November 7th, 2015, Michael Shaver went with his family to meet up with some friends at a tractor show. This is the last time Michael Shaver is ever seen by anyone other than the woman that murdered him, Laurie Shaver. You've heard a lot of testimony and evidence over this last week discussing Facebook, phone records, bank records, all sorts of evidence for your consideration. But it's important to remember that why we are here is because Michael Shaver was shot in the back of his head without any sort of legal excuse or justification and buried in his backyard. Michael Shaver, between November 7th and November 10th, shot in the back of the head and dumped, wrapped in a tarp.
You can almost see it.
That's what we've been here this week. That is what the evidence has shown you. And it has shown that the person who did that is Laurie Shaver.
Did it though?
The elements of second-degree murder are fairly simple, and it is these elements that the state must prove beyond a reasonable doubt. You can have doubt in this case, you can have doubt in any criminal case. The state's burden is to prove this case beyond a reasonable doubt, these three elements, and that is what we must prove to you. First, Michael Shaver is dead. 2, the death was caused by the criminal act of Laurie Shaver. 3, there was an unlawful killing of Michael Shaver by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. That third element is further defined by the court as an action that is reasonably likely to kill. A gun to the back of the head is obviously something reasonably likely to kill. Done with ill will, hatred, and spite. I can think of no other reason in a person's mind when they're shooting someone in the back of the head other than those three things. And 3, indicates an indifference to human life. The evidence that you have heard throughout this trial clearly show that that first element and the third element are really just not in dispute. What we are going to spend the majority of time talking about this afternoon is whether or not the death was caused by a criminal act of Laurie Shaver. And the evidence that you have heard shows that the state has met its burden for that element. As you heard the judge give you the instructions already, there is something that is called a lesser included offense to this second-degree murder, and that is manslaughter. The difference between
they have to go first, Brandy.
And the second-degree murder is it does not have that third element about an act done imminently dangerous, demonstrating a depraved mind without regard for human life. So if you feel that the state has proven that Laurie Shaver is in fact the one that shot, but didn't have that state of mind at the time she shot him in the back of the head, manslaughter would be the offense that the state has proven in this case. As we go through the evidence, I want to remind you of something that Mr. Wiggs said in his opening statement.
Oh, yeah.
What said in opening statement is not evidence. If you've heard some things in opening statement that was going to be presented to you when it came out differently, what you heard from that stand, what you got from the evidence sitting on that table over there, that's what you are to consider, not what the attorneys talked about in opening. But what Mr. Wiggs said is you aren't going to hear just find her guilty because common sense. But the instructions that the judge gives you, and the judge will give you a full written packet of all of these instructions. So you don't have to worry about writing down the various instructions as we're talking about them. The judge will give that to you. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. So common sense is absolutely part of the instructions the judge is giving you and absolutely part of what you should use when you are weighing the credibility of the evidence, the witnesses that have testified from both sides. The state has proven this case through the totality of the circumstances of this entire investigation. It is important to remember that Laurie Shaver is the only one that stood any sort of benefit to gain by the death of her husband. She had the means, the motive, and the opportunity to do this. And when I talk about the means, the gun that was recovered from Robert Seha that he purchased from Laurie Shaver prior to the body being discovered is the same caliber and class as the projectile found in Michael Shaver's skull. And remember the testimony of Megan Cleek, the firearms investigator from the Florida Department of Law Enforcement that did that analysis. Once again, I'm going to trust that you remember what she said as opposed to what the attorneys say about it. But what she said was the projectile that was found in the skull was the same caliber, meaning that it was the right size ammunition to be fired from that pink and black 38 Special. She also said that it had all of the class characteristics from that type of firearm. The only thing she said it was missing in order to make a full comparison and the thing that she would need in order to say, in fact, it was that gun, is it didn't have enough evidence of the individual characteristics from that firearm. You saw the condition of that projectile, how smushed it got once it struck the inside of the skull. You also heard her say when she did the test fires with that weapon in the most pristine situation she possibly could, firing into that water tank, the individual characteristics that were left on those pristine projectiles were very hard to see. So between the time frame, the degradation, and the fact that this gun does not leave strong individual characteristics, it's completely understandable why 4 years later, when it's examined, that they just can't find it. But all of the evidence that is in that projectile is consistent with being fired from that weapon. Motive. We actually heard evidence of a couple different motives, because it is clear that she wanted to be with Jeremy House. We are going to talk much more at length about
She wanted to be with
the
somebody.
Facebook activity, the flowers, the messages sent to Vanessa Townsend, but she wanted out and she wanted to be with her new boyfriend. But you also heard her say, when Frank Merritt came to check on the whereabouts of Michael Shaver, when she claimed that he, in the middle of the night, got into a black SUV, abandoned all of his property, his vehicle, his clothes, anything that had any sort of value, and hauled up to Georgia, that she and Michael had had a fight because she found the fact that his previous girlfriend, Kendall Davidowski's phone number was still in his phone. Motive is not something the state has to prove beyond a reasonable doubt. It is not one of those elements. But we have presented you evidence of what her motives would be in this case. And finally, opportunity. That means, was this person in a position to commit this crime? I believe Detective Dale summarized it best when she said, the body was found buried in the backyard. It's not like he got carjacked and shot on iDrop.
It's not the Declaration of Independence. We can't all sign it.
Point in the direction of Laurie Shaver. So now let's talk and focus on the totality of circumstances. That goes to all of that on that table, all the things that have been presented to you, showing how she hijacked his Facebook, showing how she impersonated him to his friends and family members through texts, Facebook messages, took all the efforts she possibly could to avoid anyone from starting to look. Now, you have heard various friends and family members talk about how over the course of 2.5, 3 years, they went looking for Michael. It wasn't a scenario where he talked to anybody on a daily basis, weekly basis. There were times that he would go and not visit and things of that. But he always responded. When people would reach out to him, he would respond. He wouldn't leave those messages unanswered. And when they did get any response after November 2015, every single person that talked to you about that said it was obviously different. It was not the way he would respond. Finally, when taking all of the circumstances, all of the evidence, and putting it all together, that's where the state is asking you to rely on your common sense. Because you can take any one piece of this puzzle and you can look at that and you can say, well, I mean, that's not an eyewitness that saw what happened. That's not a piece of DNA. Maybe that's not something that proves in and of itself that Laurie Shaver committed this murder. And we're not saying any one piece of evidence over there
Mr.
does
Prosecutor,
that.
man.
We never have. We got up here, Mr. Buxman in opening was straightforward with what you were going to see. He told you there's not going to be a witness that's going to say Laurie Shaver did this, that I saw her do this. He told you what the forensic evidence was going to be. We put that up there so you could see it. But we also gave you the explanation of why, after someone is buried in the ground over multiple years and their body decomposes, the effects that that has on any sort of trace DNA evidence, any sort of trace fingerprint evidence. But we were upfront about that with you. We told you that's how it was going to be. But we are asking you to follow that judge's instruction and use your common sense in looking at all of this together. Because when you look at it all together, the conclusion is crystal clear. Let's start going through
Oh, Lordy.
the timeline.
Yes, let's do the timeline.
November 7th, 2015 is the last time Michael Shaver is seen by any friends, family members, co-workers, anyone other than Laurie Shaver. November 9th, 2015, after Frank Merritt had reached out first to Michael the day before, text about a gun cleaning kit, did not get any response. He followed up with that. And Michael says, well, I put air quotes, Michael says to Frank Merritt, have to quit my job to work on my marriage. Submit to you, someone going and becoming unemployed and not earning any money probably isn't the best way to go about working on and contributing to the marriage. But that's the first type of response that people thought was odd. November 10th, 2015 was the first time ever that Michael Shaver did not show to work and did not call to say he was not coming in. This continues to November 12th, 2015, and ultimately leads to his termination. November 11th, from those Facebook records, the Laurie Shaver Facebook records, Laurie Shaver posts a public posting to the entire world wishing various veterans a happy Veterans Day. Most importantly, in that list of people that she thanks is her brave, loving man. Michael Shaver was never in the military. Her husband was never in the military. Jeremy Townsend was. One day after Michael Shaver has no contact with his place of employment, she is publicly posting for all the world to see, talking about her brave, loving man, veteran, Jeremy Townsend. November 12th, 2015, John Borglum receives a text message from Mike's phone that's saying he has issues at home and was in Georgia, so go ahead and fire him. Now remember, there's absolutely no evidence whatsoever that he was ever in Georgia. None of his bank records show any activity up there. His family members in Georgia, they haven't seen him. And Mike just leaves his job vehicle, everything behind. November 13th.
I wish I could see her face.
Because this is all extremely unusual, Frank Merritt goes to the Shaver residence to check in on Mike and is told he went to Georgia. Now, when Laurie testified yesterday, she tried to say, oh no, he must have misunderstood. I never said Georgia, definitely. That's just a misunderstanding. But remember, he's not the only one to say he got a message about Mike going to Georgia. Because John Borglum the day before, in that text message sent from Michael Shaver's phone, and whoever had that said he went to Georgia. Laurie's version of what happened in November. She kicks Michael Shaver out after the November 7th, 2015 tractor show, and he returns to live at the airplane hangar. So now the story has changed from he went in a black SUV, went out in the middle of the night to go up to Georgia, to he is living at the airplane hangar.
Just got to write this down.
If that is true, you need to believe all of the following.
Let's go.
1, despite the fact that the last time he was out of the home and living at the hangar, he was still working at Disney, he somehow decides to abandon his source of income. He's kicked out of the home. He's obviously going to need a place to stay. He's going to have to pay for bills, pay for food. But that's the period of time he decides, I'm not coming to work anymore. You also have to believe that he decided to just abandon his vehicle, his source of transportation, his source of actually maybe finding another job, being able to go various places. Also have to believe that he leaves behind anything he has that has any sort of value. Guns, tools at Disney, anything. Now he's unemployed, homeless, gonna need to fend for himself, but he just leaves all of that behind.
Yep.
And then you heard also today from Katina, they left all of his belongings, toiletries, and clothing behind at the house. So you basically have to believe, if you believe Laurie Shaver's version as she told you yesterday, all of those things would have to be true. So what's the evidence that that's not true? Well, the person that she indicated took him to Georgia came in and said, nope, I didn't do that. All of his friends, all of his family members that live in Georgia, no, we never saw him. All of the bank activity is here in Claremont by the home that he lived in with Laurie. The bank activity is not even out by the hangars. There's one entry that deals with Disney, but every ATM withdrawal, Groveland, Claremont, 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 Claremont. He was not in Georgia. No outgoing phone activity after November 7th, 2015. None. And then, if he is kicked out of the home, fending for himself,
yep,
there is absolutely no reason for him to just also cut off contact with friends, family, and coworkers. But that's exactly what happened.
She's writing this whole timeline down.
Michael Shaver was dead before November 10th, 2015, because he fell off the face of the earth. There is no bank, phone, any activity that is associated in this day and age with what people need to do in order to survive, because he's dead. These are the various records that you heard about, that you saw. Everything is in those folders so you can review it.
Did she tag Jeremy Townsend in this Veterans
about
Day
the gang
post?
activity
'Cause
from
that
the
would look
time he
weird.
was killed before November 10th, 2015, and then December 30th, when that account just becomes overdrawn and is never used again. November 20th, online purchase to wish.com. November 24th, online purchase to wish.com. 12/14, ATM deposit. What was that deposit? That was the check that was mailed to his home from Mariner Finance. And this is important because this check was sent to the place where she lives. And it was deposited in Claremont. Michael Shaver does not have a vehicle. I think Laurie was trying to explain to you how, well, he would just come by, no one would see him, no one would know anything, but he would just check his mail because it was out by the street. That makes no sense. He has no car, he has no money, no phone, but he's coming by to check his mail and get this check? No. That's just not credible. That's not believable. He then, after he makes this deposit, ATM withdrawal Bailey, 12/14, ATM withdrawal Claremont, 12/18, ATM withdrawal Claremont, 12/21, ATM withdrawal Groveland, 12/21, ATM withdrawal Claremont, 12/23, purchase from Walmart.com. Who was the purchaser there? She was. You saw the receipts. You saw the Walmart.com records. You saw it went to that address.
I am an IT specialist.
ATM withdrawal Claremont. And at that point, on the 30th, the account becomes overdrawn, never used again. Mike is walking around, having no contact with friends, family members between November and May. We're just getting his money. Bank account is cashed out, absolutely no activity. There's no reason, if he's out trying to forage for himself now, kicked out of the home, living at the hangar, and doesn't maintain his bank records, bank accounts. But it is depleted by Laurie.
That's right.
All that activity.
She's rewriting the defense closing arguments right now.
Phones. This is.
Look at her. She's like, here you go.
Michael Shaver's phone records. This is the number that he had. This is the number that you heard his friend Brendan Burns actually pull out his phone, say, I still have his phone number programmed in my phone. This is what it is. This is that 5121 number. And once again, all of these records are in those folders. You can look at them yourself. And obviously, you can't read all the detail here. But the point of putting this up was to show you that this one in blue is that phone call he made out on the 7th to Epcot. That was the Detective Dale told you. That was the last outgoing call from this phone number. In the research, that phone number was associated with a landline in Epcot, where he worked. Before that, this is all the activity. It almost daily calls out, calls in, calls out, calls in. This first area, all those yellow highlighted, are calls back and forth between him and Laurie Shaver. After November 7th, nothing. Not a single call out from his phone. He doesn't have a car. He doesn't have a job. He's not at the hangar. None of his friends there have seen him. He's got to communicate with somebody if he's alive in order to keep going. But there's no activity because he's not alive, because Laurie Shaver killed him before November 10th, 2015. The only phone record after November 7th, 2015 is the collections call from Mariner, because the check that was mailed
to her was deposited in Claremont, and they were coming to collect. And when they called, remember what Tara Mitchell told you. A female answered the phone and said, oh, this is a new number. But we know that's not true because you have all the phone records showing the history of that phone number, and how it changed. And we'll come back to that. So let's keep going with the timeline. In December of 2015, Mike's mother becomes ill. His family is seeking him out to let him know that she is very sick. I believe the testimony from Stacy Turner was it looked like she might not make it. Couldn't get in touch with him. All the texts, phone, Facebook, whatever they tried, couldn't find him. He's dead. But they did get in touch with Laurie. And she said, I'll get word to him. No phone calls to him. She knew she didn't have to call him. She knew he was dead. Because she killed him. March 24th, 2016, Laurie Shaver posts about the fire pit that she made. This is the area that multiple witnesses told you was a hole, was going to be a duck pond. But now in March 2014, that area is filled in. And wouldn't you know it, Michael Shaver's right there. He's in that. Isabel described it as a really big hole.
Wow.
April 6, 2016. This is where we start showing you how we know Laurie Shaver had Michael Shaver's phone and access to the ability to text people, had access to his Facebook, had access to everything she needed to do to keep people from starting to look for him, to keep people from investigating the fact that she killed her husband and buried him in the backyard. That phone number, 352-431-5121, on April 6, 2016, this would be approximately 4.5 months since Laurie said, I kicked him out. But that phone number is changed. Saw those records, Vice brought in, changed phone number to 352-801-0941. And then 10 days later, that phone number is changed again to 352-431-8444. As a reminder, the phone numbers that were important in this case started off with the 431-5121 number, the one we just talked about, how it got changed 2 times within the period of 15 days.
2 times?
We know that was Mike's number. The records are connected with Laurie Shaver as the subscriber. We also heard Brendan Burns testify. That was the phone number I've had programmed in my phone since the last time I ever talked to my friend. Laurie Shaver's phone is 352-431-0419. We have our phone records. We have the screenshot from the time frame that Vanessa Townsend had reached out to Laurie to discuss the messages that she had received. We also had the screenshots from the text messages between Jeremy Townsend and Laurie Shaver, and lo and behold, the phone number associated with Laurie Shaver in those text messages is this 431-0419 number. Now, Laurie testified yesterday and doesn't seem to remember any phone numbers that she's ever had, but the records show it, the screenshots show it, the text messages show that was her number at the time. And then there's a folder And as opposed to the call details and said, this is the call out, this is the call in, that third folder we talked about with Tanner Gale shows the history of that phone number and device. And it shows how on April 6th, the phone number was changed from Mike's original number to the 0941 number. Why is that important? Well, 2 days later, after changing Michael Shaver's phone number to a new number, she reaches out through Facebook to contact Vanessa Townsend and says, here is my number, call me. Vanessa Townsend goes to call that number at one point. Remember what she said. I called this person and asked me to call them. They wouldn't answer, but they would text. Or you can't answer the phone and pretend she's Mike anymore. She has to text. Well, that number only stays in place for 10 days. She got it. She did what she needed with it. She got rid of that number, got a new number.
I don't know, LaDonna, but I was thinking about Travis.
432-431-8441.
She's probably wanted to get rid of him for a long time, but can't.
In July, she's
Because
filing
of
a
this.
court document with her address and her phone number, 352-431-8444. This shows that she had the original Mike Shaver phone and phone number this entire time. This shows the constant link between when she killed him in November, had his device, had the number changed to contact Vanessa, and then had it changed again to the number that she represented as hers. April 6, 2016. Laurie Shaver's bank records reflect the purchase of flowers sent to Vanessa Townsend. April 9th, Michael Shaver's Facebook sends Vanessa Townsend, that's when she asked him to contact her at the 0941, the burner phone. And April 11th, 2016, Michael Shaver Facebook sends a message informing Vanessa she's about to get a special delivery. And she does. The flowers purchased by Laurie Shaver, as shown in her bank records. She receives the flowers, exposing the affair. But that's not all she ultimately gets from Laurie via the Mike Shaver's Facebook. She gets pictures after picture after picture, text message, screenshot after screenshot after screenshot. I ask you once again to use your common sense. This is Mike Shaver reaching out to inform some other person that their husband was being involved in an affair. Wouldn't this be enough? Wouldn't this picture do it? Why all that? Why? This was Mike.
Well, you got it all buttoned up in a notebook.
This isn't sent by a husband trying to inform some other person's wife that their partners were having an affair. This is sent by Laurie Shaver because she wanted to drive a wedge because Vanessa would not leave. Jeremy would not leave Vanessa, and that is what she wanted.
A vindictive witch.
September 12th through the 14th of 2016, the cement slab is poured over Michael Shaver's home. That is shown to you by the cement mixer rental being for that period. And then it is also confirmed in Facebook posts a couple days later at Isabel's birthday party on September 19th, 2016. Michael Shaver's body has been in the ground for some time now, but there is no argument that can be made that after that cement slab is put down, that his body was not there. On September 20th, 2016, after we know for a fact Michael Shaver has to be dead, there's a Facebook message to his niece. And this is the one that reached out to him and said, "Hey, Mike, how you doing?" He says, "I don't know you. I don't know who you are." She didn't have a Shaver last name. Laurie didn't recognize her. She's like, "I'm your niece." She talked about how she had discussions with him. Mike knew she was getting married, knew that she was going to be changing her name. And Michael Shaver's Facebook reply is, "I don't have a family anymore. I have no clue who you are. Now stop messaging." September 20th, 2016, after we know Mike has to be underneath that cement slab, he also sends a Facebook message to Vanessa Townsend. "Hi, Vanessa, how are you? Moving good looks good on you. Hope you and your son are doing well."
Hello, if you're new, come on into the chat.
Talks at length.
Prosecution
various
closing.
Witnesses about maybe Jeremy Townsend had this phone. Maybe he was just driving up to the house for months and months and months after this relationship was ending to try to get into the router to have the IP address match Laurie Shaver's IP address, and that he was the one that was doing all this. No reason for Jeremy Townsend to send this message to Vanessa, because it's not true. It's just as unreasonable as the idea of some sort of hacker getting into Michael Shaver's Facebook account to post a stupid meme. It makes no sense because it's not true. Laurie Shaver had access to it. Laurie Shaver had access to the devices. Laurie Shaver had the means and desire to make people not want to come look because she killed them. March 8th, 2017, after we know Michael has been dead for a very long time now, and known that he is underneath that cement slab, the Facebook profile picture has changed to a photo taken by Brendan Burns in 2014 that he says probably texted to him back then. So who would have access to that to put it up on his Facebook profile to try to act like Michael Shaver was still alive? Someone that has his phone. Who had his phone? She did. And those phone records prove it. January 1st, 2018, that is when Michael Shaver's Facebook profile is changed to the random bar picture that Detective Strickland did research into using the reverse Google image to show that had something to do with some sort of Bloody Mary company out in the Midwest, and Michael Shaver's nowhere in that photo. March 14th, 2017 is when the cover photo changed. And that was that odd looking revolver that I think had 700 bullets in it that Detective Strickland made a joke about that's not a real gun. Well, it's important to remember that the post of that cover photo and almost the 2-year anniversary of Michael Shaver's death, to put a gun after he was shot in the back of the head, shows that Laurie Shaver's Facebook account and Michael Shaver's Facebook account utilized that same IP address meaning that they have to be in the same location. The devices that are accessing these accounts, it's the same, whether it's Starbucks, whether it's Laurie Shaver's home, it doesn't matter. It is in the same IP, the same location. Both of those accounts are accessed within 1 minute of each other. Has to be someone that has control of both accounts. There's no other reasonable explanation for that. The Facebook IP logs. We spent a lot of time talking about these. This is a summary that Detective Strickland described. And going through this, you can see how there is activity throughout a 2-year period where both of these Facebook accounts are utilizing the same IP address. Once again, we've been upfront with you since the moment we started talking about this case that we are not going to be able to tell you the physical address of that IP address. But it doesn't matter. Wherever it is, you have to be in the same location to access the IP. And when both accounts are constantly utilizing the same IP address, that shows that that is the same location, the same person accessing that. If you were to go through this and go through all 70 some odd pages, you would see there are 13 separate IP addresses that both accounts utilize over the course of that period. And you heard some testimony about how providers like CenturyLink will sometimes roll that, change your personal IP address to your home every month, maybe every 2 months. What you will see is that both devices utilize a particular IP address for about a month, maybe 45 days. And then it changes to another IP address. And then both of those devices share that IP address for that entire time. There's countless instances in there where you might see the Michael Shaver Facebook address, Facebook account access an IP address, and then the next day, Laurie Shaver's Facebook account accesses that same IP address, and it goes back and forth, back and forth. That is a folder full of those examples. But if you were to go through there, you would not only would you find 13 separate IP addresses that they use, you will see activity on Michael Shaver's Facebook account that continues after the cement slab is laid over his body in September of 2016. You will see there are 31 separate days in that 2-year period where they both access the same IP address on the same day. You will see that there are 12 days in there where there is activity between the Laurie Shaver account and the Michael Shaver account within 2 hours of each other. There is one instance, which we talked about with the gun photo on the almost 2-year anniversary of his murder, that is 1 minute and 7 seconds apart. There's another instance on July 15th, 2016, where the activity is within 6 minutes of each other. This is the same person looking at these, using these. This is one example of the type of thing you'll see in this chart. This is from April 2016 on this side, where you can see there are some days, once again, look through this chart, feel free to do so, where on certain days it's actually going back and forth. Both are being accessed throughout the day. November of 2017, towards the end of that chart, this is where you can see the actual data that I've been talking about, showing the 1 minute. And not only have we given you this summary to try to help you with going through all this information, you have the originals right there, and you can go through it yourself. And you can check it and look at all of that. Justifiable and excusable homicide. Justifiable homicide is going to be the self-defense, defense of others that we will talk about shortly. The excusable homicide instruction is given to you. You heard it, read it. I would submit to you that none of these things apply when the killing is committed by accident and misfortune in doing a lawful act. There's absolutely no evidence of any of that. Accident and misfortune and the heat of passion. Heat of passion is coming in and being so overwhelmed by something that a reasonable person would not act any different. Not to be blunt, but you come in and you see your child being attacked, molested, whatever it may be, and you are overcome with this emotion, and no reasonable person would not. That actually doesn't excuse the killing. It just means that you don't have the necessary intent to commit second-degree murder or first-degree murder. It would be a manslaughter. And when the killing is committed by accident and misfortune resulting from sudden combat, if a dangerous weapon is not used. Well, we know someone was shot in the back of the head. That doesn't apply. Excusable homicide has to be given in every homicide, but none of those apply. Before we talk about the defense of others, I want to go through.
I can't believe this is even in there.
The tools the judge has given you to aid in your common sense and weighing the credibility and weighing the evidence in this case. Did the witness seem to have an opportunity to see and know the things about which the witness testified? Did they have an accurate memory? Were they straightforward in answering the attorney's questions? I'd submit to you that as you go through this, all of these questions that you ask yourself are pretty common sense, that these are the types of things you should use to try to assess a witness's credibility. Defense of others. The testimony that has been presented to you by the defense is that Isabel shot her dad in the back of the head. And then, just so happened, at that exact same moment, that Jeremy Townsend showed up, grabbed the gun, shot him again, and then threatened to kill Isabel and Aiden if anybody said something. They also say, both Laurie Shaver and Isabel Shaver, that Laurie took her kids to school, that Aiden had no idea anything that had been going on. Gunshot in the back porch, huge fight. Isabel said Jeremy threatened him and threatened to kill him. But Laurie said Aiden had no idea what was going on. I just needed to get them to school. And it was a short trip over to school. All I wanted to do is get them to school and then get back home. That's what she said. And she says when she got back, Laurie said when Jeremy got back, Jeremy was gone and there was no change in the property. She talked about how close this school was to her. All she did was take the kids to school and drive right back. Yet somehow, Jeremy was able to clean up the entire scene, remove the body, and I guess come back some other day undetected and bury it, and no one noticed disturbed ground anywhere? These rules of weighing the evidence and assessing credibility, the judge has told you specifically, since the defendant has testified, you are to use those same questions, those same tools in order to assess her credibility. And when you look at this story, it makes no sense because it's just not true. Now, ultimately, proving this case is the state's burden. We have to prove she was the one that killed him. They don't have to prove to you it was self-defense or defense of others. We have to prove to you it wasn't. And we have, because all of the evidence shows that Michael Shaver was not alive in November, was not alive when this happened, because he's been dead since November of 2015. Somehow, Isabel, who shot her dad in the back of the head and went to school, when she was 7 years old, has absolutely no memory of what year or what month this happened in. What grade were you in? I don't remember. I don't know. What month was it? I don't know. I think spring or summer. What year? No clue. And she said she went to school that day and carried on like nothing happened. It's the state's burden to prove this case. But if you are fed a story that is just patently false and fails all common sense scrutiny, ask yourself why. Why did they come up here and try to feed that to you? Because
Why?
they cover up the reality that Laurie Shaver killed her husband back in November. And they're trying to give you a story, and they're trying to fit it in to the timeline that has been established over the course of this case. Because also remember, in the very beginning, when Laurie Shaver was arrested, you heard testimony that her attorney said, you need to look into two people. You really need to look at these people. Jeremy Townsend and James Ballou. Okay? Well, if this is the story back when Laurie was arrested in 2020, why bring James Ballou into this? That's not part of their tale. That has nothing to do with it. But
How y'all doing? My name's
story.
Jimmy.
And then as the evidence progressed, that in 2022, Isabel shows up as this potential witness. And despite what Mr. Wiggs told you in the very beginning, that we were offering the truth to the state, and they shut the door on us. They said, we don't want to hear it. They want to talk to her. But you heard from her attorney. What does she tell you? Every time after she became the attorney of this witness, I would see her and, hey, anytime your client wants to come and talk, I'm here. Does that sound like the state shutting the door on his theory? Or is that just the convenient tale they want to tell? And we went through Laurie's Facebook.
Yep.
Because it has been 9 years since this happened. The person, Isabel, that you saw testify is a much different person than the little girl she was when she says she shot her dad.
Yeah, she's a snotty-nosed teenager.
Of Isabel from back when she says she shot her dad in the back of the head, went to school, carried on like nothing happened. And then this great, wonderful mother that Isabel described, who is saying that these two were involved in this horribly traumatic incident in 2016. She go get her therapy, counseling.
That was a jab.
Maybe she needs to talk to somebody.
Great, wonderful mother.
Dad in the back of her head and was threatened by her mom's boyfriend. No, one time this year, I saw a counselor and talked to somebody.
Yep.
We're fine.
Oh, look at Laurie writing away.
The story makes no sense because it isn't true. But the evidence completely disputes their tale. Dr. Coberly told you that this is a single gunshot to the back of the head. Isabel told you, I shot my dad in the back of the head. He sat there, he started shaking, he started seizing. And then they said, Jeremy came up and shot again. There's no damage other than post-mortem rib breakings from after the body was buried in the backyard for years. Also makes absolutely no sense that if someone was coming in to finish someone off, give them a coup de grace shot with a gun, if they want to put another shot in the head, that they would shoot him in some soft, fleshy area so as to not hit any bones. But this injury, Dr. Coberly looked at underneath a microscope, and she says there is no doubt that is one gunshot. She says even when you have a scenario where somebody takes the gun, pulls the trigger, and immediately pulls the trigger again in that exact same spot, there's going to be derivations, there's going to be enough movement that they can see kind of a figure eight type of movement, figure eight type of configuration, to show that there was more than one shot. There's also only one projectile in the skull. Probably didn't even need that explanation of the microscopic examination because there's only one bullet there. But scientifically, we know Michael was shot one time.
I guess Kirsten passed out. She was sick. She's
Going
probably on
back
cold
into
medicine.
those tests, going to those questions. Does the witness have some interest in how this case should be decided? Laurie Shaver, Travis Miller, and Isabel Shaver are the only witnesses in this case that had an interest in how this case should be decided. Isabel Shaver said, I love my mom. I don't want to see anything bad happen to her. I want to keep my family together. And I understand that. But that doesn't mean what she told you is true. Was the witness honest and straightforward in answering the attorney's questions? I want you to think about Travis Filmer and target his discussion of this commitment ceremony on December 31st, 2016. No, nobody thought this was a wedding. We didn't represent this as a wedding. Was she wearing a wedding dress? Yeah. Was she walked down the aisle by your grandfather? Yes. Was there someone there conducting the entire ceremony? Yes. Her testimony from other people, well, they absolutely told us it was a wedding. You also saw the Facebook post that Laurie put up announcing their engagement, saying that I'm going to be a filmer. Now,
I'm going to be an
that
adult.
in and of itself, the big earth-shattering aha moment, no. But if you can't trust them on the little things, how on earth are you going to trust them on the big things? Laurie Shaver, as far as honest and straightforward answering the attorney's questions, you got to see the way she testified, you got to see her temperament, you got to see all of that. But also, once again, the little things. Was this your phone number? I don't know.
I don't recall.
That's the types of tools you can use in assessing their credibility. Does the witness testimony agree with other testimony and other evidence in this case? Everything except for Laurie Shaver and Isabel Shaver show you and tell you Michael Shaver has been dead since November of 2015. And if he's dead in November of 2015, he definitely isn't showing up unannounced 6 months later for the first time on their porch. I guess wearing his nothing but his shorts, socks, and underwear, because that's how the body was found in the ground. Is that somebody that just shows up unannounced and starts a fight? Or is that somebody that was at home, sleeping in that bed when you shot in the back of the head? Even Laurie Shaver and Isabel Shaver's testimony conflicts with each other. Isabel Shaver said her father had not been living at home since 2014, since that DV arrest in 2014. Laurie testified actually consistent as far as that living arrangement as other testament witnesses that you've heard from, where she says, no, he was living there. But Isabel, now Dad hadn't been there since September of 2014. Also, Isabel says, Jeremy said he was going to kill me and my brother. Laurie says, Jeremy said
if you tell anyone, DCF will come and take you away from the family. Their stories don't even match. Because it's fabricated. It's made up. It's flat out not true. And it's inconsistent with everything else that you have heard. The only witness that Laurie got up there and say wasn't fabricating something was her daughter. Scott Amatuccio. He's lying that he's actually friends with Mike. They weren't really friends. Heard from Katina, like, oh no, they were great friends. Frank Merritt. He's lying. I never told him Mike went to Georgia. Jeremy Townsend. All sorts of lies. He would spend the night. He would be that right there is should be a huge red flag to you. If Jeremy Townsend was out spending the night at someone else's home 3-4 times a week, the way Laurie and Isabel tried to tell you, Vanessa would know. She wouldn't need someone to send her flowers with a card to expose an affair. Vanessa had no clue that anything was going on because Jeremy would go over in the middle of the day the way he told you. Robert Mercado is not being truthful when he said that Laurie got upset one day and was threatening people with a gun. Austin Filmer is not telling the truth when he said that he went over there and helped Travis lay down this concrete slab. Vanessa Townsend obviously is lying because she said there was never any time that Jeremy was missing at night. He always came home. He was always living at home. John Borglum apparently is lying about the reason why he terminated Mike Shaver, because Laurie got up there and said no, he was fired because of a sexual harassment claim.
She sent him to the,
I guess,
Jeremy's
Disney's
wife.
lying when they sent over all of Mike Shaver's work records and just hid any sort of sexual harassment claim against him. But today you actually heard the truth about that sexual harassment claim, and nothing to do with Michael. She called it in.
Woo!
Against Kendall Davidowski, the woman that Mike Shaver was dating when they were separated.
When she was
got up
12.
there and said, yeah, I worked at Disney. Laurie Shaver called in and made a complaint about the relationship I had with Mike Shaver. So everyone is lying about Laurie.
There we go, LaDonna.
But Laurie is the only witness that you heard from that actually admits lying to
Everyone is lying.
She admits lying to law enforcement. She admits that when they came and said, do you know what happened to your husband? She said, I don't know. That was a lie. She knows he was dead. She tries to say, I had no idea he was buried on the property. No idea that he was under this cement slab she poured. But as far as anything that happened to him, no clue. She admits lying to Ravine, her former boss, about the fact that after Michael Shaver was dead in November, she told her former boss, oh, he's in jail somewhere for failing to pay child support and his driver's license suspended. She admits that was a lie. She lies to her son, Aiden, because she says, after I saw Mike killed in the fashion they try to say it happened, she told her son that her dad went away and went to jail. Even if you're trying to cover this up and trying to tell something to the son, why say your father went to jail? That's spite. That's absolute spite on this man that she killed. And then Katina Vasquez, who testified here today, that this whole thing you heard about in 2014, on how this is just so indicative of what happens in the household and how she was abused by Michael and all of these things. What did Katina tell you? Laurie told me that was a lie. Mike should have never been arrested for that. I was the aggressor. I threw the mace. I broke the slide glass.
Look at her. She's like, we got to rewrite the entire closing argument. What are you going to say?
Mike can't get up here and speak for himself and defend himself, but he doesn't have to. There's people like Katina come up and tell you the truth about Laurie's lies. Did the witness at some other time make a statement that is inconsistent with the testimony they gave in court? Tammy Dale talking to Isabel. Do you know what happened to him, your dad, Isabel? I have no clue. I don't know. He just left. At the CAC. So you did not see anything that happened that would have made you have an idea of what happened to him, Isabel?
Oh, objection.
No. The last time she remembered seeing him.
Is there an objection, sir? Yeah.
Sidebar, please.
I knew it. Popped up like a jack in the box on that one. But remember, when she gave that statement, that was closer in time to when it happened. That's what the daughter said. She said, that was closer in time. That's right. And you said you don't know what happened. You didn't see anything. Yeah, she's going to have to rewrite the whole dang thing. She's been over there taking notes this whole prosecution closing because she's like, oh crap, the timeline. I really jacked up that timeline. She messed that whole thing up. The prosecutor's doing pretty well, even though, you know, the closing arguments are not evidence, but he is summarizing this. And you know, even though closing arguments are not evidence, like that's the last thing the jury hears. So even though they're going to take all the evidence back as a whole, that's the last thing they're going to hear. So it'll be top of mind. Yeah, they definitely listen. And plus, if you think about it, like you sit through a whole trial, right? But you want the cliff notes. I mean, think about I think she's gonna go. I think she's going. I'm down with it. But I knew you did, Kirsten. I just said that earlier. I said, I bet Kirsten fell asleep. She's on cold medicine.
Just remember what Isabel was testifying about. I asked her, did you know this?
I know, especially in Florida trial junkies. I mean, remember, they let Casey Anthony off. Don't forget that.
From what she testified. Now, I will also submit to you that back when Laurie Shaver was first arrested is when these statements were made. And this, I don't know.
And George Zimmerman. They let George Zimmerman, Casey Anthony.
With what Laurie Shaver told
Who
every
else?
other person that came with.
You just can't ever tell in Florida,
In
y'all.
2020, I believe that the evidence is completely clear that Isabel had no idea what happened. The only thing she knew is what her mom told her, and that's that he just left. And that this story was fabricated. Travis Filmer states in depo that the reason Laurie did not want a legal wedding was due to financial issues. Yet at trial, he said she didn't want a legal wedding because, quote, she did not want to sign a contract with another.
That's
man.
right,
And
LaDonna.
started talking about, oh, poor Laurie and the things that had happened. But when he was actually presented with that depo transcript and given an opportunity to show me where he had said any of that before, he couldn't, because he didn't say it because it wasn't true. And also, this whole thing about not wanting to sign a contract with another man, we know that's not true because they ultimately got married once they legally could. Once it was discovered that her ex-husband was in fact dead, they got married, and you heard testimony about that. So all of that, not true, completely inconsistent. Travis Filmer states to Robert Kroger and law enforcement, but Laurie said it's not that the victim is missing, it's that he is no longer walking this earth. And he just flat out denied it. But his friend, mentor, Robert
That she's
Kroger,
guilty.
and his
He's going under
twin
the
brother,
jail.
who said he overheard that comment to law enforcement, came in.
We're going to put our initials on the concrete.
Then Travis Filmer had told his brother, Austin, that there were times that Laurie would get his phone, send texts to Austin, basically posing as Travis. I asked him, had you ever said that before? He said, no, that's never happened, no. Austin, his twin brother, came in and said, that absolutely has happened. He's absolutely talking to me. And I could tell because we're twins.
I know.
The way we communicate was completely different from the way she was communicating with me. Which is the same thing you've heard from every friend and family member that received texts and Facebook messages from Laurie Shaver, posing as Michael Shaver since his death in November.
All right, button it up, man. Put the bow on.
Brings us to count 2, the accessory after the fact. The judge has read you the law on this. I'm actually going to hold off in talking about this charge a little bit until after Mr. Wiggs has talked to you. I will tell you that a person cannot be guilty of the murder and as an accessory after the fact to that murder. Accessory means they were helping another person. The evidence we have presented to you proves beyond a reasonable doubt that Laurie Shaver committed second-degree murder. And because of that, the verdict should be guilty of murder in the second degree using a firearm and not guilty of accessory after the fact.
That's right.
Because you can't be guilty of both.
That's right.
But the law does allow the state to present these alternate theories depending on how the jury perceives the evidence to make that final conclusion. But I will tell you that the evidence that has been presented is not that in May of 2016, Jeremy Townsend shot this man in the back of the head and Laurie had efforts to help cover that up. It's that Laurie killed him in November of 2015 and she, in order to prevent investigation into her own crimes, covered that up. The evidence of the cover-up is still showing you evidence that she is in fact the murderer. Comes back to that common sense. We've been talking all week about a lot of different things and a lot of different evidence. And what I've been trying to do here is put it together in such a way to kind of condense and show you how the bank records and the Facebook records all fit together. It's up to you to decide what's reliable, and you should use your common sense in deciding that. The totality of the circumstances show you that everything points to Laurie Shaver. She had the motive, the means, the opportunity. Mike is buried in her backyard. She's the one that installs the fire pit.
I've had 3 cups of coffee and a
puts
Celsius.
the cement slab over his body. She lied to friends, family, and law enforcement about his whereabouts for years. There was no attempts to call Michael after 2015. She depleted his bank account. She sold his property. She posed as Michael through Facebook and his phone. Everything points to her. All the evidence points to her because she is guilty of murder in the second degree. The verdict form that you are going to be presented is not as simple as just guilty or not guilty. We talked about manslaughter being a lesser included, so that is on here as well. The judge will instruct you that you are to find the defendant guilty of the highest level offense that has been proven beyond a reasonable doubt. So I would submit to you as you start your deliberations to start with the murder and go through those elements. Because if the murder is proven, manslaughter is
obviously included, so that's proven as well. And you don't have to go to manslaughter if you all agree that the murder has been proven beyond a reasonable doubt. But there's also a couple questions here for you that you will also have to decide that deal with the use of a firearm. And that is crystal clear. There's a bullet in his head, a bullet hole in the back of his skull, but the law requires that you actually designate, yes, she was in actual possession, meaning that she had it in her hand when she shot Michael Shaver in the back of the head. She discharged the firearm and it caused great bodily harm or death. The state is presenting to you evidence beyond a reasonable doubt. This was not self-defense. It was not defense of others, but it was murder in the second degree. And therefore, the verdict consistent with the law and the evidence is that she's guilty of second-degree murder, and that all three of those questions should be answered yes. Mr. Wiggs will be up here and talk about what he believes the evidence is shown to you, and I'll just remind you what the judge said, what the lawyers say is not evidence. You're to rely on your own memory of that evidence and what things were presented. So if either myself or Mr. Wiggs are saying something and you're like, that's not what I remember, you go back to your notes and you look and you make sure what you're being told is valid. It's actually what was presented to you today, this week. Thank you.
All right, thank you, Mr. Canocchio. Mr. Wicks?
Yes, sir.
Mr. Hooligan? Mr. Hooligan?
May it please the court.
Yes, sir.
It's been a
Oh
long
gosh,
week,
he's got
hasn't
a
it,
thick
everybody? I
pile of
appreciate y'all
papers.
being here. I appreciate your attention. I know it was an arduous event. All of us sitting here listening through that, all of the breaks at the bench, all those interruptions, it can be very annoying. It can take a lot of time. It's very distracting, but those things have to happen. In the voir dire, you'll remember, I stressed to y'all extensively about the Constitution. This is something we don't take for granted in a criminal case. Some people may want to downplay it. Some people may want to compromise our rights, the responsibilities, and the privileges that we have. They can't be.
Is he
They
pointing
cannot
at the
be
prosecution,
compromised
basically?
in the slightest event. This is a privilege we have. It's a constitution that is endured. It was created by hardship for men and women like us to live under the system we have. This system goes, we'll never have it back. We will never get it back. And it is at jeopardy at this stage. I told you that the founding fathers in this Constitution, they recognize
Okay, it's 1:30.
that liberty comes with an extreme price. To deprive somebody of liberty comes with a lot of responsibility.
What?
Not coming in here, throwing a bunch of mud on the wall and saying, yeah, there you go. There you go. Oh, she lied about this, or here's another misstatement, or here's another misstatement. Laurie Shaver is not on trial for lying. Laurie Shaver is not on trial for bank fraud.
Well, if you go to
Think about
Michigan,
that.
you can be on trial for lying.
That the state has the audacity to come in here and state money's moved, thus she committed a murder. Guns were sold, thus she committed a murder. There's a car in the yard and a misrepresentation, somebody went somewhere, thus causation. That's a huge leap, an extreme leap. Remember we spoke about in voir dire, and I kind of used an example, and I said, I had seen on TV about, and I believe it was Joe Rogan and Jordan Peterson talking about,
Don't
I
use
think
his
it
name.
was Rogan talking about, and he said, I see photos and stuff and talk about UFOs. And he said, and I hear this, and I hear this, and I hear this. He goes, I really would like to believe in UFOs. And he says, but, there's just not enough to put it all together for me. And Jordan Peterson said, yeah, that's a conspiracy theory. What does the state put together here this week? A conspiracy theory. She lied about this. Here's a misstatement. Here's a misstatement here. Here's a misstatement there. She must have murdered the guy. Think about that. Think about the draw and the stretch that the state has put out. Well, she had a motive.
Brandy, the nerve.
All right. That's a big stretch. Okay. I want to talk about the law foremost, and then we'll go over to some facts. And I'm going to show you undisputably, irrefutably, how more than one reasonable doubt exists in this case. And we know what your responsibility is. And I just ask that everybody abide by it. In the instructions, it talks about, yes, what are the elements of a homicide? When the killing,
Oh, yeah.
okay, excusable
that.
homicide. Now we're talking about when the killing's committed by accident or misfortune. Okay, was Michael part of his own misfortune? Obviously. 2, when the killing occurs by accident, misfortune, or in the heat of passion. Okay, Michael brings on his own death. Michael comes to the house when the state never established his right to be there. We know there were injunctions in place periodically. 3, when the killing is committed by accident or misfortune resulting from a sudden combat. All right. The state wants you to believe Laurie lied about this, or there's a misstatement here, or she's sleeping around. Why did we have to hear that testimony to disparage my client? To think they're going to get emotional impact out of you? Is that relevant to this cause? Is it probative to a material fact that you have to decide? No. It's disparagement for the attempt to pull an emotional result out of you to fill in a verdict form. I told y'all at the beginning in my board item, the state has a responsibility to seek justice. And I said, what is the state seeking here? They're seeking a verdict. That's what it is. So most of what you heard, if not all of what you heard, is an emotional ploy for you to go back there and out of anger for Laurie Shaver, fill in a verdict form for the state. That's what's going on. That's what you've heard this week. Second-degree murder. Mr. Camuccio went over the elements, so I'll briefly touch on it again. The defendant's dead. Yeah, we know he's dead. Okay. The death was caused by the criminal act of Laurie Lee Shaver. Okay. Has any single witness taken the stand and shown you one piece of evidence that established Laurie Lee Shaver killed Michael Shaver? 0. 0. Case over. Period. What they've done is brought in a bunch of digital data after the fact, after the event, and said, well, she tried to cover it up, or she didn't want to talk to this person, or she didn't want to talk to that person. Well, there's a good reason she probably didn't want to talk to numerous of these people, but a lot of it probably didn't have a darn thing to deal with the death of Michael Shaver. 3, there was an unlawful killing, an act eminently dangerous to another, demonstrating a depraved mind, without regard for human life. Okay. Has anybody established a depraved mind? No. Without regard for human life? No. Laurie Shaver was in her house when she was attacked. That's what happened. Did the state offer any evidence on causation, where this event occurred, how it occurred, any different than what the defendant and her daughter testified to? No. No. In fact, you may remember Tamara Dale. She gets up there, and I talked to her about it. And I said, you don't have any DNA. Do you? No. You don't have any prints? Do you? No. You have nothing in the scene in the house to suggest any activity? Do you? No. You don't have anything in a gravesite, do you? No. You don't have any prints in there? No. You don't have any DNA in there, do you? No. You don't have any gun that links Laurie Shaver to the crime, do you? No. You don't have any confession, do you? No. You don't have any witness, do you? No. She admitted all that. And then her response was, well, how could we solve a murder any other way if we had to have all that stuff?
Okay, I think they showed a depraved
Because you normally
mind
have that stuff if a murder has
when
occurred
she allowed her
and it's
daughter
attributable to one person.
to get on the stand. Just
The
saying.
state tried to compromise that obligation. Do you remember? Do you remember how? They said, hey, Mr. Camuccio said, you're not going to hold us to that standard like CIS that you see on TV, right? Trying to lower what you could expect to see in this case. You're right, he said that, because he knew he didn't have any evidence. So he wanted to mentally prepare you to get you ready to not see evidence. That's what that was all about. You remember his statement earlier as well? We talked about the burden of proof. You remember that. And I talked about it in voir dire, and I talked about it, and I said, it's kind of like a football field. I said, in a criminal case,
I'm going to object.
this is an analogy for closing.
Let's have a sidebar.
Wait.
Thank you.
He said, I object. So it's really rare that they're allowed to object during opening and closing statements, by the way. In some states, it's not even really allowed. It just depends on where you're at. But usually in opening and closings, because it's not evidence, they're pretty free to say what they want in those opening and closing statements because they are not evidence. But they're also not allowed to say anything that hasn't been, like in the opening statements, they're not allowed to say anything that isn't going to be presented in the trial as evidence. So whenever they do opening statements, you'll hear them say things like the evidence will show. So they're not allowed to say things in the opening statements that are just willy-nilly crazy, outlandish things. They have to say what they're going to present in the trial. That's why they say a lot, the evidence will show. And the defense, though, has a little bit more wiggle room because they're going to show their kind of their strategy.
Football field. And I said, look, if it was a civil case and the standard is beyond reason, is by a preponderance of the evidence in a civil case, that's just tilting the scale, getting past kind of the center of the field. But in a criminal case where our founding fathers put the premium on liberty and the obligation on the state, I said, it's the highest standard required under the law. You got to be on the end of the field down here. There's a high difference between this, which can't be downplayed in this case by the state throwing some mud on the wall and saying, oh, there was a lie here or there was a lie there. You see, the state can't compromise that. Let's go on a little bit. When we talk about depraved mind, and you hear that word, and you'll have a complete set of these instructions. You go through them at your leisure, need be. Okay, it says, an issue in the case is whether Laurie Lee Shaver did not have a depraved mind, without regard for human life, because she acted in the heat of passion. Okay? Inadequate provocation. In order to find that the defendant did not have a depraved mind, then it gives you some factors to consider. There must have been a sudden event that would suspend the judgment. B, a reasonable person would have lost normal control. Driven by blind or unreasonable fury, there was not a reasonable amount of time for a reasonable person to cool off, and a reasonable person would not have cooled off before committing the act.
What is he doing? Is he going back to converse with her and be like, oh crap, I forgot my notes that you wrote down, that we need to rewrite this part?
Y'all saw these photos.
See?
No, no. There were repeated acts of violence in that house.
He is such
This
a
was
walking
not
contradiction.
A blind event that Laurie Shaver just stepped up for her child and said, I'm not going to act. They knew what was coming. And this is evidence that they knew what was coming. We had multiple injunctions that were filed with the court. Michael Shaver had been prosecuted in the past, and the state wants to sit here and say, hey, this was some blind event and she just murdered her husband. I'd like to hear an explanation for that.
I do too. We're waiting.
Let's move on some.
Called a fishing pole to the back of the head.
Let's talk, because the state's going to have the last word in this case. They always do.
Always do.
We don't have the privilege to respond to their last word.
Thank God.
Okay? Let's think about this. She's charged with accessory after the fact as well as a crime. What are the elements of this offense? And let's think about it. They state that a murder in the second degree was committed by another. State has a real courage to announce who that another
I know,
person
LaDonna.
is
He was
in
trying
the
to get them to
element
not use
or in the
that.
information. They don't have
Now
the
he's using
backbone
it.
to tell you here who the actor is, who the principal is. And yet they'll come into court and say Laurie did it. Then it says, after the murder, Laurie Lee Shaver maintained, assisted, aided, or attempted to aid another person. Stop. Right there. We see and hear talk about money going into the bank or going there. Okay? Is there been any showing in this trial how any money was moved to assist, aid, or attempt to aid somebody in escaping detection of a crime? No. Laurie's using money to live a life, feed her kids, that the state can't not deny is marital money, equitable money, that she didn't have a right to touch it, anything like that. But
Build a
it's
concrete
all
patio.
for you. And then it says, and at that time, Laurie Lee Shaver knew that the other person had committed murder. Okay, let's think about that. That's an important element as well. And I'll tell you why. If you have a right to self-defense, no crime has been committed. If somebody dies, no crime occurred. So you'll have to assess, was there a right of self-defense?
What?
If so, no crime has occurred. 2, where was money being spent to aid detection for somebody who had not committed a crime? You see? Does that make sense to you?
Anya. Yeah, I saw that, Trial Junkie. A whole whopping $500.
Under the justifiable use of self-defense, it represents, and I'll just highlight some of this for you because I want to talk about facts. It says Laurie Shaver was justified in using or threatening to use deadly force, or Isabel was justified in using or threatening to use it if she reasonably believed. Now we know the history in this family. That's undisputable. That's physical. That's not to be questioned. Was necessary to prevent imminent death or great bodily harm to herself. Okay? And then it goes on and tells you, well, what's the type of harm that they suspected would happen? Michael's trying to kill her, or he's trying to commit an aggravated battery. And then the instructions tell you what that is, what the elements of first-degree murder are that Michael's trying to do, or how he's trying to create another hard battery on her. Okay? And that's spelled out in these instructions.
I know. I'm very
Then the
confused.
instruction will tell you as well that justifiable use of force is justifiable if Laurie or Isabel reasonably believed that the force was necessary to prevent imminent death, meaning that a murder,
I knew what you
attempted
meant,
murder on her,
Kirsten.
or great bodily harm. Has the state eliminated this defense? No, not at all. They want to throw mud on the wall and say, well, she lied here. She spent some money here. But they can't say first and foremost, she didn't have a right to defend herself.
Nobody wants to throw mud on the wall. It's called throwing spaghetti at the wall and see what sticks.
It's actually, listening to this case, I got to tell you, I'm spun around listening to it.
I am too. We all are.
The judge is going to give you an instruction because they've made an issue in this case out of this. And it's an important instruction because it kind of strikes a nerve in all of us. And it says this: you must understand, no individual has any duty to report the commission of a crime simply because they observed a crime having been committed. Laurie Shaver could watch Jay Townsend shoot somebody and had no duty to call the police.
Wow.
Isabel would have no duty to call the police if she hadn't shot him or done anything. Okay?
Man, Florida
That's
law.
a fact. That's a law.
Wow.
The state will act otherwise. Like, no, they could have called 911. Why didn't you call 911? Again, we spoke about this in board. Let me grab it.
Gotta go get some more notes from Lori.
Foremost, I'm going to say, excuse my handwriting. Okay? Probably the worst penmanship in the state of Florida. Anybody. But anyway, the judge will tell you that a reasonable doubt, they're in your instructions. I briefly spoke about it because this is very important. If there's one reasonable doubt, it is the requirement, the responsibility, the necessity of any
completely slandered him.
to return a verdict of not guilty.
He should definitely
Not
sue.
guilty. How does it arise? From the evidence. It can arise from the evidence itself. It can arise because of the lack thereof in the evidence. It can arise by a conflict in the evidence. Those instructions tell you. And they further say that if your feeling is not stable, but one that wavers and vacillates, you got a reasonable doubt. You see? Now let's shift over to the facts and talk about some of those facts. One we spoke about, and I want to remind you, the burden of proof is entirely on the state. Ms. Shaver was not required to take the stand, expose herself to criticism, ridicule, or the misstatement here or there. That
Misstatement.
burden stays on the state. We know in this case, it became evidently clear and should be to everybody here that Ms. Shaver was in a marriage that had gone bad. It was a case of
It ain't about the money. It's about the fact of the matter.
Lived in an environment that, as Isabel said, it just became commonplace to see these things happening.
And then her pants catch
My
fire.
dad striking, forcefully, acting out on my mom. And she said, I soon developed an attitude of feeling a need to protect my mom. I soon just responded with a attitude of response trying to protect my mom. That's how bad it got. So she said on the day that this happened, she goes, she was kind of in shock, went to school and just kind of tried to put it out of her mind.
Went on about her day.
And that's what happened.
Like a normal
and yet
day.
The state, despite all this, wants to criticize that girl who's a victim in this case.
You put her on the stand.
Shame on them.
Shame on you.
This little girl is a victim
Shame on you.
Of a house with continual domestic violence. And the state says, well, why didn't she get counseling? Why didn't she get counseling more?
Why didn't her mom do it? Oh, man.
The state chose to ignore this girl. She was brought to their attention as well as Mr. Ballou. Mr. Ballou had prior tensions with Mr. Shaver. That's why his name was mentioned. Mr. Townsend's name was given to the state. The state took no aggressive action to look into this case. I asked Tamara Dale, state talk to you about this? Did you make any efforts to go see her? Not ask Kelly Johnson, hey, if she wants to come by, why don't you just bring her over? I mean, is that investigation? That's not investigation. That's just saying, bring us some evidence. We'll maybe look at it. State was aware of the domestic violence in the house. They had evidence. They had prosecuted Mr. Shaver for a battery. They knew about it. Wilma Nichols gets up there on the stand and says, yeah, well, Michael's story at an earlier date and time was that his wife attacked him. I said, are you talking about the same incident where he was prosecuted and the state went after him? Well, yeah. Yeah, that had a lot of merit, didn't it? There was nothing contrived by Laurie Shaver and this minor child. Now listen to me. The judge is going to tell you, you had the privilege of believing all, some, or none of the witnesses' testimony. So if you find that there was misrepresentations by Laurie Shaver here or there or one way or another, okay, you can disregard those. You can say, I don't believe that truth.
Almost
But
30
again,
minutes, trial junkies.
Whereas the state led you to believe that Laurie Shaver killed Michael Shaver. They haven't. There's no evidence in that regard.
Now, flying was an Olympic sport,
We know
Corey.
there was times
You'd
when
be a
Michael
gold
was not
medalist.
residing at the residence. That wasn't contradicted. His former girlfriend gets on the stand and says, yeah, he was living at the hangar here and there. Laurie said, I let him in the house. There were injunctions. He was coming and going. Did the state offer evidence that there was not an injunction or he was not restrained from the house, not permitted into the house on a date specific when any homicide occurred? No. No.
Don't. That's ugly.
Now, let's shift over to, for a moment, to the digital
Same
data.
way.
That was interesting to me. Kind of interesting.
Because you're an IT
Okay.
specialist.
You got some guy at the sheriff's office, corporal.
Some guy.
He identifies me, that does some tech work out of there. We never
Some
heard
guy.
his qualifications, any experience really he had.
What the?
Okay, I heard a lot of arguments from him, but we heard Connor take the bench.
Like
A
3
man that had been
times.
involved in I don't know how many trials, federal trials, trials everywhere, and he had testified in court with his special skills, and he spoke to us real clear and simple, and he said, now think about, he said this, the IP records from Facebook, CenturyLink, etc., at a point in time, they expire and don't tell you the physical address it's coming from. They may have IP logs, records, you see, but you don't know where it's coming from. It could be Starbucks, it could be overseas, it could be here or there. So the state, trying to throw some mud on the wall, says, look at these IP logs, look at this, look at this. But you know what? It doesn't tell you where it's coming from, any device, or any user. You see? That's a significant fact. So the state says, well, somebody sent this, and somebody sent this, and this went here, and that went there. That would create a lack of evidence, a conflict in the evidence as well. And it certainly would not create stability in the way in which you think about it. If Jeremy Townsend is sending some of these, he could be at Starbucks, he could be at his house, he could be anywhere. He could be in a driveway, and he certainly had a motive that can't be excluded. Now, this child wants to be the state disparages this child because she doesn't know it's state specific. She said sometime in the spring. She didn't say summertime. Mr. Camuccio went on and he said, now today, well, she said the spring and the summer.
Whose phone is going
true.
off?
Mr. Camuccio's not presenting evidence here today, but some of his statements were not accurate as to the content of the witnesses themselves. You'll have to rely on your memory, the notes.
Got the judge going, shut up. It's been 30 minutes.
Now, there's a discrepancy exactly, precisely, in what Laurie said and what Isabel said. Isabel, I believe, says, and you have to rely on your memory, she made some statement to the extent Jay threatened to kill us or something of that nature. Laurie said he implied it or something to the children. There was a little discrepancy, but they got the message loud and clear. Okay, don't tell anybody or you guys are going to get in trouble and you're going to be harmed. So one, she doesn't have a duty to report anything, and somebody's threatened her. She's been the victim, we know, of repeated violence. It kind of makes sense this woman doesn't want to come forward with that kind of threat against her. It kind of makes sense that Isabel is not going to school and wanting to tell everybody all about it as well.
Because she didn't see it.
Now, let's talk about a little bit about this shooting. The state's made issue of this, and I want to bring something to your attention, and I hope you picked up on it in trial. We heard from Dr. Shaw, the medical examiner, and we heard several things I did, and it was brought out through his testimony. One, he said there was a gunshot here to the rear of his skull, and we know that, okay? And I elicited testimony from him when I said there was no soft tissue on this body, correct? Yes. And I said, could it be that somebody shot through some soft tissue and that may account for the presence of the shrapnel? He says, yeah. And so you may have a bullet that goes in, exits an eye, and there's some shrapnel in that skull. I asked him, did anybody do any meteorological testing on the fragment together with the shell to see if they were linked together? No. Now, who's in charge and directing them to do these things? The state. Does that create a lack of evidence? Correct. Does it create a conflict in the evidence? Yes. Does it create stability in your mind? It shouldn't. Okay. Whose obligation is that and the burden rests with to come in here and prove these facts? The state and only the state. Now, one thing further I brought out through Dr. Shaw, and I know y'all probably heard it. I don't know if you picked up on the significance of it at that time, but I asked him about injuries and the nature of the injuries that existed on this body. And I said, were there post-mortem injuries to the body? And he said, yes, there were. And he noted several ribs. And he said those were post-mortem injuries. And I said, when we talk about post-mortem injuries, how do you identify them? And he described about buccal fractures in the ribs and the way to identify it. And he said, this is where the body is broken after the death, and there's a discoloration in the ribs here and there. And I said, could that be accounted for? And he said that can be accounted for by moving the body.
Or a bunch of concrete being poured on it.
So Jeremy Townsend logically tells Laurie Shaver, I'll take care of this. She understands they got property elsewhere. Logically. That body disappears at that time. Now, when did the body logically and arguably show up? When after that shooting, when Laurie said, it's over. It's over. Okay. She even took the stand, and I thought this was kind of sad listening to this. And after all the violence she incurred, she started crying and saying, I still loved Michael. So we know any relationship between these two was logically over. Now, maybe, and I don't know, we talk about flowers being sent, cards being sent. Was that sent by Laurie maybe to make sure Jeremy's not coming back? Maybe to get him in trouble with his wife? Possibly. You may interpret it that way. Now, we also heard from Mr. Cios, remember? And the state called him. It was their witness. And he said, I asked him this, didn't you call Laurie, advise her somebody was trespassing on your property? Yeah, she was gone, and I saw somebody trespassing. Who had any motive to come back to that property, deliver something back to that property if it had been removed? Jeremy. You see, that fits together a little tighter. Now, talking about that gravesite, did the police think about the depth of the site, the height of Mr. Townsend versus Laurie Shaver? No. Never even analyzed that mentally. It's not that difficult to think about that. Okay. Also, there's a blue tarp in the grave. Right? We heard all about that. And I said this, and I don't know why this wasn't done. We had told the state about Jeremy Townsend. I said, did anybody do a financial audit of anybody's accounts to see who may have purchased a blue tarp? No. They should have. I'm telling you, if they had one on my client, they'd be in here waving it up in the air. It's her tarp. Lack of evidence, conflict in the evidence. I asked the officer as well. I said, did you guys, I said, you didn't find any prints on that tarp, did you? Now, I like the way the state tries to cover some of these lack of evidence up. Okay, I really kind of got entertained by it at a point. They'd say this, well, you weren't surprised, officer, that given the evidence was degraded that you couldn't find that, could you? No. And I'd say this, hey, what do you mean degraded? The evidence may have never been there in the first place. It could have been degraded when it went into the ground and evidence was put on it prior. How do you know the condition of the item before it went in the ground? But they had to acknowledge that, yeah. So the state would repeatedly, to try to cover up the lack of evidence, well, you're not surprised at this. It was all degraded. You wouldn't expect it to be there, would you? No. So that's how they try to defend themselves against the lack of evidence.
Well, did you
We
witness
saw
the
that repeatedly in
red
this trial.
drum? Are you an IT specialist? What the?
Now, we heard with regards to the tarp, the state never investigated it.
Him and this tarp.
Party with the burden of proof. 2, we heard Laurie and Isabel both take the stand. We didn't have one. Now, that logically goes with the theory that that body had been off the ground, off that site, because it comes back to the property and it ends up in the gravesite. Can we assume that Mr. Townsend put that in there with the straps, wrapped it up, took it off-site, damaged the body, brings it back and puts it in the grave? That's a logical conclusion.
Say what now?
I asked the investigator, I asked the tech people, listen, were there any telltale signs on that tarp that tarp had been dragged across the yard? Huh? What do you mean? I said, did you ask for any kind of chlorophyll testing underneath it to see if it had been dragged by somebody? No. You see? Do you know if Laurie took it out there? I don't know. Do you know the distance from the house? No, we don't. Somebody else can tell you that. So what does the state do? They offer some evidence showing she's working out, and you're just to jump to this conspiracy theory and say she could have dragged it out there. She could have done this. She might have done this, for you to fill in the gaps that the state failed to investigate. And that's what we see in this evidence thrown in your face without a real connection. You look at the forensics. I brought out, state didn't do it. The defense brought it out. There's no DNA in the house, no evidence of how the crime occurred in the house, no prints, no hair analysis, yet there were hairs. Okay, no match of any flooring that was found in the gravesite to implicate Laurie Shaver. Those all create a reasonable doubt. The state can't ignore it. Instead, they just want to say she lied about this or she lied about that and she's sleeping around. That's their case. That's the state's case. Now think about the gun we heard about. We have a gun in evidence. Again, kind of a comical display to me. You get this lady up there, and she goes through this litany as to her experience and everything. And she talks about, well, it has the signs of other guns, meaning this manufacturer that make Colt or Smith & Wesson that may manufacture a 38, they got a machine, it's going to have ridges in it. They all have that common characteristic. Millions of them, okay? But she can't identify any specific features of the gun. She can't narrow it down from millions to say it's this gun. Wow. Wow.
Get some rest,
So the
Kirsten. I
state
hope you
says
get
it
feeling
can't be
better.
excluded? No, it can't be excluded.
Have fun with your nephew.
Right. That's reliable evidence for you to hang your head on and to fill out a verdict for the state? No. The state's position is, well, we don't have to prove this case by 100%. No, they don't. Okay. That's not their requirement. We know what the requirement is. When Jeremy Townsend, the state was informed of Jeremy Townsend, why, ask yourself, didn't they look into his financial records? Lack of evidence. 2, why didn't they look into his Facebook?
45 minutes, trial junkies.
Do you remember what the testimony was on that by Tamara Dale? Here's what she said. Well, those records were too old. What do you mean they're too old? You're going to stand in here and tout that Laurie Shavers are reliable at the same period of time and not look into Jeremy Townsend, who you've been advised shot the guy?
Well, we're going to pray you're going to feel
And not
better,
even look?
Kirsten.
Not even look anywhere into his matters? No. She was closer to the body. Okay. Now, let's talk about the patio. State thinks that's a big deal. I don't. Why? Because they cleaned it out to make a pond. We all know that. Okay. They get tired of building this pond, and it sits for a while. Concrete is bought. Now let's think about that. Nobody goes and tries to conceal themselves when they're buying any concrete. They don't go paying cash. They don't go in there with a hat on or anything like that, trying to disguise themselves. It's open and clear. They're not trying to conceal themselves. They go rent a mixer, not trying to conceal themselves, not trying to make it private, or a hidden event.
Look,
They
no one
even
said she was the
post it on
sharpest tool in the
Facebook.
shed, okay?
Like this is a big secret? No. Who would do that if they're trying to hide a fact against the public and knowledge? You wouldn't do it that way. That's just common sense. Okay? You take the evidence and then you rely on your common sense or the lack of evidence thereof. That's the point. Who would write their name in concrete on top of a grave of somebody that they allegedly murdered? Not any person in the face of this earth would do such a thing.
She did.
You got to admit that. So you see, there's another reasonable doubt the state can't account for. We had Holcomb, officer, take the stand and said, oh, it was right in the middle. Okay? Like it was obviously trying to be concealed. It wasn't. When I pressed her on the video, she said, well, it wasn't on the middle, actually. Then the next officer said, well, it was a darkened spot. And you look on the photos, well, there's about 3 or 4 darkened spots all over the place. Okay? Doesn't mean, we know there's a body on there. There is clear evidence of guilt or anything like that. I want you to think about all those things that create a reasonable doubt. There's multiple, and the state can't excuse that. They cannot excuse those factors. There's a question, who killed, actually, Mr. Shaver? We know there's shrapnel. We know there's one fragment, but the shrapnel could have been a second shell. We know that from Shaw himself. Has the state eliminated self-defense? No. No, they haven't. Who has that burden exclusively and only? The state. We know this is a violent man who most likely didn't have a right to even be in the house. Is there evidence that the body was moved? Yes, there is. Has the state refuted that? No. Why no forensic audits? None. Now again, the state is looking for a verdict on something. Give me something. Give me something. So they got lessers, a primary, and an accessory. You have to understand, Laurie Shaver is not guilty. She's not guilty. Don't be pulled into an emotional game trying to compromise, thinking you're doing justice one way or another. You have to understand that. Laurie Shaver is not guilty of any crime. She has not committed a crime. The state has not refuted it through an investigation and presentation of evidence in this case. Again, I'll remind you with regard to the crime of accessory, it must first be established that a crime was committed. If there was a right to self-defense, no crime has been committed. You see? And there is anything that Laurie Shaver did was lawful. The state can't link up any transaction unjustified or evidence of a cover-up if there is no crime that is committed. Likewise, the crime of accessory must establish a firm timeline as to when the crime occurred. You're not at liberty to say, well, the state says this and Laurie says this. Let's just pick a number. Could have happened between this date. The court will instruct you that you have to, that accessory requires the completion of one event before
I think
the
so,
start
yeah,
of
LaDonna,
an
but you can
accessory
do it
offense.
yourself.
Okay. Has the state firmly established that? No. What they do is they say, well, there is, he didn't show up at work, so you got to admit, you got to assume that she murdered him. And then let's take the next step and say all this stuff was to aid or assist in concealing an offense versus living expenses and money that she had a right to touch and use. An accessory, when you see accessory,
It wasn't a very good concrete
normally,
job, apparently.
what you would
From what
see
they
is
said, it was
somebody
very shoddy
buying
work.
somebody a flight ticket to leave town, putting them in private housing, doing things to conceal them in that manner, not living like this. It kind of reminds me, this case, when I listen to it. It's all speculative, what you call circumstantial evidence. I'm sitting here listening, sitting at my table between approaching the bench, I guess, and listening to this, and I'm going, it's like playing a game of Jinko. Sooner or later, this thing's got to topple. You can't just keep putting little boards on top of each other without a firm foundation, you see? It's not going to stick. So the state just piles up some evidence and says, there you go. Come back here, reach us a verdict, okay? Give us what we want. Now, again, I remind you, and I'll sit down, leave it to you.
Thank you.
The people that may have been misrepresented, the people that any lies or misstatements were given to, really are not relevant in this case. Laurie's not on trial for lying. She's on trial for murder. Any misstatement must have been to make and conceal a crime which never has occurred. You see, if she lied about Michael, where he was or what happened or where his tools were or where he'd been, is not really relevant in this matter. So don't be distracted in that regard. Going back to the digital data, I'll leave on this. Remember, I asked these witnesses, did you find anything in the digital data that announced or indicated somebody had shot anybody? No. Did you see any evidence in the digital data of any effort to conceal a crime? No. Could you tell me where this was coming from physically? No. Could you tell me who was using the device? No. So what did we have? I found it, I don't know, I don't want to say it, but we get memes thrown in front of us and some emails from this place to that place. And you're supposed to say, let me hang my hat on this meme. Sometimes you got to burn a bridge and move on. That means Laurie Shaver killed somebody? And that's what the state is asking you to hang your hat on and just pile up a bunch of memes like a Jinko game? No. That's not how you prove a criminal case with suspicion, bare innuendos, without physical evidence of guilt.
Kind of how it starts.
Now you have, likewise, and I mentioned it to these people on Cross. I said, you got a certificate over there, a business record certificate from Facebook,
Ooh.
right?
Objection.
Sidebar, please.
He's like, dang it, I was on roll, about to end this sucker. Here's the thing about the IT information. Even if he's trying to debunk the IP address information, you can't debunk the fact that the information is side by side. And she changed his phone number twice.
Certificates from Facebook. Really interesting. I brought it out on cross-examination. I mean, kind of floored by it. But here's what they say. In essence, read them yourselves. Well, we once had this data. We gave it to you earlier. We're sure we gave you something that was accurate, but we don't have the information anymore. So we got to just assume it was accurate. Okay? That's what the state's going to hang their hat on and say this digital data is even reliable for your consideration? That's not even digital data. And we know what Connor said. You can't even link it up from this place to this place because IP addresses have expired the physical location, and the state's hanging their hat on it to throw all this out there. It's unbelievable. Further, the state doesn't even have a computer.
You don't have a computer.
There's no computer in this case. Not a computer for them to try to connect it to. I want you to think about these factors. This is where, ladies and gentlemen, my power ends. This is where yours begins under our Constitution.
Where the rubber meets the road, sir.
I can only ask, I can only beg you to do your duty Don't compromise your duty. I've listed to you multiple reasonable doubts in this case. They should never be compromised by any single one of you. I asked each and every one of you as well to please hold your verdict, and if it disagrees with other ones on this verdict, on this full jury, that you please hold your ground. I've shown you everything, every way the state has failed in this cause. Don't be misled, I ask you. The state will have the last word in this case. They always do. Wasn't like that always when I practiced law, but it is. But as Mr. Coluccio speaks, I ask you to listen. Give him the due concern that you've given me. But I ask you to ask yourself, as he speaks, what would Mr. Wiggs point to refute that? Have you answered Mr. Wiggs's questions? What about this question? What about the grave? What about the lack of evidence? What about the gun? Let's hear an answer to all these things. He can't give you an answer. So I ask that when you go back there, I know the answer, which should be given by you, but I can't do it. But I ask you to do the right thing and come back on all counts, all issues, and do justice, not seek a verdict for the state. Seek justice, as I've asked, and return a verdict on all counts of not guilty. Thank you.
All right.
Thank you, Judge.
Thank you, Mr. Wiggs. At this time, I'd like to give the jurors a comfort break. We've been in
Comfort
proceedings
break.
for nearly 2.5 hours. So let's take a 10-minute comfort break. Thank you.
So that closing argument was kind of all over the place. Yeah, he made it just in the hour, by the way, but his closing argument was not very eloquent for it wasn't neat. Yeah, you saw how the difference between the prosecution's closing argument and the defense closing argument. So the prosecution was like,
recess for 10 minutes. Thank you.
Very, like, he obviously had like a PowerPoint. His was very ready. He had his points that he wanted to get out there. Is very, like, it was just neat and buttoned up. And he hit all the major marks that he wanted to. Obviously, he wanted to get across all the parts that the story didn't make sense, right? The timeline was very, very important. The defense attorney was kind of all over the place. Like he kept saying the prosecution was doing, like throwing mud, just kind of like LaDonna said. That's what the defense was doing. He was the one throwing mud. And everything that the defense attorney wanted to be taken out, the defense attorney was throwing in. All this stuff about the volatile relationship, all about the pictures, all of the things that the prosecution, I don't think the prosecution really wanted that stuff in. I think that was the defense that opened the door on all that stuff, not the prosecution. I don't think the prosecution would have wanted the daughter as an option, much like they didn't really touch on that in their closing statement as far as the accessory after the fact stuff, because I don't think they wanted that. I don't think they want that to be an option. They're looking to go for the obviously the first charge, which I'm kind of curious as to why they're not going for first degree, because if they were going for first degree, right, that's where you kind of planned it, premeditated, and then they could go for the lesser included, which is second degree. but they're not going for first degree, which is really odd. Instead, they're going for second degree, and then they're going to go for the lesser included of accessory after the fact, which doesn't make sense. I wouldn't have put the abuse in there, but I think because the defense, I'm just confused as to what the prosecution brought in and the defense brought in, because it kind of seems like the defense brought in, or maybe the prosecution had to bring it in because they knew that was going to be part of the defense, bringing the daughter in there. I don't know, but I do have something funny y'all should look up. I was trying to look up Jeremy Townsend, and there's a company called Golf Ticks. I'm going to put it in the chat. It's a YouTube channel. Oh, darn, I spelled it wrong. Sorry. It's a YouTube channel and a website. But it has a guy named Jeremy Townsend as part of the channel. And I kid you not, he looks very, very similar to the Jeremy Townsend in Florida. He has long hair and a beard, all of that jazz. And I thought that was the same guy. Because I was like, no wonder they couldn't find him. He's all over the world doing all this touring. He looks just like him if you look on that channel. And his name is Jeremy Townsend. So weird. But I still can't find anything about, yeah, the others. It's so weird. But he's from Washington State. I think that's where he's actually from. This guy, this Jeremy Townsend. But still can't find anything about Michael Shaver. It's so sad. This poor guy. Just nothing about this poor guy. Yeah, it's amazing how you can literally find anything on the internet, but when this kind of stuff happens, like everything's just scrubbed. I don't understand. It's wild. And all that pops up is what is in the trial. It's just wild how you can go online and type their name in and then nothing pops up except what's in the trial. Oh, but I need to go on So what was going to tell y'all, Perna called earlier. Sorry, I didn't I mean, you would make it private, right? I don't know. Or you change your name, or maybe you'd put a funky green cat as your picture and then get kicked off Meta. Perna called to tell me that I'm going to post it on my Twitter and I'm going to make a video about it on my YouTube. But so the Detroit Police Department is not answering a court order from Judge Van Houten. Not responding to a court order to give Michael back his stuff. The prosecution has signed off on it. The judge has signed off on it. And by stuff, I mean like he and Tierra's stuff, his car, all of the stuff they confiscated from Tierra's apartment, all of Michael's stuff that they're not keeping any longer. As far as evidence, they are keeping his North Face jacket and the pocket Sharpies that they tested. They won't return because they are going to appeal the double jeopardy ruling from the judge. But they're supposed to return everything else that they took. But the Detroit Police Department will not respond to Perna. They will not respond to anyone, the court order, nothing. And she is ticked. So I'm going to post the court order on Twitter, Facebook, TikTok, everywhere, and tag the Detroit News, Charlie LaDuff, everybody, and see if anybody responds, because Michael's been waiting for his stuff. He'd like to get it out of, obviously, Detroit PD's hands. And not only that, but they've had his car now for going on a year. And you know his car's not going to start. It's probably the tires are all flat. I mean, it's pretty crappy. But they've just been giving Perna the runaround.
Oh, you may be seated.
Dang, that was fast. I know. Yeah, I'm gonna Perna sent me the order so that I could post it. She's like, yeah, post it. Yeah, you better get used to walking around like that, girl, because you ain't going to get to do that after, what time is it? See, once the jury starts deliberating, though, trial junkies, they're stuck there deliberating. I hope she gave her kids a big old hug and kiss today.
Are we ready for the jurors?
Yes, sir.
Yes, sir.
Okay. Please bring in the jury. Thank you.
because she is not going home.
You may be seated.
Well, dang, LaDonna, did you tell us you were leaving? You didn't even tell us you were leaving.
All of the members of the jury have returned. State, you may proceed.
May I please record?
Yes, sir, counsel.
Yes, sir. Mr. Wiggs asked who would write their name in concrete over the grave of their dead husband.
Laurie.
A woman who killed her husband with ill will, evil intent, hatred, and spite, and then over a period of years covered that up with lies and manipulation against all the people that knew him.
Get it,
That is who writes their initials on top of that grave. And that is what happened in this case. Mr. Wiggs brought up numerous things. I'll try to address as many as possible, as quickly as possible. But some of the things he said, I ask that you go back and think about what's your memory of the evidence and the testimony and realize that that's just not the way it happened. First thing one of the things he brought up was talking about how
Whatever. I've had to talk to trial junkies this whole time. Where have you been?
About how there's no DNA evidence in this case. I did. Edgar Perez from the Florida Department of Law Enforcement testified about the DNA analysis in this case. Who called it? Mr. Wiggs? From the state. We presented that to you. We presented you the fact that what the DNA evidence was, and the fact that it's not that it was someone else's DNA and we can't match it up. There's just not enough genetic material in anything that was in that gravesite to compare it to anyone. But that came from the state. And Mr. Wiggs got up here and talked to you and said that he was the one that brought that up. And that's not.
Everybody's falling asleep today. That's okay, Glenn.
Just goes back to can't trust the little things. How can you trust the big things? He talks about what he refers to as shrapnel in the skull and how that's evidence of potential 2 bullets. That's what
I'm older than you, trial junkies. What the heck are you talking about?
Or Dr. Coverly told you. They said that shrapnel is not evidence of a second bullet, but
am I not older than you?
When there is gunshots
like
that,
than
typically there will be small metal fragments from the bullet. There's only one entry wound. There's no exit wounds, and there is one projectile.
Am I not? Yes.
There's no.
I'm not older
bullet.
than y'all.
There's no.
I'll take it.
Second shot. Talks about how the state has presented no evidence to refute self-defense.
Yeah, there wasn't anything. You didn't miss anything. His
The
garbly
state
garb.
presented undeniable evidence that Michael Shaver has been dead since November of 2015. And if he is dead in 2015, he can't possibly be on the Shaver porch sometime in May in 2016 and have the events that were relayed to you happen. That's how we've proven to you beyond a reasonable doubt that this wasn't self-defense, because we've proven to you beyond a reasonable doubt that he has been dead since November of 2015. And if he's been dead since November of 2015, Jeremy Townsend had nothing to do with it.
Nobody would know with
Because
that green.
relationship
had just started
What is
at
that?
that point, continued
Cat with
up
sunglasses?
until April of 2016 when the affair was exposed, and then it was over. Laurie Shaver can tell you what day she kicked her husband out of the home in November of 2015, but cannot tell you the day he died. Think about that.
It's like an angry cat, actually. Kind of looks like that cat that tried to kill me when I was a kid.
But Dwayne says she's a kid, you know, that's not a big deal. Laurie Shaver cannot tell you the day her husband was killed on her front porch. That is completely unreasonable. And the only reason for that is because she's afraid I'm going to find something in some of these records to completely refute it.
Yep.
So if she tries to keep it vague, that's harder to do. But Michael Shaver has been dead since November, and if he's dead in November, the way Isabel and Laurie described these events to you could not have happened, and therefore it's not self-defense or defense of others. Once again, talking about Isabel and her inability to even remotely tell you when this happened, Mr. Wiggs says that I just completely made up this summer time frame. I asked you to go back, think about her testimony, look at your notes. When I went through and I asked her, can you tell me what grade you were in? No. Can you tell me what year it was? No. Can you tell me if it was around a holiday? No. The best she could do is say that we went to the beach, so it was sometime between spring and summer. And then I asked her, what spring is to you and what summer is to you might be different to me. So what is spring to you? And she said April. I said, what is summer? End of summer. And she said that would be before school, August. That was her testimony. But to rely on your own memory of those issues. Briefly talking about accessory after the fact. And the reason why I say briefly is because the state has presented to you evidence beyond a reasonable doubt that she is in fact the murderer in this case because her husband was killed in November of 2015. The evidence, the story, with all of its holes that the defense has been presented to you, if you were to believe that and ignore all the evidence and just ignore the facts that Mike was completely disappeared off the face of the earth for 6 months without a car, without a job, without a bank, without a phone, without any contact from friends, family, coworkers for 6 months and showed up without a vehicle, dressed in shorts and socks, and this event happened in May. The events as described to you by the defense show that she's guilty of accessory after the fact. Even if the initial shot by Isabel was in defense of others, according to them, when Jeremy Townsend comes up and shoots again, coup de grace, puts him out, kills him for sure. That's not self-defense or defense of others anymore, folks. That's murder. And when Laurie lies, manipulates, and covers up the fact that her husband has been dead for years, that's maintaining, assisting, and another person to conceal evidence of this crime. The defense's story is that she's guilty of accessory after the fact. The evidence in this case is that she's guilty of second-degree murder. And as I told you, the law says you can't be an accessory to your own crime. One of the things that I think is very important, one of the details that also undermines their whole disappearing body story, is Laurie's actions when law enforcement comes and excavates the gravesite. First and foremost, their story is somehow in that short drive back and forth to Pine Ridge School, Jeremy somehow got the body out, cleaned it up. They speculate maybe he drove a couple hours to Crystal River to hide the body up at his parents' house for a while, only to return at some other point to bury the body unbeknownst to Laurie Shaver in the backyard. She never notices any, like, oh my gosh, why is there upturned dirt here? And then returns the body, buries it without her knowledge, and of the entire 5-acre plot, she just so happens to choose that to put a cement slab down. That's completely unreasonable. But she needs to say that in order to convince you that she didn't know the body was there. But you have evidence that absolutely refutes that. Because Jessica Wade testified that they were doing this search and this excavation. And Laurie sat in her truck and was sitting there the whole day, the whole time watching. When did she leave? When law enforcement started to pull up that concrete over the body of her dead husband that she murdered. Law enforcement, when they were done the process, when they were done search, took a couple of days, Detective Strickland called her. Said, Laurie Shaver, we are done all our work. You are allowed to come back to your property. Would you like to know what we took from the property? And she said yes. And he went through and proceeded to tell her everything that they took. We took some swabs, we found some projectiles, we took some other items from inside the house. We took skeletal remains from your backyard. And this woman who is sitting here trying to convince you she had absolutely no idea that her dead husband was buried under the cement slab that she poured or helped pour, had no reaction whatsoever. That's why we played that call. That's why we had that for you to listen to. So you could see just how she reacted when told there was a dead body in her backyard. Nothing. Because she knew it was there. She absolutely knew that.
Oh, was that a little nod?
The defense has talked about how law enforcement, how their investigation, and they didn't look into self-defense. They didn't look into this story. And despite the fact that Kelly Johnson sat up there and told you, yes, the state was asking me repeatedly if I was going to produce my client, yet I did not do so until they issued a subpoena to her for deposition, thereby giving her immunity. I wasn't going to allow her to talk to them. But he wants to put the blame for not looking into her on me? When the witness he called said I was the one preventing it because I was doing my job as an attorney, and he sits up here and tells you that's me not looking into it? That's just not true. And it's not true based on the evidence he presented. He also talks about, in this, has the state eliminated self-defense? And it always is going to come back to the evidence shows you that Mike Shaver was dead since November of 2015.
Apparently,
That
I didn't
is
hear that.
overall how the state has proven to you it's not self-defense, defense of others, because that story in May can't happen if he's dead in November. But also think about whether or not their story is even reasonable in this situation. The scenario as outlined by Isabel and Laurie happens. What reasonable person is not calling 911 to let them know? I'm not saying do it in front of Jeremy under this scenario that they've outlined, but go some other place, call 911, explain what happens. The idea that Jeremy comes in, sees Mike Shaver shot, and then in that scenario decides he's going to shoot him again and move this body to different parts of the state and come back, that makes no sense whatsoever, and there's no evidence of it at all. He points to the neighbor, Robert Seha, saying, well, I saw a trespasser one night.
Yeah, we're going to be doing a trial with her one day.
Fine.
I hate that.
Did that person have anything? Were they doing anything? I mean, I didn't really see. Do you really even know if they were a trespasser? Not really. But most importantly, he says that happened in 2018. The cement slab is poured in 2016. The body is already there under. That trespasser has nothing to do with this. The timeline doesn't work. Also, Rebecca was living at the house at the time frame this happened. She says, I moved in there in May. While I was there, Jeremy came over to visit. When? At lunchtime, when Laurie was on her break. Exactly the way Jeremy described when he would come. Not 3 to 4 overnight visits, which would obviously put his wife on notice that something was going on, which makes absolutely no sense. But Rebecca said that she had moved in. Jeremy would come over during lunch, as Jeremy said that, but Rebecca was living there during this time frame. This didn't happen the way Laurie and Isabel said. In talking about the 2014 incident, Mr. Wiggs talks about how he went after Wilma Nicholas, and he pointed out that, well, the state prosecuted her or him, and you only got one side of the story.
Nope. Twiggy doesn't get to talk again.
That Katina Vasquez, Laurie's friend, came in and said, you know what? Laurie told me she fabricated that. That's not the way it happened. She was the aggressor. She threw that flower vase and broke the slide glass door. She hit her husband over the head. And when Mike was saying that he was trying to basically grab her, to control her, to stop her from doing these things, that was true. That's her friend saying that. The timeline. Once again, go back to those phone records that establish that Mike Shaver's phone, the phone number that he originally had, changed 2 times, ultimately ending with a phone number that Laurie Shaver admits is hers, puts in a court filing is hers, showing you that she had that device the whole time. They want to insinuate maybe Jeremy Townsend said some of these messages from Facebook. Well, we know he's not sending the 500 pages to his wife to expose the affair. That's not him. Who had motive to do that? Her. We know he's not sending this message in September 20th, 2016, months after the relationship between him and Laurie is over and he's back with his wife, saying, Hi, Vanessa, how are you? Moving on, looks good on you. Hope you and your son are doing well. After we know Michael Shaver is underneath the cement slab, we know Jeremy Townsend has no reason to send his wife that message.
And she's engaged to another
All
man.
of this connects back to Laurie. And all of it connects back to her in her attempts to cover up the crime that she committed, the murder. Mr. Wiggs, as he was going through, kind of picked and chose some things here about the heat of passion defense, and just kind of threw out some buzzwords like digital data he's been doing all week. But when he's picking and choosing through the excusable homicide, heat of passion, you can't just pick some choice phrases out. You have to read it as a whole. And as you see, none of this, even under the May 2016 story that has no factual support whatsoever, would apply to this situation. The defense under the May 2016 version of events, which is completely refuted by the evidence, would be defense of others. That's Mr. Wiggs talks about how there's been no investigation into whether or not there was drag marks or chlorophyll testing. That's fake CSI TV stuff, folks. There's been no testimony whether or not that test even exists. Quite frankly, I've never even heard of that. He talks about Richard Connor and the long credentials of Mr. Connor and Corporal Strickland. He's just a corporal. He's just law enforcement. He doesn't even know what he's talking about. What did Corporal Strickland and Richard Connor say that conflicted each other? Nothing. Absolutely nothing. They both told you an IP address is something that is given to you by an internet service provider, and it's assigned a location. It's basically like a physical address. That is what people will use in order to hook up their devices to the internet. They both said that. Richard Connor acknowledges that the Facebook records and the IP logs within them are the types of things that he, as an expert, relies on all the time. Richard Connor told you that those Facebook records that Mr. Wiggs wants to say are unreliable were reliable. He says that the fact that two different accounts are accessing the same IP address and close in time is consistent with them being in the same location. Knowing what that physical address is would be nice, but it is not at all necessary when you look at 2 years worth of IP addresses showing multiple times these two devices are accessing the same IP address. Where she was using both of these devices doesn't matter. The fact she was utilizing the same IP address shows that it's someone in the close proximity and the same person. That's what Richard Connor said, and that's what Corporal Strickland said. I've got a few more messages to demonstrate how this had nothing to do with Jeremy, and quite frankly, nothing to do with Michael Shaver, who's been dead since November. Mike Shaver has absolutely no reason for Vanessa and Jeremy to get a divorce. Laurie Shaver, posing as Michael Shaver on April 18th, says, "I'm sorry, Vanessa, you must be running scared. I heard JJ Gall is a good divorce attorney." Who stands to benefit? She does. Mike Shaver, who's been dead now for about 5 months, stands nothing to gain from the divorce. between Vanessa and Jeremy. Laurie does. We've already discussed the September 20th after the slab has been poured. Makes no sense for Jeremy to have sent that message. But that is the "Hi Vanessa, how are you? Moving on, looks good on you." This last message, I ask you, is this a message sent by a man trying to inform another woman that his husband is cheating on him? Or is this the message of a woman trying to drive a wedge and get a divorce so she can get the man she wants? This is April 20th, 2016. Hello, Vanessa. How are you doing? I know you asked for no more information.
Yeah.
Right there. Vanessa said, I know there's this affair. You don't need to give me anything more. I got it. But I feel you should be aware of this. There are emails from October through November I have been reading. There is one from November 3rd where she asks him if he changed the sheets. He replied, no, that he had not. Loved being able to smell her and that he would inform you the spot was from him if you noticed. It appears she has been at the house and they have had sex in your bed. Thought you should know that. It also appears he invited her to stop by at your Halloween party, but she declined, not feeling comfortable with you being there. Pictures of that night were sent as well. There's a ton more information about how they met and what transpired. If you would like a copy of email logs, let me know. Vanessa tells him, I got it, I understand. They're having this affair. You don't need to give me any more information. But Laurie says, you know I had sex with your husband in your bed, right? Who would do that? Mike Shaver? Jeremy Townsend? Chinese hacker? Laurie Shaver. Mr. Wiggs got up here and said, the state just wants you to be mad and check off guilty of second-degree murder because the state's proven to
I
you
know,
that he had
LaDonna.
some affairs.
She's
And he said,
terrible.
specifically, why do we have to hear that evidence? We had to hear that evidence because these are the two individuals that he provided to law enforcement. When Laurie was first arrested, he said, you need to look into Jeremy Townsend and James Ballou. And how are they connected to Laurie Shaver in this case? They were having affairs with her. This all came to light because Mr. Wiggs told law enforcement investigate these people. And they did. They did. Jeremy Townsend talked to law enforcement 3 separate times. Came in for his deposition. Came in, told you what was going on. And his testimony is consistent with the testimony of other people that he has no relationship with, that he has no connection to. Rebecca Urbanowski, who was friends with Laurie, states that Jeremy would come over during the day when she was on lunch break and wouldn't spend the night. That's what Jeremy said. Isabel and Laurie said he would spend the night 3 to 4 times a week. That's not consistent because it's not true. Oh, minor point, but this is just another example of how I think it's very important for you to rely on your own memory about testimony. Mr. Wiggs talked about Jessica Holcomb and how he says, she said this body was found
60
in the middle of the
seconds?
fire
Are you
pit.
serious?
very insistent about that. He said, remember that video that was played. Please remember that video that was played. Because he confronted her on cross-examination. Didn't you say it was in the middle of the fire pit? No. Well, where was it then? And she sat there without missing a beat. That fire pit looks like, from top down, looks like the continent of Africa. And if you were to go into the bottom section of it and the point facing at the house, and you were to go right under there, under where the depression was, that is where the body was found. That's what she said, not what Mr. Wiggs said. The state has proven second-degree murder beyond all reasonable doubt because of all the evidence points that Michael Shaver, as Laurie said, is not a missing person. He's no longer walking the face of the earth. And he has been that way since before November 10th of 2015, when all indications of him and his life are gone. No bank activity, no phone activity, no contact with family, no contact with friends, no contact with work. Wasn't at the hangar where she said, wasn't in Georgia where she said. He's dead because she killed him. And then she made up this May 2016 story to distract.
Oh my.
That's pure and simple what we have. If there is absolutely no evidence consistent with that May 2016 story, ask yourself why. And it's because she killed him in November. And because of that, she's guilty of second-degree murder with a firearm. I ask that you return the only verdict consistent with the law, the evidence, and justice, and that is guilty of second-degree murder with a firearm. She possessed that firearm. She discharged that firearm, and she caused great bodily harm or death. Thank you.
Let's go.
All right, thank you. Members of the jury, I thank you for your attention during this trial. Please pay attention to these additional instructions I'm about to give you. Rules for deliberation. These are some general rules that apply to your discussions. You must follow these rules in order to return a lawful verdict. Number one, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law. In this case, all of us are depending upon you to make a wise and legal decision in this matter. Number two, the case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of exhibits and evidence and these instructions. Number three, this case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Number four, remember the lawyers are not on trial. Your feelings about them should not influence your decision in this case.
I like how he has to put
Number
that in
five,
there.
your
Your
duty is
feelings
to
about the
determine if
lawyers.
the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. Number six, whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Number seven, your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Cautionary instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree on the same verdict. Only one verdict may be reached as to each crime charged. The verdict must be in writing, and for convenience, the necessary verdict forms have been prepared for you. They are as follows. In the Circuit Court of the 5th Judicial Circuit of the State of Florida and in Fort Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361-A-01, verdict, count 1. We, the jury, find as follows as to count one of the charge. In parentheses, it indicates check only one as to this count. And there are A, B, and C. A, the defendant is guilty of second-degree murder. In parentheses, it states, if you checked A, please answer the following questions. Number 1, was the defendant in actual possession of a firearm? Yes or no? Number 2, did the defendant discharge a firearm? Yes or no? Number 3, did the discharge cause great bodily harm? Yes or no? In section B, it states the defendant is guilty of manslaughter, a lesser included offense. In parentheses, if you checked B, please answer the following question. Number 1, during the commission of the manslaughter, did the defendant personally carry, display, use, threaten to use, or attempt to use a firearm? Yes or no? And C, the defendant is not guilty. So say we all, dated this blank day of September 2024, and there's a signature line for the foreperson. Verdict form count 2 in the Circuit Court of the 5th Judicial Circuit of the State of Florida in Fort Lake County, the State of Florida versus Laurie Shaver, case number 2020 CF 2361-A-01. We, the jury, find as follows as to count 2 of the charge. In parentheses, it states check only one as to this count. There are options A, B, and C. A states the defendant is guilty of accessory after the fact to second-degree murder. B states the defendant is guilty of accessory after the fact to manslaughter. In parentheses, if you check B, please answer the following question. Number 1, during the commission of the manslaughter, did the person who committed the manslaughter personally carry, display, use, threaten to use, or attempt to use a firearm? Yes or no? And for option C, that states the defendant is not guilty. So say we all, dated this blank day of September 2024, and again, there's a signature line for the foreperson. A separate crime is charged in each count of the information, and although they have been tried together, each crime and the evidence applicable to it must be considered separately and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over the deliberations. The foreperson should see to it that your discussions are carried out in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through telephone, writing, or electronic communication, such as blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instructions I have given in this case, you must tell me by giving a note to the bailiff. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. Certain exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any exhibit, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate rules we all share. All right, at this time,
I don't
will
remember which
excuse
lady.
the two alternate jurors, Ms. Davis and Ms. Hernandez Urbina. You are the alternate jurors. You are excused from further service.
Oh.
Thank you for your time and attention.
Dang, he quickly took them. He didn't even they didn't even do a drawing or anything. He just excused them. Usually they ask the attorneys, right? He must have already asked them. They must have already decided.
You may be seated.
Well, they usually excuse the alternates before a verdict. When they start deliberations, they excuse the alternates. But they might put them in a separate room. Sometimes they put them in a separate. Sometimes. Depends on what state you're in. Because remember one trial we watched, they put them in a separate room. But I think it depends on what state you're in. Not every state does that. Apparently, Florida is like a whole nother planet. So we're on another planet in Florida. Florida doesn't have 12 jurors. They have 6. And apparently they let their alternates go before deliberations. So I don't know. Let me.
All right, then. Is there anything further before the jurors go back to deliberate?
No, sir.
All right, please bring the jurors back to deliberate. Thank you. Yes, ma'am.
So,
all right, the jurors have gone back to deliberate. Anyone have a clean copy of the jury instructions?
I can print one up.
If you would, thank
Yes,
you.
sir. Seatbelt attached.
And, do the parties wish to review the evidence before it goes back?
No, that's fine. Yeah, go ahead. I'm just finding the final jury instructions to send the task.
Yes, sir. Thank you.
all right. So the jury's deliberating. How long do you think they'll take? What's the prediction?
You may be seated.
I emailed the final revised jury instructions and verdict form to the clerk, so when she's done,
Thank
you. Mr. Clarkson.
Mr. Wiggs, if you could review the final copy before it goes back to the jury to make sure it's your
You think before 5? Well, that's only 30 minutes, and you're only, you guys are an hour ahead of me. I mean, it's only 35 minutes. That's only 35 minutes, Brandy. So. You think they should be able to decide real quick?
Just received the verdict forms. If you could send them.
Let's see what the chat is saying in Law and Crime.
Thank you.
Yes, sir.
Eric requested they're writing down. I told them to write it down and then I write everything else. I just didn't want to go anywhere for just They're not that. I know one is they wanted to use a whiteboard or something they can write on it.
Any objections to that? No. State?
No, not all of it.
And
And the other one there, that's on the right there.
Whiteboard and
I think everybody is pretty the consensus is that they think she should be found guilty. So we'll see. Man, they're doing that countdown clock 4 minutes. 4 minutes. You think Monday now, LaDonna? I don't know. They can't go home. I don't know when they're going to go home. I mean, I don't know what the I know, right? They're doing this countdown clock. What if they went back there and walked right back out and said, "We're ready"? Yeah, I guess the judge hasn't left the bench, so I'm thinking, and she's still in the chair, so I'm like, I wonder what they're gonna. Just tell us how you really feel, trial junkies. I mean, y'all just tell me how you really feel about this situation. Don't hold back. I mean, dang. Good Lord, this I know everybody's just kind of hanging out. Nobody wants to leave because everybody's waiting to see if they're going to come back. Like, I guess they're expecting this to come back today. This is wild. Okay, I'm going to see. Look, he's taking his dinner order. What do you want for dinner? Because we're going to be here for a while. Let's look at Justin Timberlake and his statement. Poor old JT. Poor JT. Look at him.
Hey, everybody. A few weeks ago, I addressed all of you, and I said that my client was not driving while intoxicated.
Wow.
After much discussion and a thorough review of the evidence, today the district attorney's office correctly agreed to not move forward with that very charge. You see, the evidence revealed that my client finished the contents of one drink in 2 hours at the American Hotel. And contrary to what was reported, he wasn't drinking other people's drinks or warned in advance not to drive. He wasn't rude, he wasn't obnoxious, he wasn't belligerent. In fact, he was polite, and he was cooperative, and he was respectful during his entire encounter with law enforcement, as they were to him. His plea today to the reduced and amended non-criminal charge,
What is
his
going on
traffic
with your TV?
violation, is consistent with these facts and full acceptance of responsibility for them. I would like to thank the Suffolk County District Attorney's Office for its swift, diligent, and thoughtful review of that evidence and a fair resolution,
Camera
like I
person is
said,
fired.
of this very case. District Attorney Tierney and ADA Shalafeld, Bureau Chief Pat O'Connell, ADA McGill and ADA Kangro and ADA Lathier, they worked extremely hard on this matter, and their door remained open for me and my legal team to discuss, to negotiate, and to laser into the issues of this case. My legal team,
This is your dude,
Co-Counsel
Madonna.
David Smith, EJ
This
Burke,
is the hill you want to
my paralegal
down.
Kelly Fahey behind me, my interns Brendan and Charlie, who aren't here, allowed me to walk into those doors of the district attorney's office to be fully prepared. And their diligence was immeasurable within these last 90 days. I would also like to thank the court for its mindful acceptance of this resolution, and the clerks at the court, Cindy and Michelle, who I know very well, and all their hard work again over these last 90 days. I'd also like to thank the Sag Harbor Police Department, who I know very well, and they do a wonderful job.
I know.
They
I
serve
don't
and
understand.
protect this wonderful village of Sag Harbor. You see, guys, this village is truly unique. And the case was also unique for me in the sense of geographics. As you probably know, my office is right on Main Street, right across the street from the court, right next to the American Hotel, and right next to the Sag Harbor Police Department.
OMG.
It's such short distances where this case emanated out of. But coming out of this case, I believe will have a message that will travel long distances and extend far and wide, because it's that message coming from Justin himself as he'll approach here and address you all and tell you what's in his head and in his heart. So I'd like to turn that over to Justin.
Good morning, everyone. So I don't know how many of you were in the courtroom and heard what I had to say in the courtroom, but I'll reiterate that and say this to you.
Madonna.
Many of you have probably been covering me for a lot of my life. And as you may know, I try to hold myself to a very high standard for myself. And this was not that. This was not that. I found myself in a position where I could have made a different decision. But I've had some time to reflect on that. And I also understand by, the fact that all of you are here, that I have a platform, you have a platform, we share that platform. And so what I'd like to say to everyone watching and listening, even if you've had one drink, don't get behind the wheel of a car. There's so many alternatives. Call a friend.
Uber.
Take an Uber. There's many travel apps. So take a taxi. This is a mistake that I made, but I'm hoping that whoever's watching and listening right now can learn from this mistake. I know that I certainly have. And like I said, even one drink, don't get behind the wheel of a car. I also said this in the courtroom before, but I grew up in a small town, so I can appreciate and understand the strain or unique nature that this must have been on the people of Sag Harbor. But I just want to say to everyone who's been involved, from everyone in the courtroom to everyone outside, including the police department, that I'm very grateful, and I thank them. And I guess in closing, I'd like to say we can all be more safe out there. And I'm going to do my part. I hope that everyone else does their part. And thank you very much.
Justin, have you spoken enough? It's over. Charity, will you be working with?
Well, that was fast.
It's over? Yeah. I was like, it's gonna happen. When it happens before or after?
I know that. I'm friends with something.
Well, they're not happy. That's all they got.
Want me to go here? Okay, absolutely. Okay.
Oh, what are we listening to?
What's wrong? Oh, swamp things that you swamp. Okay, gotcha. Flash drive, a photograph, miscellaneous paperwork, a HP laptop, additional swab, SD card with photos belonging to the sheriff's office, possible buckshot videos, projectile, unfortunately this is the one that limited, and human skeletal footage. So as far as all that, do you have any questions? Yeah. Okay. Do I need to sign any of that paperwork, or it's just at the property? Okay. Okay. All right, thank you so much.
You need to listen to it again?
Would jurors like to listen to it one more time, or was
Oh,
that
dang,
sufficient?
they've already asked to listen to some. Oh, dang, LaDonna, this is going to go fast.
Okay. All right, please bring the jurors out. Thank you.
This is going to go fast. They already got questions. They're trying to hear stuff. This is going to go fast. They're already asking to hear stuff, y'all.
The jurors have exited the courtroom. You may be seated. Are there any other matters that need to be addressed before we adjourn?
Yes, sir.
Okay.
That's
You
it.
provided the phone number where you can be reached.
Yeah, I've given it to Mr. Pucci.
State, will you be in the courthouse, in your offices, or?
Yes, we're not our phone number as well. And we provided the clerk with our phone numbers.
Great. Thank you. If there's nothing further, then we'll adjourn.
Thank you, sir.
Thank you.
Wait, they're adjourning? What's happening?
Thank you.
Yes, sir.
Eric. I'm just kidding.
I'm rewinding it because I'm trying to see what's happening.
All right, will the parties please come up for sidebar?
Okay, we're 7 minutes in, and the jury already has questions. Oh boy. Oh boy. So 7 minutes in to deliberations, and they already had a question. And they wanted to hear that recording. Man, y'all, they brought that recording out at the very end in the rebuttal witnesses. So what does that tell you where the jury's mind is at? That recording must have made a difference. What did I say? They paid attention to the last thing they heard. Yeah. But yeah, you're right. They probably do want to go home. But okay, woo. I wonder if I got time to walk my dogs. I know y'all heard the WALK word. I know his little butt. He's been a butt all week. All week. It's been a pill. I know, Bubba's. So next week, in case y'all don't know what next week is,
Yes, so they would like to come out and listen.
it's
All right, are the parties ready for the jurors? Please bring out the jurors.
Chelseac
All right, just one moment, please.
Korean Fall Festival, Korean Thanksgiving. Y'all haven't had Korean food. You need to go celebrate and eat all the Korean food you can. And celebrate Korean Thanksgiving. Celebrate Chosiak. You can eat japchae. You can eat Korean pancake. You can eat japchae. You can eat kimchi. You can eat rice. I don't want to hear it, Miss Vegan. Get out of here with that. That's what I'm saying. You can eat that. You can eat kimchi and rice and bean sprouts. I don't eat bean sprouts. Tofu. You can eat all that stuff. Heck, if I think about it, most of the Korean food is vegan. Yeah.
Well, yeah, actually, do I need to sign any of that paperwork, or it's just at there? It's just at the property. Okay. All right. Thank you so much.
All right, please bring in the jurors. Thank you.
They are very close. Hey, kind of like, remember when Wade Wilson got that female sitting next to him? And who else was kind of chummy that we watched?
Watch the
I'm glad being vegan saved Doc's life. I tried it. It lasted about 2 months.
All right, thank you. Please be seated. The audio tape has been queued up and ready for you to listen to.
It is. Asian food is better. I'm not a Chinese food fan, but we have to listen to all the rings. We can't go far, LaDonna. I think they're going to come back today.
Shoes. Did everybody help her open? Yeah, let me see what she's doing.
Look, Trial Junkies, if you don't tell me it's vegan, I'll try it. Just don't tell me. There's like a baby screaming in the background.
This is mine. Hey, sure, hi. And this one's calling down for the over property. So we are done out here. You guys are welcome to come back anytime. We locked the doors back up. Put the keys off them down in the shed back there go along. And everything is secured. But I did have to real quick and put the paperwork will be left in the house. To include all the items that we took. If you have that, I would like to just run over this list of items real quick with you over the phone. Let you know the items that you
Okay, absolutely.
Okay. Cell phone, swab, ISO SD card,
What's swab?
and they stuff that, like,
Oh, swab things that you swab. Okay, gotcha.
flash drive, a photograph, miscellaneous paperwork, a HP laptop, additional swab, SD card with photos belonging to the County Sheriff's Office, possible buckshot videos, projectile, unfortunately there was a laser, and human skeletal fluid. So as far as all that, do you have any questions?
Yeah.
Okay.
Do I need to sign any of that paperwork, or it's just at the property? Okay.
Okay.
All right, thank you so much.
You need to listen to it again?
Would jurors like to listen to it one more time, or was that sufficient? Sufficient?
Yes.
Okay. All right, please bring the jurors out. Thank you.
All right, you found a body in my backyard? Cool beans.
The jurors have exited the courtroom. You may be seated. Are there any other matters that need to be addressed before we adjourn?
Yes, sir.
That's right.
Provided the phone number where you can be reached.
Yeah, I've given it to Mr. Capuccio.
State, will you be in the courthouse, in your offices, or?
Yes, we're gonna have our phone number as well.
Like, we ain't going nowhere.
The clerk with our phone numbers.
All right. Thank you. If there's nothing further, then we'll adjourn.
Thank you, sir.
Thank you.
Oh, this jury is coming back today, y'all. They are, this Friday the 13th, ain't gonna be no anniversary for her. All righty. Is that what she said, Brandy? All righty. All righty. All righty. I will. 20 minutes it's been. I mean, okay, LaDonna's at the store. Why is that showing up there? Stop showing that. Okay. Ow. All right. So this trial, yeah. So the trial, this person up there said this trial went very quickly. I mean, for a red rum trial, yeah. Oh, which one is that one? Let me see. Oh, the dude in Virginia. I think depending on the I think when you look at a case, sorry, that's the screen was stuck. I think when you look at I think when you look at the complexity of a case, like Wade's was fast, but it was pretty much cut and dry. Like he did it, you know, and it really shouldn't have gone to trial. His pretty much should have been like done. So but I think that's why these trials go fast is because they pretty much have them, or they feel like they have them. Kind of, but the Samantha Wall trial, like that went forever because they don't have that trial. They didn't have the evidence and they weren't confident in their case. That's why those cases go longer. I'm looking for the recent one, but I'm only seeing 3 weeks ago, Gwen. Oh, here it is, I think.
Naresh Bhatt just appeared before a judge for another hearing related to Mamta's disappearance. News 4's Amy Cho was in the courtroom, and she joins us live in Manassas with the latest. Amy, good morning.
Good morning, Tony. Yet today in court, a judge ordered prosecutors to turn over 2 pieces of evidence that Naresh Bhatt's defense team had been asking for. The defense arguing they believe Mamta Kafli Bhatt is still alive, and that evidence could help to prove her husband's innocence. Now, first, a quick recap of what has happened leading up to this point. 28-year-old Mamta Kafli Bhatt has been missing for more than a month now. Her friends say they last saw her on July 29th. Police arrested her husband at their home about 3 weeks later. Investigators say in the criminal complaint they believe Bhatt killed his wife, but right now he is only charged with concealing a dead body.
Sorry. Looking for the longer. Looking for the longer version. He says she's still alive.
We have an update tonight in the search for a missing Manassas Park mother. Police tell us they were back at the home of Mamta Kafli Bhatt today. They tell us they were looking for evidence based on new information they've received. However, they could not tell us exactly
Oh,
what
that's
they
a
were
nice
looking
neighborhood.
for. You can see right here, we flew over that scene about an hour ago, but did not see any police activity at the time. Mamta has not been seen since late July. Her husband there on the right, Naresh, has been charged with concealing a dead body. He's due back in court tomorrow, and of course, we will be there to let you know what
But
happens.
not with.
We continue to follow the disappearance of Mamta Kafli Bhatt in Manassas Park, Virginia. It's a story so many of you have been looking for updates on. And this afternoon, we have an update on Naresh Bhatt, accused of killing his wife. Today, a judge ordered that Naresh Bhatt's public defender will be able to get access to more evidence that could prove his innocence. Our Rafael Sanchez Cruz was inside of the courtroom. And Rafa, what exactly does the evidence show?
Yeah, Simone, the defense requested 6 items, but today a Prince William County judge only accepted 2 of those to move forward. The public.
In just hours, the husband accused of killing his Manassas Park wife is expected back in court. Good evening to you. I'm Scott Thuman. Naresh Bhatt is charged with concealing the body of Mamta Kafli Bhatt, who is presumed dead. And as investigators are still searching for her, we're now learning police have Naresh's Tesla. 7 News' Christian Flores spoke with an automotive expert who says this is a big get. And Christian, you're finding out how this car could actually help crack the case.
Well, this could be a massive development. The expert I spoke with tells me there.
Sorry. There it is. Okay. I see it. Trying to find it. This is just an hour of nothing.
Okay, there's few things that's going to hand over. He had asked for everything. So basically, he had asked for this GPS tracking device, but car GPS information and Tesla's information he wanted. That didn't happen. Just overrule that. So only thing that he's going to have will be video from July 27th that Mamata had ordered a Uber and that was canceled and got into the route. Speak from your heart.
Okay.
Guys, ready? Come on, Melissa. All right. I don't know.
I don't know if she's the attorney or what.
Let's start with the easiest question to start.
Okay.
First and last name and spell it out.
Okay, my first name is Prava, Prabha. Middle name is Bhattarai, Bhattarai, and last name is Deuja, Deuja.
And I'm Melissa Barton, Melissa Barton.
I'm Angel Rodas. It's spelled Angelrodas.
Also, it's like an honor go taking out.
Okay, there's few things that's going to hand over. He had asked for everything. So basically, he had asked for this GPS tracking device, but car GPS information and Tesla's information he wanted. That didn't happen. Just overrule that. So only thing that he's going to have will be video from July 27th that Mamata had ordered a Uber and that was canceled and got into the ride with somebody else. That was the information was required to be handed over. And then second one was no cell phone data or GPS will be handing over. And of course, the investigation is still going on, but body camera worn on that day requested communication between the police department and Mr. Butt. That information has to be handed over. Those are the information will be handed over. Whatever the defense was talking about Mamata, and however he described, keep in mind, no mother will leave the child behind on their first birthday. There was no phone call came in. Okay, that's what we were waiting for. That didn't happen.
We heard an audible kind of like gasp from some people really upset, specifically when the defense was arguing that they're saying that Mamta is still alive, and people were really upset with that, how they're going to pursue this. I mean, what's your take on this after hearing the details that we've heard in court for weeks?
There was no explanation for the blood found in the home. There was blood splatter. There was pooling of blood in the home. The pictures have been released. They could not explain that. Also, she had contact with people after the Uber ride, and there was no explanation as to why they would need that canceled Uber ride video.
And also keep in mind too that she's always the person that she would communicate whether she goes. And he also defense also stated that that she had left previously, but previously she called and told everyone where she is, and all and that with her communication with everyone. So that part was not accurate either. So just wanted to let you know that.
So here, my take, and please hear me when I say this. She had contact with her mother via video in her home after that car ride. So you're basically saying that her family lie? No mother. I'm a mother, I'm a grandmother, and I'm also a survivor. If you're going to leave, you're going to take your kid with you. The February call, from my understanding, the police said they had to separate. She took her baby, she went to a friend's house. That is noted. Let's get the facts straight. Mamta has a voice. We, the community, is her voice. Say her name! Mamta! Say her name! Mamta! Say it and keep saying it in the media. Because what they want to do is make her look like, oh, she just ran away. She's not the type. I don't know her personally, but her story resonates with me. Her story resonates. I went out with several of the group, go search, pass out flyers, even ask people about their Tesla, about their information about it. That car records
everything.
There's more to come, right? There's more to come. The trial date has not been fixed, right? Once the trial date fixed, then obviously there will be transfer of documentation. So we need to respect that part as well.
Right.
So everything comes in pieces by pieces. And their job is to rush it and close it and move on. That's not how it works in a real world.
No.
Real world works is step-by-step process. And we need to give Commonwealth the credit for doing what they're doing right now.
If they give their evidence too early, and in the criminal justice field, if you give it too early, your ACE card, it could be damaged. They're not stupid. They're giving it as they go when they feel it is necessary. People, let them do their jobs. Let them do what they are created to do. My job and the community is to find Mamta so her mother can bury her properly and grieve, and her daughter has closure. Because what he did, in my book, is unforgivable.
Thank you, guys.
Justice for Mamta. Say her name.
Justice for Mamta.
Justice for Mamta. Say her name. Mamta. Say her name. Mamta. Say her name. Mamta. Please keep her name in the news. Do not let this story die. Her mother depends on this story to be still in the system so that her daughter get justice.
Yes, and also just keep in mind, thank you so much for all of you coming in.
Yes.
And taking time on your busy schedule to keep us alive with her. So we are part of it, and you guys are part of it. And thank you so much. And all our community is here as well. Thank you. Okay, Prava, Prabha. Last name is H-A. And middle name is B-H-A-T-T-A-R-A-I. And last name is D-E-U-J-A.
Woo, that lady is very passionate.
Angel, A-N-G-E-L, Rodas, R-O-D-A-S. And again, I'm a survivor. I walked her shoes 22 years ago before coming to Virginia. I understand her completely without knowing her. That woman loves her daughter in all her videos. Just know that she's a loving person. Her smile affects everybody. She's an inspiration to all. Just know that. Please put that so they know that she is the best mother, friend, daughter anybody could ask for.
Yes.
Somebody has to be a voice for her.
Angel, I'm sorry, I just wanted to ask you, not, you mentioned that she was with her mom on video the day after. How do you know that? Was that in evidence somewhere?
I don't know. I do know that whatever the police department have, they know that she was in the last time she had contact with anybody was the 28th.
We knew that there was a that she had
I can't.
Right,
I don't.
remember, Nepal
Where is
time,
it? I don't have.
Nepal time is different than U.S. time. So in her time is maybe their time is the 29th for us. Yeah.
She's.
But after that, everything.
Oh wait. Hold on.
Requested calendar for 2015 and 2016. Madam Clerk took the liberty of printing out a 2015 and 2016 calendar. If the parties could approach, view the calendars, and let the court know that it is to their satisfaction.
And I think they'll be sure to go and look at each calendar to make sure.
And this is the request of the parties wish to view it. All right.
That's terrible. I know how that woman feels to be so passionate about something.
Okay, if that stipulates, state stipulates, then the two calendars will go back to the jurors. Thank you. All right. I don't believe there's anything further, so we'll adjourn.
Thank you.
Thank you.
Oh, they just wanted the calendars for the. This is coming back today. So they asked for the calendars for 2015 and 2016. Ooh. Okay, Alan, thank you for the update. I don't know why they're doing this. I'm going to get dinged for this. Law and Crime's going to ding me. Dang it. I need to find this on a different channel because Law and Crime's going to ding me. Fold this. Ugh. Yeah, I'm afraid to go walk my dogs. I don't want to keep it on Law and Crime because they're going to ding me. Because they're popping their comments and stuff up on the screen, and I don't want to get dinged. So when the verdict comes back, I'll switch back over to Law and Crime. But for right now, I'm going to keep it on the local news station. I need to WALK my dogs, but I'm afraid to leave. I know y'all have to keep up with the time. It's 4. I know I don't have the timer on because I had to take it off Law and Crime. So I like their little clock, their countdown. Oh, sorry. We were. What did you say? What's it called? Trial junkies. Because it won't let me it doesn't let you put the stuff in the chat. Yeah, we're just waiting. I'm afraid to leave because I'm afraid they're gonna come back. They've already asked for the listen to that phone conversation, and they've asked for the 2015-2016 calendar. So I don't know what you want me to play, Trial Junkies. I'm afraid to play anything. Every time y'all ask me to play something, I get dinged. You're out. LaDonna's out. Let's see. That was such a joke with Justin Timberlake. Guilty of what? All right, I'm looking to see what else is happening. Oh my Lord. I don't even want to talk about YSL. Oh, are y'all gonna watch the are you leaving? It is just a few of us. Okay, they've been 47 minutes. Okay, I might have to put on a different. I want to get dinged for law and crime again. Okay, they're still waiting. Still waiting. Well, it's only been 50 minutes almost 50 minutes. So we'll see what happens. So next week, I don't think there's any trials going on except for jury selection for Donna Adelson. I don't think there's any trials. But at the end of the month, next month is like jam-packed. So we're going to have to like figure out, we're going to have to trial hop. Next month we have, we'll have Donna, we'll have Sarah, we'll have Daniel Penny, we'll have, like, there's just so many going on at the same time. The Delphi DNA. Yeah, we have so many, Brandy. It's nuts. Oh, yeah, a Gigolo Beach. Do I have that written down? Oh, yeah, Gigolo. No, Gigolo's not till July. Corey Richens and Gigolo is in, Corey Richens is April. Gigolo is in July. Phobos. Lake and Riley is in November. We have very busy fall and winter. October 6th is Sarah Boone. But that's what I'm saying. We have a lot of trials running together. We have Sarah Boone, we have Donna Adelson, we have Daniel Penny, and Delphi are all running together. So it's a lot. We got a lot going on. So may as well enjoy the break while we have it, because it's about to just be like nonstop choo-choo train with trials. And then don't forget that on I know I need to get a big calendar too. So that's what I should do, because I'm a visual person. I need to have like everything written down. The Menendez brother Netflix movie or series or whatever is coming on September 19th. Oh, yeah, that comes on Netflix. And I think they might get, y'all can tell me what your thoughts are on the Menendez brothers. Do y'all think they should be out? Do you think they really had abuse? I think we've talked about it a little bit before. What everybody thinks about that? You think they should be free? I think they were a couple of spoiled rich brats that I don't know. I don't know how I feel about them, actually. I don't know. I think they're trying to get them out. You think is that you think so, Trial Junkies? Yeah, I think I don't know. It's hard for me to wrap my head around these kids doing the stuff they're doing. So like this little girl, Isabel, right? Like she's not going to have any consequences or repercussions for what she said on the stand. She is going to get away with getting up there and saying these things that she said about her father. She's getting away with saying, I mean, that she literally pew-pewed someone in the back of the head, and she's just going on about her business. You know what I mean? Like, that's terrible. And like those kids in the Apple River situation, the kids in the Gilbert Goons, the kids, I mean, all of these kids. that are just going around doing stuff and they're not taking any responsibility. Yeah, I just don't understand. I mean, I think the brothers, they well thought out. Well, I don't want to say they well thought out because it was a very messy scene. I think she did too while he was sleeping. I don't think he saw it coming. And I think the kids were at school, obviously, because I would hope. I mean, I don't know, because Laurie's pretty manipulative and conniving. She's a terrible person, but I think the kids were at school and he must have been asleep. And you saw that she posted that on Veterans Day, November 11th, right? Her husband was gone by November 7th, according to the prosecution, because nothing was heard from him after November 7th. So she was clearly very into what's his name. My thing is, did she tag him on Facebook? Because if you tag people on Facebook, right, it pops up on their Facebook feed, and then who's Elijah? Oh, was a Saturday? Okay. That's why they asked for the calendar. Okay. Who's Elijah, LaDonna? Oh! Thanks, LaDonna.
Yeah, we're here at the press conference. We're just waiting for the Two Rivers Police to come out and give us an update. As you said, you're on the Two Rivers work. So I think you're the last 6 months taking it all. This is a story that's had the attention.
This poor child.
That first night in February, we were out walking the streets, listening to people talk about Elijah and me, meaning with the look up the word Elijah all over. As you mentioned earlier.
Y'all are so good. I got the best peeps. We're small but mighty.
Just waiting now to see when they will come out. We will have more updates here soon. And they are coming over.
Good afternoon. My name is Melissa Wiesner, last name spelling Wiesner. I'm the Assistant Chief with the Two Rivers Police Department. I would like to first thank you all for taking the time to be here, and also to those of you watching or listening in. Your unwavering concern and support for Elijah has been greatly appreciated by all of us. Today, we're holding this press briefing to provide you up.
What the devil?
Since the moment that we took the call on February 20th of this year for Elijah Vu being missing, Elijah has been our top priority and will remain our top priority. Because we are committed to open and honest communication with our community, we are holding this press briefing. Chief Ben Meinert of the Two Rivers Police Department will be sharing important updates with you all. Meinert's last name is spelled Meinnert. We will not be taking any questioning during or following the press briefing because we are already sharing all of the information that we are able to provide to you at this time. There will be a packet available for you containing the information that Chief will be sharing, and I will provide that to you following the press briefing. Chief Meinert.
Thank you all for being here. Last Saturday, Sheriff Hartwig called me immediately upon learning his deputies were responding to investigate a report of skeletal remains found by someone in the town of Two Rivers. With night falling near, the entire area was secured while a variety of resources were gathered to investigate. Ultimately, a forensic anthropologist with the Wisconsin State Crime Laboratories was able to confirm a skull and bones as human remains. On Sunday, my staff assisted the Manitowoc County Sheriff's Office, Department of Justice, Division of Criminal Investigation, and the Wisconsin Crime Lab with recovery of those remains and any associated evidence. The intentions of our team were to first notify family of the discovery and then alert the public. Prior to that, however, reports went out on social media and other platforms, some of which were false and most of which had yet to be confirmed. While we do feel it's important to share information with the public, our first priority is Elijah and the integrity of the investigation, as well as communication with the family. These are the facts that I can share. The remains were found on private property by a person getting his land ready for the hunting season. This land was not on Manitou Girl Scout camp property, but rather a thick wooded area with heavy underbrush, just to the north of Manitou. This location is just over 3 miles northwest of where he originally was reported missing. This area had been searched several times, as had been reported, by law enforcement searches, by private searches, by the landowner, by air, and with various search and rescue teams. Despite all those previous efforts and throughout different conditions and changing seasons, we continued searching and even had continued searches scheduled as early as next week. The remains found by the hunter and recovered by law enforcement were taken to the Wisconsin Crime Lab for DNA testing to identify the person. It is with a heavy heart that I announce to you today, those remains were identified as Elijah Vu. With that news and following this briefing, the Amber Alert will be canceled. As soon as Elijah was identified, we notified his family. I ask that you respect them and allow them to grieve. The area where Elijah was located is private property, and we ask that you respect the private property owner and avoid that area. This is not the outcome that we hoped for. The family's devastated, we're devastated, our community's devastated. I never met Elijah, but I watched that 3-year-old boy bring out the best in this community. I can't thank the public and our businesses enough. Thank you, DCI, for continuing to lead this investigation, FBI for their support, and our local, state, and federal law enforcement and fire departments, as well as the numerous neighboring agencies. I'd also like to thank all the churches, schools, all the search and rescue groups, and our residents and the family members. Thank you to all that the various city employees have done. The efforts of all of you and many others help bring conclusion to this phase of the investigation. What started out as a search for a missing boy is now a death investigation. Although we understand your desire for information, we can't share every detail, and we must maintain the integrity of the investigation. We know the family and the community has a lot of questions. This is a process that will take a great deal of time, and we'll do everything we can in this investigation to answer those questions. Going forward, we'll continue to share updates provided from DCI and the Manitowoc County DA. Now that we know the location of where Elijah was located off Christy Bob Lane and Manitou Drive, we ask that anybody with any information, if you haven't previously provided it or you think it may be useful in this investigation, to please contact law enforcement. Again, my assistant chief will provide you with the information on how to do so if you can. And again, thank you all for being here.
Chief, do we expect a death investigation or autopsy?
Sorry, as a reminder, there will not be any questions.
When that autopsy results be coming?
As Chief said, if you have any information that you feel would be beneficial for this investigation, please contact Detective Lieutenant Glazer of the Two Rivers Police Department at 920-686-7200. Again, that's Detective Lieutenant Glazer, Glaser, at the Two Rivers Police Department at 920-686-7200. As Chief Meinert said, we too are devastated by this news. Elijah was a little guy, but he left a huge impact on all of us, and he will not be forgotten. That will conclude the information we're sharing today at this press briefing. As a reminder, we will not be having questions at this time, as we already shared all the information we are available.
Is an autopsy scheduled? Is an autopsy scheduled? What's the reason for not taking questions?
Have all of his remains been recovered?
No, they said they weren't going to take any questions.
We are learning new details about how a 14-year-old was able to sneak.
Okay, we're still looking at the ceiling, so. Let me see, Brandy, because I honestly heard about him, but I didn't. I don't know very much about Elijah. Let me.
12 News tonight has learned of a link between human remains discovered and a missing 4-year-old boy in Manitowoc County. A hunter found those remains about 3 miles away from the home where Elijah Vu vanished in Two Rivers in February 20th.
Wow.
12 News Kendall Keys tonight with the discovery Elijah's mother once lived across the street from where those remains were found.
Wow.
The woman who keeps her horse at this property now tells us Katrina Bauer, Elijah's mom, once lived at this property right across the street from where law enforcement says a hunter discovered those human remains Saturday. 12 News has obtained a photo that shows Bauer holding little Elijah in the hand of a little girl who we are not identifying. Her mother, Elijah's grandma, confirmed that her daughter did indeed live there for a time. The blue railing and cement front steps in the photo match the property right across the street from that wooded area where a deer
deer hunter found skeletal remains. Take a look, News Chopper 12 with the exclusive view of investigators combing through the wooded area across the street Sunday night in rural Manitowoc County. A mobile command unit set up several law enforcement vehicles on the property near Camp Manitou. Yellow tape could be seen with investigators working in the wooded area. Kathy Hasselman says it's not the first time detectives have been on the property.
The next day, FBI was out here. They checked her house. I think they did a DNA with her, my sister, which kind of was shocking, but she just cooperated, whatever, you know.
The sheriff's office has not shared age, race, or gender of the remains that were found and says the identification process will be lengthy. In Manitowoc County, Kendall Keys, WISN 12 News.
That's crazy.
I'm sure they're working to get answers because they know people want answers.
Emily Middleton is the director at UWM's Center for Forensic Science. She says investigators have their work cut out for them.
It's the kind of case that takes an emotional load, too.
The task to identify skeletal remains a deer hunter found in the town of Two Rivers Saturday.
Good.
News Chopper 12 flying over the wooded area turned investigation scene Sunday. The remains located on a private property next to the Girl Scout camp, Camp Manitou. Katrina Bauer, the mother of missing 4-year-old Elijah Vu, used to live nearby.
She lived here before my sister got here, and there was a picture of her on the porch.
12 News obtained this photo. It shows Bauer holding Elijah and a little girl who we're not identifying. The railing and steps in the photo match the farmhouse across the street from that wooded area. As the community invested in Elijah's disappearance waits,
I hope and pray that it is Elijah. We need answers.
Detectives work to narrow down age, race, and gender of the remains.
Extracting DNA from skeletal remains is a much more labor-intensive process than it is from getting DNA from something like blood or soft tissue.
Middleton isn't directly involved, but is an expert on the process of extracting DNA from bones.
The first step would be to extract a sample. And then you're going to need to clean that and turn it into a powder, and then try to extract the DNA by putting it through a series of chemicals.
How long do you think it will take to have these answers?
I think it's going to take a while, unfortunately. I know people want answers.
Kendall, Middleton said it could be weeks, even months before the bones can be identified.
Right. An exact time frame depends on a lot of factors, including what bones were recovered and the state those bones were in. The Manitowoc County Sheriff's Office says today they have not yet narrowed down a time frame.
Okay, so does anybody know what this is? I don't know what this is all about. So he has been missing since February. Who reported him missing? Let me look this up because I honestly don't know. I've seen that he was missing, but I didn't know much about it. Elijah View. So I'm looking up some information about him because I don't know. So he's been missing since February 20th, 2024. Oh, his mother and her boyfriend are facing charges. Did you guys know that? Oh, yeah, it's still 5. It's been an hour and 17 minutes jury watch. So the parents, sorry, I'm looking at this now. LaDonna's got me down this rabbit hole. So since, oh, he's Asian. Oh, this is bad. See, now I know the world's going to hell in a handbasket when the Asians are doing stuff. Oh, yeah, I didn't know. What is he in a gang? Oh, no. Yeah, she doesn't look like a winner, that's for sure. They both look. Oh, is there no sound? Oh. Oh my goodness. Oh. Can you hear it now? Oh, yeah, okay. Wait. Can you hear the video? You can't hear the video? That is terrible. Okay, we're at 1 hour and 22 minutes on the verdict. So even if the daughter it got immunity, if the daughter got immunity, but she can still possibly get perjury, don't you think? Can they prove her lying on the stand? I would think even if they gave her immunity, they could still get her for perjury. She's got to learn her lesson one way or the other. Well, I just played the video, Gwen, to see if I could catch up on well, yeah, I wonder if it protects her from anything she says on the stand. I don't know. Well, remember Jeff, of course, I don't know what the thing is in Florida. Florida's another planet, we've learned. But, Jeff got use immunity. Anything he said on the stand couldn't be used against him. But anything he said on the stand couldn't be used against him. That doesn't mean he couldn't be charged with perjury. So, but then what can you prove is perjury? Yeah, I mean, can you prove it's perjury? I mean, I guess you can if her mom gets convicted. Yeah. I don't know. It's at his parents' house. Or he chunked it somewhere, but I think it's at his parents' house. I think it is. I don't even think they're going to dig that deep. I honestly don't. That's what the crazy part is about these trials and these cases is they don't ever go past the defendant. Once they get the person that they want, they don't go past that person. That's the same thing it is with Michael, with Samantha. They're not going to go past him. That's why the prosecution is appealing the use of the double jeopardy. They're appealing a Supreme Court ruling of double jeopardy. How in the heck? So that's just insane. I don't know if you guys ever heard Trial Junkies. You've maybe heard of it being in Texas. I'm sure. I mean, I'm sure most of y'all have heard of it because it was pretty popular. But Bernie, the guy Bernie, he was the with the old lady here in Texas, the mortician who was with the grandma old lady here in the small town in Texas, and she had a lot of money, and he was that one, but he, he ended up fishing poling her 4 times in the back, and they let him out, and he moved to Austin, and the director of the movie that made the movie about him put him up in his backyard in like a garage apartment because they thought he was, I don't want to say innocent, but they thought he should be like released. Jack Black backed him. Everybody backed him. Even the town like backed him, supported him. And then even the DA, the DA was like, "Oh, we take it back. We don't think he should be in prison anymore." I'm like, "What the heck?" And they were talking about this out of body experience, the dissociative disorder mess. Yeah. So that's what I'm saying. Like, they were trying to say that he had this out of body experience and he didn't know what he was doing. But yet, for like 9 months, he was living in the town and spending her money. And she was, meanwhile, in her own freezer in her house in the town of Carth. Anyway, yeah. And then he goes back to court, right? Because they're like, "We're taking you back to court." And they, new prosecutors took him back, and he ended up going back to prison. But yeah, they were actually fighting for him. You deleted someone 4 times in the back, an old lady. What the heck? Yeah. And I mean, the documentary, it's old. It's an old case. It's like from the 90s or something, like 90s or 2000s or something. Cause, they made the movie about it. And then like the new prosecutors on the case were like, we're not buying this Hollywood sensationalized story. And Jack Black was like, "Oh, he served his time. I think he should be out." Richard Linklater, the director, was like, "Yeah, he even testified in court on his behalf." I'm like, dude, this guy is a con man. And he literally was embezzling, like he embezzled millions of dollars from this little old lady. And apparently she was figuring it out. And that's why I think they said he panicked and like did what he did to her. But he's all like, "Oh, I'm such a good guy." I know. That's what I'm saying. Like, dude. I mean, he took out a defenseless old woman. And he's trying to say she was abusive to him and everything. I'm like, what? This doesn't make sense. I don't understand. That's like with the brothers. Like, I don't think they lived at home anymore. Wasn't Lyle off at college or whatever? Off at school? Weren't they off away at this point? Why would you Why would you wait till you're like moved out of the house? Yeah, I just don't get it. I don't see why you would wait till you're moved out if that's what you're going to do. Like, that doesn't make any sense. I'm shocked that the jury has not come back with any more questions or anything for Laurie. I thought that they would be back by now. It has been an hour and 33 minutes. I should have walked my dogs. That's what he said. I don't know. I'm still on the fence about if I think they were. I mean, they may have been. I mean, I did see that in Menudo, because their dad was part of the Menudo. I used to love Menudo. Not the food, the group. Yeah, because the Menudo group, like by the time they turned a certain age, I think it was like 15 or something, they would recycle and put in new kids. I think the oldest, they did have one kid that they kept in the group for a while, because I watched the documentary about them, and he was aged out, but they kept him longer. They still have Menudo today. Yeah. Oh my gosh. I used to love them when I was growing up. They were around before freaking New Edition, anything, before America even thought of doing that boy stuff, the boy groups. Menudo was around. Oh my goodness. Okay. I wonder if I should walk my dogs. Oh gosh. I said the word. Augie's eyes opened. Oh, he's picked up his head. Oh Lord. Oh. I know. I don't know. I am. I'm fixing to. I'm going to put it on. I'm going to put it on the screen so y'all can see it. I know y'all ain't doing nothing. Shoot. My dog, they're about to cross their legs right now. I know. He's such a butt, man. I swear. You just don't know what a pill he's been this week. It's like having a child. All right. Did you make one? Oh my Lord. You better be puffing too. I'm fixing to eat me half a gummy. I'm tired. I've been sitting here. I'm in pain. I should have known. I should have known. And I was on time this morning. I was on time. I was watching the wrong day, but I was on time. All right. I'll be right back. I almost fell in my cloffice. That'd have been hilarious. I'm kind of worried. There's no verdict. Kind of concerned. I wonder when he's going to ask the jury if they want to go home. Yeah, I did. It's hot outside. The dogs are hot. They don't do jack all day. All they do is sit on their, lay around and nap all day. They're over here heavy breathing. Oh my gosh. Y'all are so funny. Watching it, spying on your neighbors and chickens. That's okay. I live across the street from the high school, and I was trying to figure out what all this racket was, and it's the football game. I forgot. I wonder if the judge is going to come back and say, okay, do y'all want to go home for the night, or are you going to keep deliberating, or what? Because at some point he's got to... We have deer. I like to go out and see the deer. And we have one of our neighbors has a bunch of guineas and turkey. And I don't know what else, but they have a lot of freaking wild animals. All right, I'm gonna give them until oh, I love opossums. What? Okay, we're almost at 2 hours. But really, is Justin Timberlake crying? Okay, so I'll just tell y'all this, like, so what? Aw, that's so sad. That's how it is. Like where we live, they're building so much that the deer are just like running out of space. I don't know what's happening in my comments, but somebody must have did a comment and it got deleted. I don't know. It is so sad because they're all over and they have just nowhere to go because we're just taking over all their land. Every time they have videos of like shark attacks and stuff, I always tell people, I'm like, well, then don't go in their house. Sharks don't just attack. I hate when they call them shark attacks because I'm like, they don't just attack. They don't just like show up and just attack. They're sharks. They're in the ocean. Like, if you don't go out there, they're not going to bother you. But everybody just goes out there. Like, don't go to their house. If you don't come to my house unannounced, you'll be fine. Right? I mean, that's like, don't show up, don't come to my house unannounced. That's sharks. Sharks don't just attack. I don't understand why they call it Shark Attack, like Shark Week, when they have it on whatever channel it is. And I'm like, it's not a thing. All right, when my man gets home, I'm gonna have to jump off of here because it's Friday the 13th. But y'all need to venture out next week and have Korean food because it's Chuseok. It's a very important holiday. Fall Festival week. If you want desserts, you should try Chinese mooncake or Taiwanese mooncake, or you can try Korean rice cake. Hangwa, you can try that. I would highly suggest y'all get out and get your Asian on next week. Try something fun. LaDonna, are you going to be watching football this weekend? Well, I wonder if he's going to go into like... Well, I hope she's hugging her kids and stuff. I wonder how she's spending her last... Like, just think, what would y'all be doing if it's your last... Like, it could be your last hours of freedom. I mean, they said, like, okay, when I was looking up this stuff, so, I mean, I don't know. What would you do? That's all you had? Like 24 hours. That's not very much time. I don't know. I don't know what I would do. That's a hard one. Like, there's not a whole lot you could get done in 24 hours. I would want to, I don't know. Obviously, see my kids. See Ashton, see my dog. I mean, there's so many, like, everybody's so spread out, though. 24 hours isn't enough time. That sucks. And then I would want to have, like, I don't know. That sucks. That's a lot. That's not enough time. I'd want to squeeze in seeing everybody that I love, and then I don't know. I'm thinking I would want to go away with seeing a good view, like looking at something pretty, not looking at the four walls of my house. Or I don't know if that's not very long. That would suck. But I'm thinking, like, if you thought that you were going to lose your freedom, like, go away, and this might be the last time you get to hug your kids. I mean, because she may not necessarily be in a prison in Florida. Because, what's his name? Charlie Adelson, he's in South Dakota. And they're bringing him in from South Dakota for his mama's trial. So, they're not always in the same state that they got convicted in. So that would be, I mean, could you imagine? Like, you're used to being in sunny Florida, and even if you were convicted of a crime, but you were sent to South Dakota, like, that would suck. Sorry, I'm looking at stuff. Did he? What the? There's some crazy. So apparently Sarah Boone's having another hearing next week on 9/19. I don't know what it's for. And I know. I know. I know we've already been here this long. It's like, like just as soon as we get off here, they're gonna come with a verdict. What? Y'all, there's some crazy people in this world. And I don't even need to say world. There's just crazy people in this country. Just here. Yeah, I just saw that. Yeah, Sarah is having another hearing on the 19th, but I don't know what it's for. I'm sure she's trying to get this trial postponed again. Let me see.
It's 1 o'clock right now. I was awake, but I actually got out of the bed at like 12:30ish, whatever. So I came downstairs and I was like, oh, he's in the suitcase still.
Now for what's trending in true crime. Sarah Boone has a brand new attorney. Her defense attorney has added co-counsel ahead of her upcoming trial. James Owens, who now represents Boone in her murder trial, is going to have some help. A notice of appearance says co-counsel was filed Tuesday for Tony Henderson, who will now serve as second chair in the case. This is him. He's a graduate of the Florida State College of Law. He's got over 25 years of experience practicing criminal law, trying over 250 jury trials. Our question this morning: is the new addition to the team going to help or hurt Boone's case? Let's bring in our guests, criminal defense attorney and former prosecutor David Bruno and trial attorney and former prosecutor Randolph Rice. Okay, let's talk about this. We've got a new addition really at the 11th hour because trial is about to start in a couple of weeks. Randolph Rice, do you think this is going to help the team?
Oh boy, this just, I mean, I can't tell you, and I'm sure David's had the same problem and issue in the past of dealing with clients like this who just are so difficult. And I bless Mr. Henderson for joining this team because this is a tough road to row. I mean, when you go through 8 attorneys and you're on your 9th one, it clearly is not the attorneys that's the problem. It seems to be the client that may be the problem. I commend him. He is brave for taking this on. Will it help? I don't know. The problem is he's only got a couple of weeks to prepare for this trial. Doesn't sound like the court's going to delay this any longer, which has been a tactic that she has been using, it seems like, to delay this, is just keep firing and hiring new lawyers to push this trial out farther and farther. So God bless him. He's got a long road here in front of him, and I hope he doesn't become, number 9 or 10 that goes away. So.
Oh, I know, Randolph. Yeah, keeping track. Yeah, she's on. So I guess he makes 10. I guess if we're counting. Oh my gosh. And so now here we are. And David, Bruno, what are your thoughts? In addition, I'm sure you'll agree with what Randolph said. Mr. Henderson deserves a medal for joining this team. Is he going to help things out?
Oh, genius idea to have 2. Why? Because obviously we've seen all of the problems with the prior 8, right? As 9 comes in, it's better to have 2 attorneys because of the communication, right? Because there's probably problems communicating to the client. And if you bring a second attorney in, well, they could both explain and help. And 2 heads are better than 1. So especially in a situation like this with all of the prior counsel, I think it's a good idea to have 2 attorneys. At the Bianchi Law Group here, we have 7 and we work on our cases together. Oftentimes when we need to jump in and help and communicate with more than 1 attorney, it helps explain and for them to understand things. So I think it's genius, especially in light of the history.
Exactly. David, thank you for that. So here's what else is going on with Sarah Boone and her defense team. We know with attorney number 9 and now number 10 too. They are trying to present at trial a defense, an affirmative defense essentially of battered spouse syndrome, which falls in line with self-defense. And so we know that they filed a notice of intent to do so last week. We heard a little bit about it at the last court hearing. And now we're getting a response from the state of Florida asking the judge to strike that notice, saying that defense is entirely inappropriate. One reason being that Sarah Boone previously said it was an accident, that she left Jorge Torres in the suitcase by accident. And the prosecution said, well, the defense then can't be claimed of battered spouse syndrome if this was accidental. For more on the very turbulent relationship between Jorge Torres and Sarah Boone, here's Court TV legal correspondent Kelly Craft.
Nonetheless, I have to live without him now. Yeah. Nonetheless. Punishment in itself.
George Torres's death in 2020 was not the first time police had been at the home he shared with his girlfriend, Sarah Boone. Boone and Torres began dating in March of 2016. They moved in together 4 months later, and the relationship was volatile.
I should probably not be together, but that's not my business.
While police interrogated Boone about Torres's death, they questioned her about the violence in their relationship.
So every time that you guys fight, you both hit each other? So you should have probably gone to jail all those times that he went to jail for domestic?
Well, the one time I did, at one point, I started documenting everything.
Okay.
So you all will see in my pictures, bloody fingers, split foreheads, he split my nose.
In July of 2018, police were called to the couple's home after a night out. Boone told the officers she had recently gone through a divorce, that Torres was going through a lot, and that he had beat her up that night.
He let loose on my ass tonight, and I'm not having it. Okay. I got kicked in the face. I don't want him to get in trouble, but I'm tired of being beaten up.
Torres told the officers that she strangled him until he was having trouble breathing. He had red marks on his neck, and Boone's eye was bruised. She was arrested for aggravated battery by strangulation, and he was arrested for battery.
You could probably stay in there for a day, maybe 2. Possibly. It's all up to the judge.
In 2019, Boone called the police to their home. She claimed Torres had beaten her up again and that he had told her, "You are going to die." Boone had a lump on her face and scratches on her neck. Torres also had scratches on his neck, but he denied hitting her. He was arrested for battery.
I had him arrested. How many times?
But you also went down and bailed him
I know.
the next day.
Well, I know.
Torres was arrested for battery again a month later. Boone called the police on him, accusing him of punching her multiple times in the neck. Investigators did see marks on her neck. An officer asked Torres what happened. He said he gets hit all the time. And what is he supposed to do? A week later, even though there was a no contact order, Torres and Boone were together. And again, a fight broke out.
I was asleep, and again, he comes in and wakes me up because he gets mad at me because I go to sleep. The whole time I'm being belittled. That's when I got punched in my ear.
On the phone, you told me that you attacked him as well.
I didn't attack him.
You said you exchanged, you had a physical altercation on the phone. That's what you told me.
I pulled him up to me.
He said he has marks because I was fighting for my life.
I was being honest with you.
Police found Torres hiding in the bathroom. He told them Boone hit him often. He was arrested again for battery. This case, like their other domestic violence incidents, was not prosecuted because neither of them would press charges. Less than 6 months later, Torres was dead.
I fell asleep, and I woke up, and he was dead in the suitcase, so I don't know what happened.
Sarah Boone set to appear in court next week. So we're asking, if the judge allows her team to present this defense, is it going to work? Is battered spouse syndrome going to work at trial? Let's bring back in our guest legal analyst, David Bruno and Randolph Rice. Randolph, what do you think about this? Do you think they could be successful?
I think you make a great point at the open when you talked about that she admitted to doing this. This was an accident. This wasn't intentional. And the battered spousal, this battered syndrome that they talk about is something where you have a buildup of abuse that you ultimately act out on. So I don't think it's going to succeed. I think that the judge will deny it. I also think even if the judge does allow it in, the jurors are just not going to believe this. Certainly it was a tumultuous relationship. They certainly had a lot of incidents where they were both, it seems like both of them were beating on each other. And I just don't think a jury's going to be able to buy that.
Right. David Bruno, to you next, please. Your thoughts.
Yeah, this is going to require an expert. So they're going to need to find an independent expert to come in and look at that history to conclude that she is a battered woman under the syndrome. That's number one, because they have to show, and this history that you lay out with this relationship may actually get her to part one. However, part two is that syndrome caused her to believe that it was necessary right then and there. And I think factually, that's where she's going to have the biggest problem with her prior statements and also the circumstances of how it went down. In a suitcase, again, another fiction novel that we could all be writing about this, but he's put in a suitcase and we have the video of the statements while he's dying.
Exactly. Great points, David Bruno. Thank you so much for joining us this morning. It's always a pleasure. I know we have to say goodbye to you, let you get off to court. Randolph Rice, we're going to see you in a little while. Stand by, please.
Sorry. It's not a thing.
He methodically.
Okay, it's 2 hours and 23 minutes into but now she has an extra lawyer. So now she has 2 attorneys. She went from having 0 attorneys to 2 attorneys. Do you think she's crazier than Laurie? They're both pretty nutty. I mean, I don't know. Yeah, he just went to go get some propane and propane accessories so we can grill out. Because now that LaDonna mentioned grilling, I was like, we can grill out tonight. He skipped the gym just for me. That's a big deal. That's a big, big deal. Skipping the gym. That never happens. We're at 2 hours and 24 minutes. Man, I'm disappointed. I thought they were going to be back faster than this. Dang it, LaDonna, we didn't peg this one like we thought. Are you telling me to grill? Who said that? Gwen? You said I better grill him a good steak? Oh, no. I know. Yeah. I know. I don't cook. We've already had this conversation. I think you, myself, and Brandy had this conversation. I do not make or grill or cook or any of those shenanigans. That does not happen. Y'all got me all wrong. That's not how it works. I don't cook. I do need to go do dishes because I have not done anything in this house all day. I know, LaDonna. I think it's good. He's got to let the jury go home, right? So I guess we're going to have to call it. I'm not missing out, Gwen. I promise I'm not. I don't think I am. Not at all. I'm not missing out. I got the best thing right here because, I mean, I have a man who works, pays all the bills, goes to the grocery store, and then comes home and cooks the food. I'm not missing out on anything. If anything, I need to do better. So, yeah. No, I don't cook. Why would I do something like that? That's insane. I bought an air fryer. I barely use that. Yeah, we are definitely. Yeah, I am. No. I know how. I just don't. And yeah, no. I would not survive on my own. I am basically like a parasite. That's what they call babies now, right? So I'm basically like a parasite. I would not survive without my host. Mike is my host. I would not survive. Yeah, that's the gist of that. Yeah, I'm pretty much like these dogs that live here. They don't pay rent. They don't have opposable thumbs. I have opposable thumbs. I just don't do anything. I can't survive. They can't survive without their host. So, yeah. I'm just a pain in the butt like my Neo. And I just, mooch off of my host. And Hey, I've already been there, done that. I've had the corporate life, and I'm good. I have an excellent man. This is great. See, LaDonna's all, yeah, I have my old folks. They're great. Everything's great. Then I got this pain in the rear right here who's trying to get back up here in my lap. And there he is. Oh, I don't know what kind of grass he got into outside, but he stinks. All right, we're rocking on 2.5 hours. So I think when we hit 2:30, 2 hours and 30 minutes. We're gonna call it in about 20, well, whatever. 20 seconds. Y'all enjoy your weekend with your loved ones. Go San Fran, War Eagle. Happy Friday the 13th. Happy Chosiak next week. I will let y'all know if we're going to do a live or anything pops up. Y'all look out for some new videos. And I will see y'all later. Thank you so much for toughing it out. See y'all. Kamsahamnida.